The committee will come to order. We exist to secure two fundamental principles. First, Americans have a right to know that the money Washington takes from them is well spent. And second, Americans deserve an efficient, effective government that works for them. Our duty on the Oversight Committee is to protect these rights. Our solemn responsibility is to hold government accountable to taxpayers, because taxpayers have a right to know what they get from their government. It's our job to work tirelessly in partnership with citizen watchdogs and the IG community to deliver the facts to the American people and bring genuine reform to the federal bureaucracy. I would note today that what we read at the opening of every committee hearing is particularly questionable today, or appropriate today, when it says, government accountable to taxpayers. Our democracy was created by people and for the people. When government power is used to target Americans for exercising their constitutional rights, there is nothing we as representatives should find more important than to take it seriously, get to the bottom of it, and eradicate the behavior. Since 2010, there appears to have been a targeting of people based on their beliefs. These people, particularly those who use Tea Party in their name, were mocked by the liberal media, mocked by late-night television, and referred to by this administration regularly with disdain. Even here in the House of Congress, people would talk about who the Tea Partiers were, who was Tea Party supported, when in fact there is no Tea Party. As the evidence has shown, there are hundreds and hundreds of organizations as independent as any single American who simply wanted to live up to the Constitution, to have their freedom and have it protected by our country. So last year, when we received troubling complaints by groups across the country who were receiving what appeared to be inappropriate and unnecessary question, in many cases after more than a year, sometimes 2 years, of inaction by the IRS, we went to the Inspector General, who is here with us today. In March of last year, upon the request of our staff and later in a formal letter from Mr. Jordan, the committee subcommittee chairman, and myself, the IG launched a formal investigation. We knew then that something seemed to be wrong. We knew then that there was smoke. We knew then that, in fact, something just didn't seem to be right. What we didn't know what was really wrong, and we could never have suspected an organized and pervasive denying of hundreds of applications, not by a reject stamped and sent back, but by deliberate inaction. So our suspicions were just that. Only in the last few weeks have we begun to realize that this was, at least within the IRS, vast, because every single person who looked at one of these applications could have and should have been a whistleblower, could have and should have realized there was something wrong. During this period of time of more than a year, we had an intervening election. Many people want to talk about this relative to the election. I will not do that here today. This is more important than any one election. We need to look at this relative to our democracy. The power to tax is the power to destroy. The power to grant tax status is, in fact, an enhancement of the right and liberties of our speech. That is what was at stake here. And it wouldn't matter one bit if a different group was targeted. It is wrong. Congress produces laws, many of them complex. We may hear in the weeks and months to follow that there was the complexity of these applications that caused this. Complexity is created more often than it exists. The IRS finds complexity when it's convenient, and simplicity when it's convenient. That is what we've begun to find out. During the same period of time, well, at least two investigations were going on, one by the IG and one internal. Congress was misled. The American people were misled. Just yesterday, the committee interviewed Holly Paz, the Director of Exempt Organizations, Rulings, and Agreements Division of the IRS. Well, a tremendous amount of attention is centered about the Inspector General report or investigation. The committee has learned from Ms. Paz that she, in fact, participated in an IRS internal investigation that concluded in May of 2012, May 3rd of 2012, and found essentially the same thing that Mr. George found more than a year later. Think about it. For more than a year, the IRS knew that it had inappropriately targeted groups of Americans based on their political beliefs, and without mentioning it, and in fact without honestly answering questions that were the result of this internal investigation. Many people believe that the IRS is an independent agency. Nothing could be further from the truth. We define it deliberately as less political. It has only two political appointees. It is carefully and scrutinized to have limited visibility to Congress, limited visibility because we're protecting American people's rights. But in fact, the Commissioner, former Commissioner who's with us today, will tell us he reports to the Deputy of Treasury. In fact, he is a subordinate of a Cabinet officer. It is not an agency that gets to do what it wants to do or that cannot be challenged by Treasury. As a result, we discovered that not only did Ms. Paz know about this, learn about this, and participate in the IRS's internal investigation, but she also played an integral role in the IG's report or investigation. We were shocked to find that Ms. Paz participated in virtually every one of the interrogations or interviews with her own subordinates. In those, of course, one of the questions the IG had to ask was, did anyone tell you to do this? If that question was asked, their own superior was in the room. Although it appears as though this was signed off by the IG, this committee finds it inappropriate for any inspector inspecting wrongdoing within an agency to include individuals in the agency who, in fact, could be, and we now believe, participated willingly in this activity. It's also unclear why the Inspector General did not inform the committee of his substantive findings when he first became aware of the targeting no later than July of 2012. And here's where I take a liberty of this committee, a liberty of the Congress. Despite numerous requests from the committee for information and updates, including an August 3rd letter, the request for the IG to inform Congress about serious or flagrant problems quickly, the IG failed to do that. Ladies and gentlemen, that is existing law. That is under the IG Act. That has been a responsibility of IGs across the board since the 70s. And we, in fact, on this committee, both support, defend, and promote the IGs, but we must also insist, particularly after situations like the GSA scandal that this committee dealt with, that we not wait 10 months to find out that there's a there there. That, in fact, is perhaps the greatest failing of an otherwise well-regarded inspector. Today, we will be looking at how things went so wrong, how multiple wrongdoings occurred, how no one in position of authority seems to know anything about it. And within the administration, there seemed to be a culture of insulation that puts higher priority on deniability than addressing blatant wrongdoing. The American people don't expect perfection. Men and women, many of them working very hard and trying to do the best within government, make mistakes. A few make wrongdoings and do so deliberately. But the buck has to stop somewhere. So in this investigation, the buck will stop with this committee. This committee will not stop this investigation until we know that the IRS is fixed. In a one-on-one interview with the IG shortly after his report, I asked the Inspector General a simple question that I expected to have a mixed answer on. The question was, is this the only time? Could this happen again? In fact, his answer to me in an unambiguous way is, the internal controls are not there for me to say that it isn't happening somewhere else in the IRS. Meaning, the American people today should not have confidence that this is an isolated incident, but rather, like the days of Enron and WorldCom, you ask the question, has Congress made this organization auditable and accountable the way they make us auditable and accountable? I paid a lot of taxes in my life. Most people on the dais have. We know one thing. You cannot just say you're doing the right thing and expect the IRS to take your word and the check you send in. Documentation, the ability to verify is essential when dealing with the IRS. We can expect no less when we deal with the IRS. I now recognize the ranking member for his opening statement.
Mr. Chairman, I thank you for calling this very important hearing. Mr. Chairman, you are absolutely right. This is more important than one election. The revelations that have come forward so far provides us with a moment pregnant with transformation. Not transformation for a moment, but for generations to come and generations yet unborn. That's why this hearing must be about two essential things: truth and trust. The American people expect the IRS to exercise its responsibilities in a fair and nonpartisan manner. When the IRS breaches that trust, it damages the ability of the agency to implement the nation's tax laws effectively and efficiently. The Inspector General has called the actions by IRS employees in Cincinnati, quote, inappropriate, unquote. But after reading the IG's report, I think it goes well beyond that. I believe that there was gross incompetence and mismanagement in how the IRS determined which organizations qualified for tax-exempt status. Again, this is about truth and trust. By now, we have all heard how IRS employees use terms like Tea Party and Patriots to single out conservative groups for enhanced scrutiny. But the IG report also discusses how some cases took more than 3 years to resolve. Ladies and gentlemen, we're better than that. We are simply better than that. IRS staff stopped working for more than a year, from October 2010 through November 2011, while they waited for guidance from supervisors on how to process these applications. This is simply unacceptable. When the IRS finally got to processing applications, employees with little or no oversight sent overly extensive requests for information to many of these groups, which understandably angered them. New processes have been put in place to prevent these abuses in the future, but much more needs to be done. According to the IG audit, at least part of the reason for this mismanagement is is inadequate guidance on how to process these cases. The original statute passed by Congress requires 501c4 organizations engaged exclusively in social welfare activities. But in 1959, the Treasury Department issued a regulation that requires these entities only to be primarily engaged in social welfare activities. As a result, many groups now believe they can spend up to 49% of their funds on campaign-related activities. Significant concerns also have been raised about groups that have already qualified for tax-exempt status, or whose applications are still pending and are now openly engaging in campaign-related activities and spending millions of dollars with little or no IRS oversight of their activities. These concerns are not limited to just one political party, by the way. For example, good government groups like Democracy 21 and others have written to the IRS about Crossroads GPS, which was created by Karl Rove, as well as Patriots USA, which was created by former Obama administration officials. I'm encouraged that the IG has already announced that he will be examining this issue in more detail in the upcoming audit. But it is also time to revisit the 1959 regulation and consider returning to the original standard set forth in the statute that bans political activity by these groups altogether, which is what Congress originally intended. As we investigate the actions of IRS employees, I urge my colleagues to avoid making the investigation into a partisan attack. Let me pause here to say that there are many great employees in the IRS. I'm sure the chairman would agree with me that it is not our intention to take a broad brush and say negative things about all the employees at the IRS, because there are many hardworking people who are probably looking at this event right now, wondering, why they talking about me. Well, we say to all of those employees, we appreciate what you're doing, but we're trying to make sure that this organization is straightened out. Mr. Shulman, who was the head of the IRS when all of these actions occurred, was appointed by President Bush. And there's no evidence to suggest that he directed IRS employees to intentionally delay or harass Tea Party groups. Similarly, the Inspector General and all IRS officials who have appeared before Congress to date have agreed that no one outside the IRS participated in these activities or was aware of them when they occurred. These facts were confirmed again yesterday when the committee conducted a transcribed interview of Holly Paz, who served as manager of the Rulings and Agreements Office in Washington, D.C., which oversees the Cincinnati unit that processed these applications. I share the chairman's very serious questions about why Mr. Shulman and Ms. Lerner failed to inform Congress about these problems. Again, ladies and gentlemen, we're talking about truth and trust. To me, this is one of their most significant failures, and I do not believe their answers to date have been sufficient. Truth and trust. As the committee continues in what I hope will be a bipartisan and thorough investigation, I want to make a request of the chairman. Now that the president has designated Danny Werfel as the new acting director of the IRS, I believe the committee should hear from him about his plans to address the recommendations in the IG report and other steps he intends to take to restore the public trust in the IRS. As I've said repeatedly, to do our jobs on this committee, we must focus on oversight and reform, holding a hearing with Mr. Werfel will allow us to do both. Finally, Mr. Chairman, I would like to say a brief word about Ms. Lerner. Her attorney has written to the committee to inform us that she intends to invoke her Fifth Amendment right against self-incrimination. Of course, I am disappointed that we will not be able to ask her questions today. I believe that she could shed much light on what we are trying to find, the truth. But every member of this committee takes an oath to support the Constitution of the United States of America. And this is Ms. Lerner's right under the Constitution. So I will honor her decision, and I respectfully urge all of my colleagues to do the same. I ask unanimous consent to place into the record written answers that Ms. Lerner provided in response to questions posed by the Inspector General, as well as similar answers provided by her boss, Joseph Grant.
They will not be accepted at this time. They have not been provided to us by the IG on a bipartisan basis, I've been informed. So at this time, we will take them under advisement. They will be, I will take back my reservation if after Mr. George has viewed them and agreed that in fact they are true, or someone else from the IG. And I must mention, I'm shocked that I'm finding things that we want being delivered now.
They were provided last night, I understand.
They were not provided to us. The committee has respectfully requested all of these tribes' interviews from the IG. Mr. George, am I to assume that this was the only one provided, or were all of them provided to the minority?
Mr. Chairman, I've been informed that they were provided to both sides last night.
Well, there's a way to get them to us to where we know they're there. Can we? No, that's all right. That's all right. Will we expect to receive all transcribed interviews or only this one? We've asked for all of them equally.
We prioritize them, sir. We're still working on requests.
Can we get an estimate of time, as long as we're at this point, this juncture? By the way, I'll take back my reserve. But
thank you very much, Mr. Chairman.
Sir, we're working on the request. We've prioritized them as requested by the committee. I cannot give you at this very moment a definitive time for your receipt of them.
I trust it will be no greater time than we give taxpayers to respond. With that, unanimous consent is accepted. It will be placed in the record.
Mr. Chairman, let me make one comment very briefly on what just happened. Mr. Chairman, we would not submit. We were under the impression that you all had the document, and you said something that implied that we were trying to.
It wasn't you blindsiding me, I assure you.
Very well. And just as I close, I want this committee to be very careful, and I've said it many times. This committee should act on the level of a federal court. And I think we need to be very, very careful not to let partisanship undermine the integrity not only of the committee, but of our investigation and our work product. The American people are depending upon us, and I have full faith and confidence in the Chairman and all of our members that we will do as I just said. And so I certainly look forward to our witnesses' answers to our questions today. I look forward to your opening statements. And with that, Mr. Chairman, I yield back.
I thank you, Mr. Cummings. We now go to the chairman of the subcommittee, Mr. Jordan.
Thank you, Mr. Chairman. 2 rogue agents. That's what the White House tells us were the people responsible for this. In fact, I got a news report from May 15th that says White House aides, 2 rogue IRS employees from Cincinnati were responsible for investigating conservative groups. 2 employees in Cincinnati responsible for the systematic targeting of conservative groups for over 2 years. This administration would have us believe that. This administration, this agency, the very agency charged with enforcing Obamacare, systematically targeted groups who came into existence because they opposed Obamacare, and they started the targeting the very month, March 2010, that Obamacare became law, expects us to believe it was just the work of two rogue agents. This administration, this agency, which according to Mr. George's report found out about this practice certainly as early as June of 2011, and after that date, Ms. Lerner had 14 opportunities in direct and distinct interactions with the Ways and Means Committee and with this committee, 14 different occasions where she could have set the record straight, and she chose not to do it. And yet they expect us to believe that the systematic targeting of conservative groups was just the work of two rogue agents in Cincinnati. This administration, this agency, which was so calculating that they planted the question 12 days ago when Ms. Lerner gave the news that the IRS was engaged in this targeting before the IG's report came out. So calculating, they all got together and said, let's do this, let's plant the question and break this story, and yet they expect us to believe it was just the work of a couple employees, two rogue agents in Cincinnati. And finally, Mr. Chairman, I would say this, subject that this committee knows something about. This administration which told us and told the American people that the attack that killed 4 Americans in Benghazi was caused by a video, is now the same administration who expects us to believe that this scandal was just the result of two rogue agents in Cincinnati. Mr. Chairman, people don't buy it. American people get it. And they just want this administration to give them the truth. And that's why this hearing is so important. And I yield back.
I thank the gentleman. I understand Mr. Lynch will, on behalf of the ranking member, Mr. Lynch is recognized.
Thank you very much, Mr. Chairman. I want to thank you and the ranking member for holding this timely hearing. I'd also like to thank the witnesses for coming forward and helping the committee with its work. Mr. Chairman, each year the State Department releases its country report on human rights and practices. It's a comprehensive assessment of human rights conditions across the world. Notably, the overview of the country report released this year provides that sustainable democracy means more than just elections, and includes a quote from President Obama's remarks at the United Nations in September of 2012, defining true democracy as dependent on the freedom of citizens to speak their minds and assemble without fear on the rule of law and due process that guarantees the rights of all people. The country report goes on to conclude that these elements of democracy, particularly the freedom of expression and the freedom of speech, face serious threats around the globe in 2012. I just want to point to a couple of these examples offered by our own State Department. While the law in the People's Republic of China provides for freedom of speech and freedom of the press, the report states that authorities generally do not respect these rights in practice. In particular, those who made politically sensitive comments in public speeches, academic discussions, and comments to the media remain subject to punitive measures. And the government frequently monitored gathering of intellectual scholars and dissidents where political or sensitive issues were discussed. And similarly, in the Republic of Belarus, the national constitution provides for freedom of the speech and freedom of press, but the authoritarian regime in place also does not respect the rights in practice. Specifically, it says individuals could not criticize the government publicly or discuss matters of general public interest without fear of reprisal. Authorities videotaped political meetings, conducted frequent identity checks, and used other forms of intimidation. In my view, these and other blatant violations of individual freedom of expression serve to illustrate exactly what is at stake when a federal agency, for whatever reason, targets U.S. citizens based on their political beliefs. Such a practice compromises one of the bedrock principles of our democracy, the commitment to ensure that all citizens are free to exercise their freedom of speech without fear of retribution from their government. And it constitutes a significant infringement on human rights in this country. It is why the facts set forth in the audit report issued by the Treasury Inspector General are deeply troubling and reveal an IRS practice that is unacceptable. According to the Inspector General, the criteria used by the IRS Determinations Unit in Cincinnati to identify tax-exempt applications for further review include specific organization names, such as Tea Party and Patriots, as well as policy positions such as government spending. In any case file, and this is what gets me, any case file statements that criticize how the country is being run. Anything that criticizes the government on how this country is being run, that was subject to enhanced investigation by the IRS. The Inspector General has also reported that many of these organizations had not received an approval or denial letter from the IRS for more than 2 years after submitting their applications, and in some instances remained open as long as over 1,000 calendar days. Moreover, the audit report notes that the same determination unit sent out burdensome request letters for additional information, 58% of which the Inspector General has characterized as unnecessary. In light of these and other reports, it's my hope that today's hearing will serve to build upon the investigation conducted by Inspector General George and assist our committee in determining how we can better ensure that such practices are never repeated within the federal government. But there's something else at play here. If this committee is prevented by obstruction or by refusal to answer the questions that we need to get to the bottom of this, you will leave us no alternative but to ask for the appointment of a special prosecutor or appointment to special counsel to get to the bottom of this. This is a very serious matter. We would like to handle it in this committee. But if I watched the last hearing where the witness for the IRS had no names and no direction as to who led these investigations, who chose the terms to be used, and basically stonewalled the committee. That cannot continue. We know where that will lead. It will lead to a special prosecutor. It will lead to special counsel being appointed to get to the bottom of this. So I hope that's not the approach of the IRS going forward, because there will be hell to pay if that's the route that we chose to go down. Thank you, Mr. Chairman. I yield back the balance of my time.
I thank the gentleman. All members will have 7 days in which to place their opening statements in the record. We recognize our panel of witnesses. Mr. Russell George is the Treasury Inspector General for the Tax Administration. Mr. Douglas Schulman is the former Commissioner of the Internal Revenue Service. Ms. Lois Lerner is the Director of Exempt Organizations at the Internal Revenue Service. Mr. Neil S. Woolen is the Deputy Secretary at the Department of Treasury, and as I previously noted, essentially the report two of the Commissioner. Pursuant to the rules of the committee, all witnesses will be sworn. Would you please rise, raise your right hand to take the oath. Do you solemnly swear that the testimony you will give will be the truth, the whole truth, and nothing but the truth? Let the record indicate all witnesses answered in the affirmative. Please take your seats. For all the witnesses, your entire opening statements will be placed in the record. We understand sometimes you're obligated to stay with your opening statement. If so, keep it within 5 minutes. If you'd like to use the time to either add to or to summarize, that can be very helpful for the members. Mr. George, you're up first. Welcome.
Thank you, Mr. Chairman. Chairman Eisler, Ranking Member Cummings, members of the committee. Thank you for the opportunity to discuss our recent report concerning the Internal Revenue Service's treatment of groups that apply for tax-exempt status. As you noted, and as you are aware, Mr. Chairman, our audit was initiated based on concerns that you expressed due to taxpayer allegations that they were subjected to unfair treatment by the IRS. The 3 allegations considered during our review were proven true. The IRS targeted specific groups applying for tax-exempt status. It delayed the processing of these groups' applications and requested unnecessary information, as well as subjected these groups to special scrutiny. It is important to note that the IRS conducted an audit, that we, TIGTA, conducted an audit of the IRS and not an investigation. Pursuant to the Inspector General Act, TIGTA is authorized to conduct both audits as well as investigations in our oversight of IRS programs and operations. Audits are generally reviews of IRS programs designed to identify systemic problems and recommend corrective actions, whereas investigations are focused on a person or persons and are usually undertaken in response to reports or complaints of misconduct. Investigations may be criminal or administrative in nature and can result in referral for prosecution or referral for management for administrative action. Once again, the report we are discussing today is an audit of the IRS's processing of tax-exempt applications. It is not uncommon for audits to present specific issues that lead to additional reviews or investigations. The inappropriate criteria discussed in this audit were the IRS is targeting for review Tea Party and other organizations based on their names or policy positions, a practice started in 2012 and which was not fully corrected until May 2012. Actually, the practice was started in 2010 and not fully corrected until May of 2012. These criteria were inappropriate in that they did not focus on tax-exempt laws and Treasury regulations. They remained in effect for approximately 18 months. The organizations selected for review for significant political campaign intervention experienced substantial delays in the processing of their applications. In addition, many of these organizations received requests for unnecessary information, including lists of donors. In closing, our overall assessment is that the IRS demonstrated poor judgment and gross mismanagement in the implementation of this program. The substantiated allegations are troubling and raise many questions. Chairman Issa, Ranking Member Cummings, members of the committee, thank you for the invitation to appear.
Thank you. Mr. Shulman.
Chairman Issa, Ranking Member Cummings, members of the committee, thank you for the opportunity to appear before the Committee on Oversight and Government Reform to discuss the Treasury Inspector General's findings. I was the Commissioner of the Internal Revenue Service from March 2008 until November 2012. And during that time, the agency was called upon to tackle a number of challenges. The agency played a key role in stimulus and economic recovery efforts during the economic downturn, aggressively addressed offshore tax evasion, and completed a major modernization of its core technology database. The agency also continued to deliver on its core mission of collecting the revenue to fund the government. The IRS is a major operation with more than 90,000 employees who work on issues ranging from processing individual tax returns to building complex technology, to ensuring compliance with businesses, to educating the public about tax law changes, to administering a very complex set of rules governing tax-exempt organizations. I've now read the Treasury Inspector General's report. I was dismayed and saddened to read the Inspector General's conclusions that actions had been taken creating the appearance that the service was not acting as it should have, that is, as a non-political, non-partisan agency. Utilizing a list with keywords to select applicants for review based on organizations' names or policy positions is, in my view, inappropriate, and damaging. The IRS serves a critical function for our nation. It collects the taxes necessary to run the government. Because of this important responsibility, the IRS must administer and must be perceived to administer our tax laws fairly and impartially. Given the challenges that the agency faces, it does its job in an admirable way the great majority of the time. And the men and women of the IRS are hardworking, honest public servants. While the Inspector General's report did not indicate that there was any political motivation involved, the actions outlined in the report have justifiably led to questions about the fairness of the approach taken here. The effect is bad for the agency and bad for the American taxpayer. I'm happy to answer questions.
Thank you. Ms. Lerner, I note that you have not provided a written testimony for the committee. Do you wish to make an opening statement?
Yes, sir, I do.
Please proceed.
Good morning, Mr. Chairman and members of the committee. My name is Lois Lerner, and I'm the Director of Exempt Organizations at the Internal Revenue Service. I have been a government employee for over 34 years. I initially practiced law at the Department of Justice and later at the Federal Election Commission. In 2001, I moved to the IRS to work in the Exempt Organizations Office. In 2006, I was promoted to be the director of that office. Exempt organizations oversees about 1.6 million tax-exempt organizations and processes over 60,000 applications for tax exemption every year. As director, I'm responsible for about 900 employees nationwide and administer a budget of almost $100 million. My professional career has been devoted to fulfilling responsibilities of the agencies for which I have worked, and I am very proud of the work that I have done in government. On May 14th, the Treasury Inspector General released a report finding that the Exempt Organizations Field Office in Cincinnati, Ohio, used inappropriate criteria to identify for further review applications from organizations that plan to engage in political activity, which may mean that they did not qualify for tax exemption. On that same day, the Department of Justice launched an investigation into the matters described in the Inspector General's report. In addition, members of this committee have accused me of providing false information when I responded to questions about the IRS processing of applications for tax exemption. I have not done anything wrong. I have not broken any laws. I have not violated any IRS rules or regulations, and I have not provided false information to this or any other congressional committee. And while I would very much like to answer the committee's questions today, I've been advised by my counsel to assert my constitutional right not to testify or answer questions related to the subject matter of this hearing. After very careful consideration, I've decided to follow my counsel's advice and not testify or answer any of the questions today. Because I'm asserting my right not to testify, I know that some people will assume that I've done something wrong. I have not. One of the basic functions of the Fifth Amendment is to protect innocent individuals, and that is the protection I'm invoking today. Thank you.
Thank you for your testimony. Ms. Lerner, earlier the ranking member made me aware of a response we have that is purported to come from you in regards to questions that the IG asked during his investigation. Can we have you authenticate simply the questions and answers previously given to the Inspector General?
I don't know what that is. I'd have to look at it.
Okay. Would you please make it available to the witness?
appears to be my response.
So it's your testimony that, as far as your recollection, that is your response.
That's correct.
Ms. Lerner, the topic of today's hearing is the IRS improper targeting of certain groups for additional scrutiny regarding their application for tax-exempt status. As Director of Exempt Organizations of the Tax-Exempt and Government Entities Division of the IRS, you are uniquely positioned to provide testimony to help this committee better understand how and why the IRS targeted these groups. To that end, I must ask you to reconsider, particularly in light of the fact that you have given not once but twice testimony before this committee under oath this morning. You have made an opening statement in which you made assertions of your innocence, assertions you did nothing wrong, assertions you broke no laws or rules. Additionally, you've authenticated earlier answers to the IG. At this point, I believe you have not asserted your rights, but in fact have effectively waived your rights. Would you please seek counsel for further guidance on this matter while we wait?
I will not answer any questions or testify about the subject matter of this committee's meeting.
We will take your refusal as a refusal to testify. The witness and counsel are dismissed. The gentleman will state a point of order. Please wait.
Mr. Issa, Mr. Cummings just said we should run this like a courtroom, and I agree with him. She just testified. She just waived her Fifth Amendment right to privilege. You don't get to tell your side of the story and then not be subjected to cross-examination. That's not the way it works. She waived her right to Fifth Amendment privilege by issuing an opening statement. She ought to stand here and answer our questions.
Chairman.
Mr. Cummings.
First of all, with all respect to my good friend, Mr. Gowdy, I said I'd like to see it run like a federal court. Unfortunately, this is not a federal court, and she does have a right, and I think, and we have to adhere to that.
Thank you. We'll pause for a moment. Ms. Lerner, I'll ask you just a couple of additional questions. Is it possible that we could narrow the scope of questions and that there are some areas that you would be able to answer any questions on here today?
I will not answer any questions or testify today.
Ms. Lerner, would you be willing to answer questions specifically related to the earlier statements made under oath before this committee?
I decline to answer that question for the reasons I've already given.
For this reason, I have no choice but to excuse the witness, subject to recall after we seek specific counsel on the questions of whether or not the constitutional right of the Fifth Amendment has been properly waived. Notwithstanding that, and consultation with the Department of Justice as to whether or not limited or use of immunity could be negotiated, the witness and counsel are dismissed. The clerk will please rearrange the seating. For all the members on both sides of the dais, I think it's important that we take a moment, both I think I speak for Mr. Cummings and myself, this is a committee that is investigating more than anything else the ultimate right of free speech and the First Amendment. So as we go on with the rest of this hearing, I would admonish all of us to remember that it's not the First Amendment or the Second Amendment or the Fifth Amendment or the 10th Amendment in a vacuum. We have to respect them all. The gentlelady who has departed was entitled to assert her Fifth Amendment, although there are some questions about how it was done. There can be no question that we have to respect it. Additionally, that her assertion is not to be viewed or used during this hearing to make any determination plus or minus as to actions that were taken. We have the Inspector General with us today. We have other fact witnesses, and this committee has more than 10 additional witnesses that will be called either to hearings or to interviews already on the schedule. I believe that this committee has a long history of very few during my tenure of 12 years of these occasions, and we should not use this either for political gain or for any indication that it is anything other than somebody's right. It is the committee's work to find out what went terribly wrong. I'll take one liberty mentioning Mr. Cummings' earlier statement. At this point, this committee is not investigating wrongdoing for political purposes by high-ranking individuals in or out of this government. We are investigating something which has now been entered as fact. That wrongdoing occurred, and occurred over a group, and that group happened to be key-worded things that are generally called conservative. In my research on this, and I think Mr. Cummings would agree, this is not new to government. This has happened before, and it has not always been conservative groups. So as we go through this, I would ask all of us to avoid talking about who was liked by President Bush, who is liked by President Obama, who is liked by Republicans or Democrats. Let's all be Republicrats and Democrats today. Mr. Cummings.
Mr. Chairman, first of all, I appreciate you saying what you just said. And I agree with what you just said. And I would associate myself with your words.
Mr. Chairman?
Thank you. What purpose does the gentleman seek recognition?
Gentleman, just for 1 minute.
A fraction thereof.
I just want to say the same. I appreciate what the chairman said. I think he's right on target, but the irony is inescapable. Ms. Lerner gets to exercise her constitutional rights, but she won't stay here and answer questions about the constitutional rights of thousands of Americans who were denied by their actions.
I think the gentleman, it is this committee's goal to get to the truth. If we have to go circuitous routes, we will eventually get there. The dots will be connected. With that, Mr. Woolen, would you move over? It'll be less distracting, and we'll remove the other chair. Actually, I'll take note of the gentlelady's opening statement. She made it very obvious with 90,000 IRS individuals, 900 working for her, and more or less 9 out of 900 involved in this, or maybe slightly more. We're talking about a fraction of 1% of the IRS, and I join with the gentleman in recognizing that this is not to disparage the men and women of the IRS. Mr. Woolen, you're recognized for 5 minutes.
Thank you, Mr. Chairman. Chairman Issa, Ranking Member Cummings, members of the committee, thank you for the opportunity to appear before you today. Last week, the Treasury Inspector General for Tax Administration, Mr. George, published a report on the Internal Revenue Service's use of inappropriate criteria to identify tax-exempt applications. Like President Obama and Secretary Lew, I believe that the activities described in the report are absolutely unacceptable and inexcusable. The IRS must operate without bias or even the perception of bias. It must act in an utterly nonpartisan manner. It must act with the utmost integrity. The IRS did not do that here. Upon learning of the IG's findings, President Obama and Secretary Lew took immediate action. First, within 24 hours of receiving the IG's report, Secretary Lew asked for and accepted the resignation of the acting commissioner. The next day, the acting commissioner for tax-exempt government entities tendered his resignation. The day after that, the President appointed Danny Werfel to be the new IRS Acting Commissioner and charged him with holding accountable anyone responsible for improper conduct. Second, Secretary Lew instructed Mr. Werfel to implement fully and promptly all 9 of the recommendations in the IG report. Secretary Lew also directed Mr. Werfel to examine and correct any failures in the system that allowed this behavior to happen. Third, the Secretary asked Mr. Werfel to conduct a broader review to see whether the inexcusable conduct reflects larger management failures and cultural issues at the IRS that require systematic change. Secretary Lew directed Mr. Werfel to take action and implement necessary changes. Within 30 days, Mr. Werfel will report back to Secretary Lew and the President on his progress and on any future actions he expects to take. Before I describe Treasury's interactions with the IG related to this audit, it is important to underscore 2 critical points. First, there is no indication that Treasury was involved in the improper conduct of the IRS. The IG report did not find any evidence that Treasury or others outside the IRS had any role. Mr. George confirmed this point in his testimony before the Ways and Means Committee last Friday and before the Senate Finance Committee yesterday. Second, the improper conduct already had ended by the time Mr. George informed Treasury of the fact of his audit. Mr. George's report states that the improper conduct ended in May 2012. Mr. George has testified that he first notified Treasury of the fact that he was conducting an audit in June of 2012. At some point in 2012, though I do not recall precisely when, Mr. George notified me, at his initiative, that he had undertaken an audit of the IRS's review of tax-exempt applications. He told me only of the fact that he had undertaken such an audit and did not provide any findings. That is my recollection, and that is what Mr. George testified before the Ways and Means Committee last Friday and before the Senate Finance Committee yesterday. In that conversation, I told him that he should follow the facts where they lead. I told him that our job is to stay out of the way and let him do his work. I told him to let us know if he wanted our help, and otherwise to let us know when he had more to tell us. I understand that Mr. George also notified this committee in July 2012 that he had begun his review. And similarly, in October 2012, he provided a notice on his public website that he was conducting his review. Again, to be clear, Mr. George told me that he was conducting an audit, and I told him to follow the facts wherever they lead. Our core principle is that we do not interfere in any way with the independent review of an Inspector General. When an Inspector General tells us he is conducting a review, we step back and leave him to do his work. That is how the process functions, that is how the process should function, and that is how the process functioned here. Let me reiterate that there is no indication that Treasury was involved in the inexcusable behavior at the IRS, and Treasury only learned of the fact that the IG was conducting a review after the unacceptable conduct had already ended. It is important in this context to make clear that Treasury's longstanding practice, spanning Republican and Democratic administrations, is not to involve itself in the details of the IRS's administration and enforcement of the nation's tax laws. It is critical that the nation's tax laws are administered and enforced in a way that neither involves political influence nor the perception of political influence. This is particularly true with respect to decisions affecting specific taxpayers. Over the past 12 days, President Obama and Secretary Lew have taken decisive action to address what happened at the IRS. The President named a new acting commissioner, and we charged him with holding responsible parties accountable and with taking immediate action to prevent these inexcusable acts from happening again. Treasury is committed to taking all measures to restore the public's confidence in the IRS, and toward that end, we have asked the IG for its continued assistance, and we are cooperating fully with this committee and with the Congress. Thank you again for the opportunity to appear before you today.
Thank you, Mr. Willen. I'm going to comment that I've never heard his defense of not knowing, and I'm disappointed. I'm going to go through a line of questioning primarily with Mr. George. Mr. George, before the Ways and Means Committee, you told Representative Danny Davis the following. Our audit, sir, began with the request of congressional staff in what I want to give you the exact date, sir. I do not have it here. March 1st of 2012 is when there was an initial contact with the Government Reform and Oversight Committee, and our audit began, or roughly, and then you go on with May or March, et cetera, et cetera. So essentially, this began in your mind when you were made aware of it in March of 2012 by members of my committee, staff members of my committee, correct?
Yes.
So, oddly enough, we have with us, and put it up on the board, from Holly Paz, a document just released to us, I guess in preparation for yesterday's interview, that says, forward TIG document request. The following are issues that could indicate a case to be considered a potential Tea Party case and sent for secondary screening. 1, Tea Party Patriots of 912 Project. 2, or number 4, statements in the case file that are critical of how the country is being run. Now, that's May 20th of 2013. To your knowledge, is that that is essentially the result of an internal investigation done by the IRS, not your investigation? Oh, I'm sorry. That's July 23rd. I'm looking at emails, which unfortunately are this year, but that's July 23rd, 2012. Is your understanding that the IRS concluded that they had wrongdoing through their own internal investigation by July 2012?
I have no information on that, but let me consult with my counsel.
I can go ahead.
I have been informed that they conducted an internal review, sir, that was completed before that period.
Okay, so it's your testimony that, in fact, independent of your activity, Mr. Schulman's reports conducted and concluded wrongdoing and could have, in fact, reported that up the chain and taken appropriate action independent of your activities.
That is certainly an option, sir.
So, Mr. Schulman, before I go back to Mr. George, it was your watch. Your people did an internal review. How is it you did not know that things were rotten in your shop in time to not only make sure it stopped and stayed stopped, but in fact the Treasury, your boss sitting next to you, was aware of it?
You know, I've said that I learned about this sometime in the spring, and by this, I mean I learned the fact that there was a list and the fact that Tea Party was on it.
Okay, so you knew at that time that you had mistreated Americans within your organization and saw no need to report it up the chain. Is that your testimony?
My testimony is that at that point, I had had a preliminary verbal report. I had been told at that same point that the activity was being stopped, and I was told that the IG was looking into the matter.
Stop there. I don't really care about the IG right now. The IG probably prompted the internal report. The IG, in fact, has been the reason that we didn't hear about this until long after the election, till months or actually a year had gone by. I'm asking you a question. It was your job to make sure people weren't abused. It was your job to stop abuse, but also to report it. Americans had been injured by the activity, wrongful activity of your organization. You say you got to vote. I don't care that the IRS doesn't keep paperwork. I know when I have to pay my taxes, I don't do it based on what I say I made or what I say my deductions are, that I need paper. However, you knew you did not report up, or did you report up to anyone else within your chain?
I had some of the facts, not all of the facts. I had no idea of the scope and severity. I didn't know the full list. I didn't know who was on the list.
I'm not going to belabor that because I don't know has been your answer previously. I'm going to move back to the IG. Mr. George, September 24th, 2012, committee staff mentioned, your report would be ready in September. Now, these are exchanges we're putting up here that are back and forth. They're not all personally with you. So September 24th, 2012, the answer to our request about this IG report was field work for this audit is still ongoing, meaning we don't get an answer. December 18th, 2012, any update on this? Sorry for the delay response. I was studying for a final. Okay, that's when it was pushed off to March. These are staff. Committee staff just wanted to know, to check on the progress of this. This is February 12, 2013. Of this, are you at a point where you can schedule a briefing? from your organization. We are leaving no stone unturned. This is February 22nd of 2013. We won't be able to provide a detailed, substantive briefing until late April, early May. My time is limited, so I'll put the rest in for the record. Mr. George, I could go on as late as May 9th, where the committee staff said on the 8th, can we go ahead and schedule a briefing? May 9th, I'll get back to you. And it goes on. Mr. George, this committee and the entire Congress has existing laws. Yesterday I spoke before all of your fellow IGs. Under existing law, you have a peer-level report of substantial misconduct or problems, including waste, fraud, and abuse. The Act describes your establishment, which meaning, in this case, the IRS, and Congress in the same sentence. On August 3rd, this committee, I sent you a letter explaining the 7-day rule, explaining the statute as it has been written for decades. You have a responsibility to keep us continuously and, according to statute, equally informed. In this case, it appears as though you certainly did not. Would you agree with that?
No, actually.
Okay, so when you conducted day after day after day with Mr. Schulman's subordinate, Ms. Paz, one after another interviews in which she's in the room, she's listening to all of these, you're doing that. You know at some time, and I'm going to close with just a question, on what day did you know, over this year period, did you know personally that in fact the IRS had abused Americans in the process of approval? What was that day? What was the aha moment? And didn't you have an obligation to report that to Congress at that time?
Mr. Chairman, I have a detailed timeline which goes from almost month to month as to the interactions that we had with your staff and then subsequently with the Commissioner as well as with officials at the Department of the Treasury. And I would appreciate the opportunity to give you a sampling of it.
We're going to accept that, and I just want to close, and then I'll let you take as much time as you need. If your timeline essentially says you kept us informed so we knew that, in fact, there was a pattern and could speak to Ways and Means to find out that hundreds of people, hundreds of organizations still languished not being approved even after, quote, the abusive behavior began, they still didn't get their answer in a timely fashion. And if you're saying that you informed Mr. Woolen so that he would understand what was going on, or others at Treasury, and you informed us, and Mr. Schulman, here's my problem. Mr. Schulman has already said under oath he didn't know. Mr. Woolen has already said they didn't know. And although I'm not under oath, I have reviewed my committee staff documents, and of course it's a bipartisan relationship. We certainly did not have the information in any way, shape, or form that could be understood so that congressional action could occur until practically today.
Mr. Chairman, there are established procedures for conducting an audit, and once again, this is an audit. And to ensure fairness and to ensure that we are completely accurate with the information that we convey to Congress, we will not report information until the IRS has had an opportunity to take a look at it to ensure that we're not misstating facts.
Mr. George, that is not the statute. That is not the statute.
But it would be impractical for us to give you partial information which may not be accurate. It would be counterproductive, sir, if we were to do that.
Well, I appreciate that. I've taken a lot of time, and I'll give the same amount of time, of course, to my ranking member. But this committee, last August, made it very clear that the statute as written does not give you the ability to, for any IG, to use us as a whipping boy when you want to, and in fact keep us in the dark until an investigation is completed. Mr. Schulman, I will admonish you as best I can as one member of government to a former member of government, that in fact there was a there, people in your own internal operation knew. If you didn't know, you were derelict in your duty, or your management style was such that you didn't get informed. Either way, that is certainly certainly not something you should be proud of. To the extent that you did know or suspected, Mr. Willen standing here or sitting here implying the Treasury didn't know is astounding. Mr. George, fact is, if these individuals did not know, then you did not allow them in a timely fashion to take corrective action, even while you continued with what could be a criminal investigation / audit. In the case of Congress, I will work with the ranking member to reiterate with clarity Congress's absolute right to have, according to the statute, continuous information, and that is not waiting for the final conclusion. The Act did not say audits and investigations shall, upon their conclusion 7 days after being given to the principal, be delivered. That is not the portion that we referred to in August of last year. I'll give you the last word.
Sir, I would welcome the opportunity to work with you and other members of Congress to clarify exactly what the quote-unquote 7-day rule is under the Inspector General Act. But once again, I think it would behoove all of us to ensure that accurate information is given to Congress so that we don't act precipitously. And as you, I'm sure, are aware, many times when information is conveyed to the Hill, it is sometimes not retained in the Hill, and on the Hill, rather. And that is not fair to the people who were investigating or
I apologize. I said I would give you the last word, but right now we're seeing an awful lot leaking out of the administration, and the IRS leaked in this particular case. This organization maliciously leaked this information. Mr. Willen, the only other thing, and I apologize, Mr. Cummings, I'm going way past where I ordinarily would. It is our understanding that today, as we speak, dozens, if not hundreds, of applicants who have been waiting years are still being essentially denied justice. If they continue to be denied justice, every clock tick is a clock tick of you're not meeting your obligation. Mr. Shulman has left office. He left office without making sure that those, quote, Tea Party groups and others had a legitimate adjudication in a timely fashion, which means they were already overdue because of the prior abuse. To the extent that there's one applicant that comes forward to this committee that today has not been approved or denied for cause, you are now derelict in your duty. Mr. Cummings.
Thank you very much, Mr. Chairman. Mr. Shulman, I want to pick up where the chairman left off with you. You were the head of the IRS from 2008 to 2012. All of this activity happened on your watch. The development of these terms, the use of the terms, and the targeting of conservative groups. The IG called this activity inappropriate, but I think it's far worse than that. It undermines the public trust in the IRS, and that's very, very unfortunate. I want to ask you about two major issues. First, I'd like you to address the allegation that the administration was engaged in some kind of effort to use the IRS to target its political enemies. So I want to walk through this very quickly with you. Who nominated you to be the head of IRS?
President Bush.
Are you biased against conservative groups?
No.
Do you think they deserve more scrutiny than liberal or progressive groups?
No.
Did you ever order IRS employees to target conservative groups?
No.
Did you ever encourage or prompt them to do so in any way?
No.
Did you ever receive instructions from anyone at Treasury to target conservative groups?
No.
Did you ever receive instructions from anyone at the White House to target conservative groups?
No.
So these misguided actions, Mr. Shulman, were initiated by IRS employees. They were not part of any administration conspiracy, and you had no knowledge of them before 2012. Is that right?
I personally don't remember ever hearing about this until the spring of 2012.
Now, we've dispensed with that issue. I want to address the very serious question of why you failed to inform Congress about these activities last year when you learned of them. And I must tell you, Mr. Schulman, I want to remind you that you are under oath. And I tell you, when I watched your testimony the other day, it was very troubling. As a matter of fact, some of your testimony this morning has been troubling. And so I want you to give us your answers, and I know you will be truthful. Members of Congress wrote numerous letters to you expressing concern that conservative groups were being targeted by the IRS. When asked about these allegations at a hearing before the Ways and Means Committee in March 2012, you answered, and I quote, "There is absolutely no targeting," end of quote. Even if you did not know it was going on when you testified, you learned about it soon after, but you never corrected the record. You were the head of IRS. Why didn't you ever come back to the Congress to explain that you were mistaken?
So what I can recall is that I learned about the list after that testimony. And when I learned about the list, I learned two other things. First, I learned that the activities were stopped. So by the time it got to me, the list was no longer being used within appropriate criteria. And I also learned that the matter was in the hands of the IG. And my standard procedure as head of the IRS is when I knew something that sounded of concern, as the chairman called smoke, and I didn't have all the facts. I didn't know what was on the list, exactly how it was used. Were there liberal groups as well as conservative groups? I didn't have the facts. And it was in the hands of the IG, that the IG would do a thorough review of the matter, and when he had all of the facts, would report that to the IRS, to the Treasury, and to Congress. And so at that point, I didn't have anything concrete. I didn't have a full set of facts to come back to Congress or the committee with.
That answer would be more acceptable if you had not given the answer that you did in March 2012. When Congress asks you a question and then you say these words, there's absolutely no targeting. It seems to me that even given what you just said, you knew that Congress was concerned about this issue. You knew then that the information, you just said it had been corrected, but it seems to me that if you say to Congress absolutely not, absolutely no targeting, it seems to me that you would come back, even if it was a phone call or a letter or something. I mean, common sense. People, I mean, a reasonable person would expect you as the head of the IRS communicating with Congress to come back and do that. You didn't feel that way, though.
I mean, I guess I would repeat.
I don't want you to repeat.
In March,
I don't want you to repeat. I take it that you disagree with what I just said.
At the time I learned about this list, I felt I was taking the appropriate actions and that my course was the proper one, and I still feel that way today.
Well, I'm sorry, that's simply not good enough. It's simply not good enough, Mr. Schulman. The IRS conducted an internal investigation of its own. Not the IG investigation, but your own investigation. You personally knew there was a target list. You knew it said Tea Party on it. You put new processes in place, and you took personnel actions. You reassigned at least one individual back in 2012. Come on, Mr. Schuman. I mean, help us help the taxpayers. Am I missing something?
So
did you have an investigation? Was there an internal investigation?
I never understood that word, internal investigation.
Did you ever assign at least, reassign at least one person back in 2012?
Not that I was aware of.
You don't know that?
To the best of my knowledge, I was not involved in the reassignment of people in the determinations unit. I have no recollection of that.
So when you learned about the targeting, apparently you made some kind of inquiry because you said you found out that it had been resolved. Who did you go to, and who told you that it had been resolved, and what did they say the resolution was? You were the head of the IRS.
I was the head of the IRS.
And you got Congress people that were upset about targeting. They had been asking questions. You had come and said there was absolutely no targeting. And so help me with this.
Yeah. First of all, I mean, let me express this is a very serious matter, and I fully recognize that. This was a 90,000-person agency, and this was a unit that was working on applications by definition for organizations that had political activity. My general operating style as the only one of two presidential appointees in the building was to have the responsible career officials be the hands-on people in sensitive case matters that involve political activity. So my deputy informed me of this.
And who was your deputy?
Steve Miller.
Okay.
And at or about the same time, he informed me that we found this list. It had Tea Party on it. I have no memory of having knowledge of what was on the list, what else was on the list. To the best of my understanding, didn't know how it was being used, didn't know if it also had the target word progressive on it. He said, look, it's not being used anymore, it's being stopped. The IG is looking into it, and I was aware that some of these cases were languishing because we'd gotten letters from Congress, and he said, and we put extra people on there and we're moving cases. That's my memory of this. And as I said, once the IG has this, my practice was to support IG reviews and investigations, but not interfere with the full confidence that he would get the information.
But this has nothing to do with interfering with an IG investigation. This is merely coming back to Congress. You got to understand why I'm getting to this. Remember in my opening statement, I said two words, just two. Truth and trust. And we want to be able to trust the IRS, but for this moment, on this day, we need to be able to trust your word. And what I'm saying to you, you keep telling me, you act as if something that was a paramount concern to the Congress, paramount concern to the chairman of the top investigative committee in the Congress, and you find out information and you know it's a concern, did you get upset when you heard this from Miller?
Yeah, I had concern. I didn't know the scope and severity of it. As head of the IRS, I felt comfort that the IG was going to look into it, find the scope and severity, and report it back to Congress at the appropriate time.
Mr. Chairman, as I close, you know, you headed up an organization. You were responsible for that organization. You don't even know that an employee was reassigned back there. And you did not come back to Congress and let Congress know what you knew. You didn't have to give us a lot of details. It's just that if I had said something to Congress that was just the opposite of what it was, seems like just logic would tell me to go back and say, look, I thought that I acted on certain information I didn't have. Now I have it. This is what it is. I have limitations. There's an IG investigation going on. but at least I want to set the record straight. I take it that you disagree with what I just said.
I told you before, I think I took the proper course.
Very well. Thank you, Mr. Chairman.
Thank you, Mr. Cummings. We now recognize the gentleman from Florida, Mr. Mika.
Thank you, Mr. Chairman. And I guess look around, I end up being the most senior member of this panel, and having seen a number of scandals and also participated in various investigations, I don't think I've ever seen any investigation or review by this committee or subject that has so riveted and shocked the American people. Going home last weekend, almost to a person, everyone asked me about this. Maybe it's because what Mr. Cummings said, you know, people expect truth and trust in government. Everyone, just about everyone that I deal with or talk to pays taxes or has to deal with the IRS. So this has really come home to them in a very personal way. They want us to get to the bottom of this. And Mr. George, you know, so far IRS would have us believe that this is a bunch of lower-level IRS employees who got around the water cooler one day in Cincinnati and said, who do we target this week? And they sort of got out of hand, and that's the end of the story. Do you think that's the end of the story?
I do not, Congressman.
You do not. And neither do the American people. What's disturbing, too, is I made this little chart this morning. Sort of the pattern. This isn't very fancy. The staff, not highly paid graphics here, but you know, this all started back in 2010. And here's a long list, Mr. Schulman, of members of Congress who contacted you, and I see Sarah Hall Ingram, I see Lerner, on and on. Not just people like Mr. Eisen and myself of this committee, but senators and everyone else asking questions here, all the way through. And for 27 months, you said you did all you could to expedite those requests. For 27 months from here to here, nothing got done. None of those were approved, were they? Not one. Not one.
I defer to Mr. George, who's
I'm
looked
just
into the
telling
details.
you, we checked 27 months, none. So what you're saying, it doesn't hold truth. Now, the thing, too, and you may disagree with the Tea Party or conservative groups, so whether you're liberal or conservative, Americans under the right of this little document, the Constitution, you know, maybe not in the framework of the Constitution, but right at the beginning, we have 10 amendments that the Founding Fathers to pass it, put in there. The first is the freedom of speech. You closed down or gagged for 27 months people, or folks who work for IRS, closed them down for 27 months between 2010, when we were discussing policies of expanding government, of health care important to the American people, of a whole host of issues, plus the election coming up. For 27 months, you gagged or closed down the legitimate right of those folks to participate in the process under the Constitution. Do you disagree with that?
Let me premise that I was, because on purpose, I was not heavily involved in let me finish, in tax-exempt organizations, but my best understanding is people were not closed down during this time. No, my best understanding, though, is that people were operating at that time, and there's also, my best understanding is there's a whole other option for someone to be a 501c4.
Mr. Miller,
they don't need to apply.
Did you know Mr. Miller or had sent or had you approved of sending Ms. Lerner down to look at this?
Mr. Miller informed me sometime in the spring that he was going to look into the matter further and find out what was going on down in the
But did you know Ms. Lerner was doing it?
My interactions on this were directly with my deputy.
Okay. Well, did you know, for example, Ms. Lerner, who's the head of it, got a total of $740,000 between 2009 and 2012 over $42,000 in bonuses. Would you check off on bonuses? And this is the one that used to sit there and was going to testify but didn't. Do you check off on
that number does not sound familiar. I didn't individually make decisions, but I probably signed off on overall agency compensation.
And have you participated in the political process? Could you tell the committee of your political participations, donations?
My whole life?
Well, yes. Are you, I don't know your background. I heard you were appointee of one administration, but what is your history of participation?
My full life history of participation in politics, I don't.
The gentleman's time is soon to expire. We could take a short version,
let me
please.
Not try to take you through all of it.
For example, to parties and groups?
Have I?
Yeah.
In the past? To the best of my recollection, I have.
You have?
Yeah, I mean, to the best of my recollection, I have. I haven't in a long time. Didn't make any contributions while I was IRS Commissioner.
Thank you. Thank you, Mr. Chair.
The Chair now recognizes the gentlelady from New York, Ms. Maloney.
Thank you, Mr. Chairman. I believe we are united in this committee in being outraged at the alleged targeting of Americans for their political beliefs by the IRS. Mr. George, is it illegal to target Americans in the IRS for their political beliefs? Is it illegal activity?
The way in which the Internal Revenue Service exercised their authority in this matter, at this stage, Congresswoman, we do not deem it illegal. We do not believe that it was illegal what they did.
Do you believe it should be illegal to target Americans in the IRS for their political beliefs?
Well, the IRS currently has policies which state that if there are willful actions taken that would violate civil rights of a taxpayer, which would in other ways falsify documents, destroy documents, there are illegal activities that the Internal Revenue Service employee can engage in. But I have to note, Congresswoman, that the Secretary has delegated tax policy questions to the Assistant Secretary for Tax Policy, and I have to defer to him.
Well, I personally believe it should be illegal, and I find it very troubling, the allegation that the IRS not only targeted Americans for their political beliefs, but also withheld information from this committee. And specifically, Mr. George, in roughly March of 2012, Chairman Issa and Representative Jordan sent you, or rather Mrs. Lerner, asking for information about the potential targeting of Tea Party organizations by the exempt organization office. Is that true? And that in response to that letter and media reports and requests from this committee that you started an investigation of and reviewing the applications for tax-exempt status. Is that correct?
Actually, it is correct, but we had had conversations with staff of this committee prior to the receipt of that letter.
But you did begin an investigation?
Yes, we did.
And your staff informed Chairman Issa and this committee about that investigation, correct?
That is correct.
Mr. Shulman, in March of 2012, the IRS began conducting its own internal review of the tax-exempt organization division. Is that true? Did that happen? And is that a common occurrence? Why did the IRS start their own internal review when you have an IG whose job it is to do the internal review, and he had notified Congress that he was doing the review?
Look, I don't have a direct recollection of the time frame, but I read the report and saw that in the report in late March, at least in the report, it said that my deputy asked someone to go take a look, and I think that's what you're talking about.
Well, absolutely.
My understanding at the time, I'm sorry.
what I'm talking about is you did not inform the committee that you were doing an internal review, which is the process.
I don't remember it ever being called an internal review. I remember somebody coming to me and saying, hey, people from headquarters are going to go down and talk to the folks in Cincinnati and find out what's going on.
Okay.
And so I don't, I don't remember it being
well. Then specifically, the IRS not only chose not to alert Congress and this committee about the internal review or looking into it, whatever you want to call it, but on April 26 of 2012, Ms. Lerner responded to a letter from this committee with her own letter stating that information was gathered from these organizations, and I quote, in the ordinary course of the application process to obtain the information as the IRS deems necessary to make a determination whether the organization meets the legal requirements for tax-exempt status, end quote. And at no point in the letter did Ms. Lerner mention that IRS officials were conducting their own internal review. And Mr. Shulman, why did she omit that fact?
I'm not familiar with that letter. I'm sorry.
And in fact, Ms. Lerner never informed the committee of what was happening in the IRS tax-exempt status in any way. And I just would like to ask you, do you think it's appropriate for the IRS to send such a misleading response back to this committee?
I'd have to look at the whole response, and if it came from Ms. Lerner, it's very unlikely that I knew about it or reviewed it.
Well, I would say that we're all outraged, but it's not too early to start talking about what we can do to fix it. And in your report, Mr. George, you mentioned that it need to be clarified. What is tax exempt? What is not? What is political activity? What is not? What is the status of changing it so that this doesn't happen in the future?
Once again, Congresswoman, that is a tax policy question. I don't know the answer to that, and that would fall within the ambit of the Assistant Secretary for Tax Policy. But if I may, please just elaborate on my earlier response to your question. We are still in the process of looking at this matter. It is possible that criminal activity may have occurred, but it is too early at this stage to make that determination. Ma'am.
My time has expired.
Thank you. Mr. George, just to clarify on the gentlelady's question, you did talk about the complexity about the system, but in no way did you say that this misconduct was the result of a lack of clarity. In other words, targeting these individuals is not because of complexity, but rather something that was inappropriate, whether it was complex or simple.
It's a combination, Mr. Chairman. The determinations unit did have some technical questions which they submitted along the chain to the appropriate people in Washington. It took over 13 months before they received a response. That was a cause of some of the delay in addressing some of the exempt issues. But I would attribute it mostly to a lack of training, sir. That there was very inadequate training of the people who were handling these applications. And I do fault the IRS for that.
I thank the gentleman. We now go to the gentleman from Ohio, Mr. Turner.
Thank you, Mr. Chairman. I appreciate your holding this hearing. There are a number of investigations, congressional, internal IRS, Department of Justice, the IG, all targeting the issue of who knew what when, who was involved, who directed these targeting actions, and who is complicit. And the answer to all these questions, we will find out. Through all these investigations, we will find out who at the IRS, who, if any, at the White House, and who, for political reasons, targeted conservative groups, Tea Party groups, and constitutional groups. There are those who would have us believe that this was just spontaneous, that this just erupted in the organization, but I don't think anybody believes that. Someone did this. Someone directed this. Someone orchestrated this. And someone was complicit in this. But that's not my focus today. My focus today is wanting to make certain that this never happens again. I was absolutely shocked when Ms. Lerner from the IRS made her statement of, we made mistakes. For that, I apologize. I was shocked, and I think the American people were shocked because they were thinking, that's it? An apology? That the actions of the federal government using its investigative arm
to prosecute American citizens based upon their political beliefs and their affiliations, their membership, their activities, and they get an apology? Now, Ms. Lerner has invoked her constitutional rights not to answer our questions about her involvement or the IRS's involvement, ironically, about denying others their constitutional rights. I believe that that should be a crime. Mr. Shulman, it's reported in my community that you and I hail from the same hometown community. So I have a question of you, and it's not about what you knew when, it's about what you know now. Do you believe that the actions of the IRS in targeting individuals based upon their political beliefs represents the values of our hometown community, or our country, or even our democracy? Mr. Shulman?
I've read this report, and this use of the criteria used by the IRS was inappropriate. It's something that I'm incredibly sad about. I'm sad that it happened. I'm sad that it's cast a shadow over the rest of the good work of the agency. And
you would agree it doesn't represent our democratic values, correct, Mr. Shulman?
So far, I mean, look, Mr.
Shulman, do you agree that it doesn't represent our democratic values to have the government persecute people based upon their political beliefs? Surely you can.
I did not see those words in the report, Mr. Turner. And
Mr. George, Mr. George, you've been subject to criticism for the timing of the report, but I want to thank you because, but for your answers and your work, we still would not know. If we waited for the IRS to tell us, we still would not have any understanding of what has occurred. Now, you answered Carolyn Maloney from New York that you do not have any evidence of a crime, and you have not concluded that a crime has occurred. Is that correct, Mr. George?
As of this time, yes, sir.
Mr. Shulman, if you had directed this, according to the United States Code, this would have been a crime. You would have been subject to 5 years of incarceration and $5,000 in a penalty. I personally believe that whether this happens from someone under you or by you, it should be the same. I've introduced H.R. 1950 that would make this a crime for anyone in the IRS to target someone based upon their political beliefs or their religious beliefs. We have over 80 co-sponsors. Marco Rubio has entered it into the Senate. I think this is an important step to say this will never happen again because no one should have a supervisor walk in their office and tell them to target Americans based on their political beliefs and have that employee do it. Without an understanding that not only are they violating somebody's constitutional rights, but they're violating the United States Code, and they will go to jail. Now, I happen to believe that even without this, that there are people who are going to go to jail and that there were constitutional rights violated. I think there were laws violated. And I think it's why we have to continue these investigations. Mr. Woolen, you've continued to answer the question as to when you knew things based upon the assumption that the question that you're being asked is when did you know about the IG report. I don't want to know when you knew about the IG report. I want to know when you knew that the IRS was targeting people based on their political beliefs and their statements such as Tea Party or constitutionally directed organizations. When did you know what was happening in the IRS, not when did you know what Mr. George was doing?
Congressman, I learned that when Lois Lerner made her public statement, and then subsequently a few days later when the Inspector General released his report, I did not know any of the findings or the details of the substance of what Mr. George looked into in his audit until then.
Mr. Shulman, one more thing. You said that you were a political appointee and that if the employees beneath you had gotten political, that you were not taking actions. I think it's a travesty that you would have had a constitutional oath to execute your duties, and as a political appointee, you decided that if the organization decided to take political actions against people, it was not within your responsibility, because it absolutely was. And we're going to get to the bottom of this, and I certainly hope that in the future this is criminal and no one at the IRS is just subject to merely termination. Thank you,
Mr. Turner, you misstated what I said.
Before yielding to Mr. Lynch, Mr. Woolen, just to follow up Mr. Turner's question, when did you learn of the internal investigation the IRS was conducting?
I learned through whatever testimony over the last few days. I hadn't heard of it before.
You didn't know about it earlier?
No.
Okay, thank you. Mr. Lynch, you're now recognized for 5 minutes.
Thank you, Mr. Chairman. Mr. Shulman, I want to go back over your testimony before Congress. On March 27, 2012, you testified before the Committee on Ways and Means. Did you have a chance to talk to Mr. Miller prior to your testimony?
On March 22?
March 22nd, 2012. Any time prior to that, did you have a chance to talk with, now you're testifying before Congress, obviously you prepare for that. Did you speak to Mr. Miller before your testimony?
To the best of my knowledge, I did.
You did, okay. How about Ms. Lerner? Did you speak with Ms. Lerner prior to your testimony?
I don't remember speaking with Ms. Lerner before my testimony.
Okay. I want to just describe what Chairman Boustany said to you in a dialogue. He said, "We have seen some recent press allegations that the IRS is targeting certain Tea Party groups across the country, requesting what have been described as onerous document requests, delaying approval for tax-exempt status, and that kind of thing. Can you elaborate, this is his question to you, can you elaborate on what is going on with that? Can you give us assurances that the IRS is not targeting particular groups based on political leanings?" In response to that question, you answered, and this is a quote, "There is absolutely no targeting." Now, what was the basis of your answer?
So I had received letters from members of Congress, I believe.
I know that. You received a lot of them.
Excuse me?
You received quite a few.
On this issue, I believe I received 2, but I'm not sure of the number before that testimony. And I said no targeting in the sense, and this, if you read the full testimony, that there's 2 ways for a social welfare group or a 501c4 to start operating.
Well, I'm not going to let you use up my time on that. Your answer was, the operative language was, there is absolutely no targeting. What was the basis for that statement? So obviously,
I can give you my explanation, and to the best of my recollection, what is in my mind, if you'd like me to.
Yeah.
So I said there was no targeting in the sense that there's 2 ways.
No, you said there's absolutely no targeting. It was more affirmative than that. What I'm getting at is you definitely gave Congress the impression that was absolutely no targeting. Absolutely no targeting. That's what you said.
If you give me a minute, I can actually explain this.
Well, I only have a short amount of time. If you can explain it quickly.
Well, first let me just say, I answered truthfully based on the information I had at the time.
That's what I'm getting at. That's what I'm getting at. What was the basis of the information you had at the time? How could you sit there under oath, testify before Congress and say there's absolutely no targeting going on, and put Congress in that position to believe that you're telling the truth? What was the basis of your understanding when you led Congress to believe that there was absolutely no targeting going on?
That's what I'm actually trying to say.
Okay.
So I said there was no targeting in the sense that a 501c4 had 2 options to operate. They could apply or they could start operating. There's no need to go through this application process. You can be a 501c4, do your business, and file a tax return at the end of the year. I said there was no targeting in the sense that, from conversations that I had had, that these people voluntarily come in. And so the question that had been posed to me was, why are they getting all these questions? And I had said that it's normal to have this kind of back and forth. So that was one piece of my understanding. The second is, my understanding at the time was that conservative groups, and this is to the best of my recollection.
All right, I want to take back my time. I understand.
My understanding was that conservative groups were not the only ones getting these questions. That was my memory.
So progressive groups were also being targeted.
And finally, I certainly
Wait a minute, I want to back you up on that. Now you're saying that they weren't being targeted because other groups were also being targeted for their political views. Is that what you're saying?
No, that's not what.
Well, that's interesting, because that's just what I heard.
Well, I'd love to explain it to you, Congressman.
Please.
My understanding at the time was complaints had come in about letters. I had conversations about, are these questions normal? Are these questions legitimate? Are these things we should be asking? At no time, to the best of my memory, was I ever given the impression that these were only being asked of conservative.
All right, you gobbled up most of my time. I just want to close with this. Okay, so after leading Congress to believe that there is absolutely no targeting going on, you learn later on that there's a list. There's a list of people being targeted. After telling Congress that absolutely no one is being targeted, you learn that there's a list of people being targeted. Tea Party, patriots, people who are critical of how the government is being run. And what did you do after that point? You did nothing. You did nothing to straighten out the impression that you had left by your testimony before Congress. Sir, you misled Congress. You misled Congress. Make no question about it. You told us one thing when you learned that our suspicions were true, when you learned that there was a list. You did nothing. You did nothing. You abdicated your responsibility, and you allowed Congress to proceed under your prior information that was false, that was untrue. And you never came back. You never notified Congress to say, sir, I gave you the wrong information. I misled you. You never came back to Congress to straighten out that impression. That's inexcusable. It really is. I yield back the balance of my time.
Thank you, gentlemen. First question, gentleman from Tennessee, Mr. Duncan, is recognized.
Thank you very much, Mr. Chairman. It was primarily conservative groups that were targeted, but people of all political persuasions are very upset about this. President Obama said on May 15th, he said it's inexcusable, and Americans are right to be angry about it, and I'm angry about it. I will not tolerate this kind of behavior in any agency, but especially in the IRS, given the power that it has and the reach that it has into all of our lives. And as I said earlier, it should not matter what political stripe you're from. The highest official of the ACLU here in this city said that even the appearance, quote, even the appearance of playing partisan politics with the tax code is about as constitutionally troubling as it gets. With the recent push to grant federal agencies broad new powers to mandate donor disclosure for advocacy groups on both the left and right, there must be clear checks in place to prevent this from ever happening again. Mr. George, will you promise to us or commit to us this time that you make it a high priority to make sure that something like this never happens again?
Sir, I make a commitment to you to do our level best to work with the Internal Revenue Service and others involved to help establish procedures to help identify and avoid this from occurring. I cannot, obviously, sir, control what happens within the approximately 100
All right, thank you.
IRS.
Mr. Shulman, on March 22nd, 2012, you testified that there was absolutely no targeting when asked this by Congressman Bustani at the Ways and Means hearing, and that's been covered several times already this morning. But there was an internal IRS review that was completed in early May, just a little over a month later. And you said that when you met with Mr. Miller, you were assured that this activity had stopped. Was that, and so you took no further action. Did you ever discuss this with anybody at the Department of Treasury, any Treasury official at all?
I had definitely had no substantive conversations with anyone at Treasury and did not report that that there was a list and that kind of things.
Mr. Walden, when you learned that this had gone on, who did you discuss this with at the Department?
Well, I learned the details, Congressman, when the report was made public a week or 10 days ago, and obviously the Department at that point, we discussed it with the Secretary and General Counsel and others to make sure that we began to put in place both the accountability with respect to people who are responsible for this misconduct, but also to make sure that we put in policies and procedures that would make sure this wouldn't happen again, not just the implementation of the recommendations that the IG included within its audit report, but also to charge, as the Secretary of the Treasury has done, the new acting Commissioner of IRS with a broader agenda to make sure that this was looked at carefully and to make sure he had a broader review to make sure that this didn't happen again.
Let me ask you this. Apparently one of these groups called the Coalition for Life was asked was asked by IRS officials about prayer meetings that they'd held and how much of their time was spent on prayer meetings and what went on at those prayer meetings. Do you think that questioning like that is proper?
No, Congressman. I think that the conduct that is outlined in the IG's report is obviously inexcusable, deplorable. I can't be more clear than that. It's absolutely outrageous.
Mr. Schulman, do you think that those types of questions should be asked in this situation?
Certainly sounds inappropriate to me.
About religious beliefs.
No, I don't. It sounds inappropriate to me.
Now, a few minutes ago, you said that there was another method. There's the 501c3, and then there's the 501c4, and you said that there are situations where people don't have to apply. What were you talking about there?
My best understanding is that none of these groups, of the 300 that are talked about, or 298 in the report, actually have to apply for 501c4 status. That a 501c4 can start operating, can hold itself out, can do all of its business, and then can file what's called a Form 990, which is the equivalent of a tax return for a tax-exempt organization. So I think that's an option that organizations have.
That's what I thought you meant, but I wanted to be clear on that. Thank you very much. I yield back.
Thank the gentleman for his questions. Now recognize the lady from the District of Columbia, Ms. Holmes-Norton.
Thank you very much. Mr. Chairman, even granted that the seed was planted for something bad to happen, when somehow the interpretation of a law was changed from exclusively to primarily, it's terrible. That's a terrible thing to put on civil servants. So they somehow have to take the clear words of statute that's now been changed in a way that I'm not sure how you're going to enforce that. But one thing is clear, that we see here something at least terrible incompetence, the absence of the normal kind of managerial oversight you'd expect in any federal agency, and certainly in the IRS. And I'm particularly troubled that the problems persisted for, it looks like, a year and a half, because of what seems to have been very little oversight for management at the headquarters. So, you know, civil servants are doing their incompetent best, I suppose. But I want to make sure that's what it was. I'd like to ask Mr. George, because I saw something of your testimony in the Senate where you testified that your audit did not uncover any evidence that the Treasury suggested the use of screening criteria or approved of the screening criteria that was used. Is that the case? Would you indicate whether you asked that question?
We did pose that question, Congresswoman, and again, the response was that there was no direction from the department itself to those in the determinations unit in Cincinnati, nor their affiliate office in Washington.
Well, I ask these questions because the incompetence and the terrible handling of this, which is shaken confidence in the IRS, is bad enough, but it would be far worse if there were any evidence that there was outside influence outside the IRS. And did you find any evidence that anyone in the White House in particular suggested that the IRS target conservative organizations, or that they played any role whatsoever in selecting the criteria?
No, Mrs. Congresswoman, but in all honesty, we didn't look at the White House. We didn't question anyone as to whether or not they'd received any direction from the White House. And
that specific question was not asked?
That's correct.
Now, in the investigation which continues, do you intend to ask that question?
And again, if I may, and again, this may seem like semantics, I want to be clear. At this stage, it is an audit still. And so...
well, it was an audit then, but you asked questions that...
Yes, yes, but again, and even there, it was an audit.
Well, I'm asking you in the continuing audit, do you intend to ask that question?
At this stage, I am not in a position to say whether or not, because as it's going to be continue, we will go as wherever the facts lead us, Mrs. Norton, or Ms. Norton, Congresswoman. So, but I have to say that. I'll just have to leave it at that. We'll go wherever the facts take us.
Well, let me suggest, Mr. George, that it would be appropriate to ask whether anyone outside of the IRS, without fingering any particular agency or any particular individual, anyone outside of the IRS, the record needs to be clear on that.
May I clarify my answer then? We did ask if anyone outside of the IRS.
And so you take that to imply the White House and anybody else we can think of.
At this stage, yes, we do.
I guess it's Mr. Warren I ought to ask, the Deputy Secretary. Did you yourself ever suggest, or did you yourself ever propose that IRS personnel use screening criteria of any kind to target conservative organizations?
Absolutely not, Congresswoman.
Or other organizations?
Absolutely not, Congresswoman.
Did you order, did you approve the inappropriate screening criteria used by the IRS personnel in Cincinnati, Ohio?
I did not, Congresswoman.
Well, Mr. Chairman, I very much think the committee is pursuing the appropriate investigation, and believe that before it is all over, if we get direct answers from all those involved, we will know what needs to be done next. And I do want to say, Mr. Chairman, that whatever we do, the difference between exclusively and primarily has to be clarified, so that I think there is proper direction from the Congress, so that the IRS can in turn give the proper direction. Thank you very much.
Thank you. Mr. Shulman, you've testified yesterday and today, and you said last spring you had a partial set of facts. You didn't have the full story, didn't fully understand what took place until you read the Inspector General's report. Is that accurate?
That sounds accurate.
All right. In the 2 years that this targeting was taking place, did any member of Congress contact you, excuse me, write you about this particular subject? Did you get any letters from Congress?
Yes.
All right. You know how many?
I do not.
We got some information from you all yesterday, a list of correspondence regarding 501c4s, and we counted them up. 132 different members of Congress contacted you over the appropriate time period. Did you read any of those letters?
The letters that I remember about this set of facts around...
No, did you read any of them?
The General started coming in February of 2012.
Well, this is from the IRS. We got 132 members of Congress contacted you about 501c4 status. You ever read newspaper articles about this issue and the time period that in question, Mr. Shulman?
To the best of my knowledge, yes.
You know how many news stories, hazard a guess, took place in the time period that we're focused on?
I wouldn't guess.
You have your staff, and we in our office, we have like a Google alert. If my name comes up, they find out what the press is saying about me, and they let me know. Do you have that when you were at the IRS? You have like a Google alert when stories about the IRS or Doug Shulman come up? Did they let you know about those stories?
IRS has press clippings that I saw on a regular basis when I was.
Would you hazard a guess about how many major news stories took place in this time period that is in question when the targeting was going on before you said you know?
No, I wouldn't.
42. We just did a quick search. 42 major news stories. So here's what everyone wants to know. You got 132 members of the United States Congress contacting you about this issue, 42 major news stories about this issue in the time period in question, and you never checked it out. You never researched it. I mean, are you sure you're being square with us today, Mr. Shulman?
I'm absolutely telling you the truth today.
Absolutely. Well, that's interesting because Mr. Lynch just cited your testimony from a year ago, and you used similar language. When in front of the Ways and Means Committee, can you give us assurances that the IRS is not targeting particular groups? Thanks for bringing this up because I think there's been a lot of press about this. There was, we found out, and a lot of moving information, so I appreciate the opportunity to clarify. First, let me start by saying, yes, I can give you assurances. I don't think you can say it any stronger. We pride ourselves on being a non-political, nonpartisan organization. And that's why people are wondering if you're being square with us today, because you said you could assure everyone, the American people in the Congress then, that nothing was going on. And the gentleman sitting beside you just issued a report last week that says what you told the Congress, what you told the American people a year ago, is absolutely wrong. And you're sure you're being square with us.
Excuse me?
You ever talk to anyone at the White House about this issue?
About this issue? Not that I remember.
You ever go to the White House? Time as commissioner, did you ever go to the White House for meetings?
Yeah, I had a number of occasions to go to the White House.
How many times did you go to the White House?
Many times around budget and policy matters of tax and other things like that.
Got a number? Any idea?
I don't have a number.
We just looked at the White House log. Now, we couldn't get 2012, but in 2010 and 2011, 118 times you were at the White House. I mean, that's a lot. I bet these Democrat members of Congress in this administration haven't been there close to that many times. 118 times you were at the White House, 132 members of Congress contact you about this information, 42 major news stories about this very subject, and you told Congress a year ago, I can give you assurances, nothing is going on. Everything's wonderful. We're not targeting conservative groups. I mean, that's why the American people are like, this is unbelievable. You sure you didn't talk to anyone at the White House about this issue, Mr. Shulman?
About singling out conservative groups for special scrutiny?
Well, that's what we're talking about, isn't it?
I'm absolutely sure I did not talk to anyone.
118 visits. It didn't come up in a casual conversation after 132 members of Congress contacted you about it. You sure you didn't bring it up with anybody at the White House?
Not to my memory, and it wouldn't be appropriate, and so I certainly believe I did not have any conversations.
Recognize the Mr. Lynch, I think, is, or excuse me, Mr. Conley is next up for questioning.
Thank you, Mr. Chairman. Mr. Shulman, you were appointed by President Bush when?
I was nominated in 2007, confirmed in 2008.
And you served until?
November 2012.
So you served both in the last year of the Bush administration and through the first term of the Obama administration, is that correct?
Correct.
There might be many reasons you would be at the White House. What would be some of the reasons you might be at the White House?
The Easter egg roll with my kids.
Well,
questions about the administrability of tax policy they were thinking of, our budget, us helping the Department of Education streamline application processes for financial aid.
I just want to be clear. You're very aware of the fact you're under oath today.
Yeah, very aware of that.
And your testimony, to be very clear, in response to Mr. Jordan's question, is that you've never had any conversation with respect to this subject, the subject of this hearing, with anybody at the White House, though you were at the White House 118 times. Is that?
Yeah, just so I'm clear, I have no memory. Would have been appropriate, would not have been appropriate to have a conversation with the White House, with anyone at the White House, about the subject of discriminating against conservative groups in any part of our operation.
Let me be real clear about that, because you answered a series of interrogatories from the ranking member, Mr. Cummings, a little earlier, and again, in listening to your answers, I want to be clear, no one from the Bush White House and no one from the Obama administration White House, ever called you and said, there's a little list of groups, or there's an umbrella of titles I want you to be particularly sensitive about if they apply for a nonprofit status?
No, nobody ever talked to me about
that. That never happened. Is that correct?
Right.
Thank you. Mr. George, I'm looking at your report, and I want to make sure I understand it. I mean, we're talking about this like it happened in a vacuum. Somebody, some sinister plot was hatched by normally kind of, colorless bureaucrats in Cincinnati to get somebody for their political beliefs. Now, was there a triggering event that flooded the IRS with new applications between 2010 and 2012?
We have had some difficulty, Congressman, getting a definitive answer as to exactly how this began, the genesis of this program.
Well, can I just help you a little bit? I'm looking at your own report, and what seems to be the triggering event is the Supreme Court ruling, Citizen United. The number of applications between 2009 and 2012 for 501c4, even though Mr. Shulman points out actually it's sort of redundant, but doubled to from 1751 to 3,357. That's in your report.
There's no question that that event, the ruling of the Supreme Court, came down.
Yeah. Did IRS resources expand? Did Congress rush to IRS's aid here, saying, well, since you're flooded with new responsibilities, here's some more resources to help you hire up or to train, because you cited bad training, so you could handle this volume of applications? Did that happen?
I would have to defer to Mr. Shulman.
Mr. Shulman?
Could you repeat the question?
Yes. Were you flooded with resources after Citizen United to deal with the volume that the inspector...
Were we given resources?
Yes.
No.
No. All right. Mr. George, again, I'm looking at your report, and it's a pie chart I want to make sure I understand. Here's the pie chart, and we're focused particularly on conservative groups. Of course, I think all of us feel, as Americans, irrespective of your political beliefs, nobody should be targeted, in the proper exercise of their right to express themselves politically. Now, you've got a pie chart with 298. Is that 298 cases you looked at?
That is correct.
Now, if I'm reading this right, 72 of those were Tea Party, had the name Tea Party in them. Is that right?
That is correct.
And 11 had 912. Is that right?
That is correct.
13 had Patriots. Correct?
Correct, sir.
But 202 are listed as other. Were those all conservative groups, or could some of them have been progressive groups?
We were unable to make that determination, sir, because in many instances the names were neutral in that you couldn't necessarily attribute it to one particular affiliation or another.
And I know I have very limited time left, but I know the Chair has been indulgent with my colleagues because this is so important, and all of us as Americans don't want the chilling effect of any government agency suppressing the expression of thought or the right of every American to express themselves politically, irrespective of those beliefs. To what do you attribute this, what seems to be kind of a rogue element in Cincinnati? It was told once to stop and ignored it or returned to this activity. Is it just a natural perversion in Cincinnati? Or I mean, what were they doing that they thought was proper, apparently?
It was, the conclusion that I can give you today, Congressman, is that it was a lack of oversight from management, both in Washington primarily, and the fact that they did not go back to ensure that the directions, the instructions that were given to the determinations unit within Cincinnati were being complied with. Once they found out that the initial inappropriate action had occurred, attempted to make corrective action, and did direct a corrective action, they failed to go back to ensure, to follow up, to make sure that those actions were being complied with. So it was mismanagement. It was a lack of fulfilling the responsibility that they have, sir.
Thank you very much, Mr. George, for your testimony, Mr. Shulman, and thank you, Mr. Chairman.
Thank you.
Mr. Shulman, real quick follow-up. The 118 times you're in the White House in 2010, 2011, who were you meeting with?
First of all, I'm not familiar with that.
Straight from the White House.
And I'm assuming that it counts when I go to OMB, which is the budget office for resources, et cetera.
No, it counts when you go to the White House. That's what it was. The times you've been at the White House, that's when it counts. So who'd you meet with?
I met with a variety of people.
Is there somebody main? What was the main subject you talked about? You talked about 118 different things, or was there just kind of some themes and focus?
The themes of things I would have talked to people at the White House about would have been our budget, would have been about tax policy, fiscal cliff, would have been about streamlining the FAFSA, the financial aid application, would have been when the tax for airport.
Did you talk about the implementation? Did you talk about the implementation of the Affordable Care Act?
Implementation of the Affordable Care Act would have been one of the themes, and there could have been more. I'm not prepared to give you an exhaustive.
Which one consumed the most of your time of those subjects you just listed?
Probably budget, general tax policy, and the Affordable Care Act.
So the Affordable Care Act was pretty important. You talked about it a lot.
The IRS has a major role in the money flows.
Exactly. And you started targeting the very groups who came into existence because they opposed what you were talking about in the White House, 118 different visits there. You started targeting them the very month that the Affordable Care Act became law. And yet you didn't have any conversations about the subject matter at hand today on those 118 visits, when many of those visits were about implementation of the Affordable Care Act, and the groups you were targeting were opposed to the Affordable Care Act. That's a question.
I'm sorry, what is the question?
You went to the White House 118 times. One of the key subjects you talked about was the implementation and enforcement of the Affordable Care Act. Going on in your administration, at the time you're as commissioner, targeting of groups who came into existence because they opposed the Affordable Care Act, and you never brought it up in any of those conversations and all those visits to the White House when this was a major topic of conversation.
No, I did not.
Okay.
That's all I wanted to know. As a nonpartisan, non-political person trying to implement the laws that were on the books. It would have been inappropriate, and nobody ever asked me, nor did I ever.
That would all be well and good, Mr. Shulman, but Mr. George issued a report that said just the opposite. That's the whole point. That's why we're here. And you said you could give assurances that it wasn't happening. Mr. George issued a report that said it was, and you were at the White House 118 times talking about the Affordable Care Act, and you never had any conversations about the targeting that was going on of groups who oppose the Affordable Care Act. And the American people are supposed to believe that. Gentleman from Utah.
Thank you, Chairman. Mr. Shulman, in your confirmation hearing on January 29th, 2008, you were asked by Senator Wyden. He said, what do you intend to do to make sure that the IRS on your watch is not used as a political tool? And your response, Mr. Shulman, was, that's a great question. I believe that is incredibly important that the IRS is seen as fair, is seen as a non-political, non-partisan, that really is a public service organization. I would be a public servant serving all American taxpayers and really the government, end quote. How would you, based on that standard, based on the answer you gave, what letter grade would you give yourself in your tenure and what you did there?
Look, I tried every day to be a good leader and public servant.
I'm asking you for a letter grade on your assessment of how you did there.
There was clearly a breakdown in our terminations process.
I know what you know letter grades are. You don't.
I'm not going to grade myself.
How these 118 visits to the White House, did you ever have a discussion about the 501c4s?
First of all, this is the first I've had an accounting of this 118.
Did you ever go to the White House?
I just don't accept the premise that there were 118 visits to the White House may or may not be true. So let me just stipulate for the record broadly if there's more questions about that.
Did you ever talk about 501c4s at the White House?
About our either determination process or
anything about 501c4s. Did you ever talk about the Citizens United case?
Not that I remember.
You never had a discussion?
Not that I remember.
No discussion about 501c4s?
Not that I remember.
It was a major thing. It is a big deal. You never had one conversation?
Not that I remember.
You said you first heard about this problem in spring of 2012, correct?
I heard that I first heard about the BOLO list in spring 2012.
When did you first hear that there was a concern about the targeting of based on political beliefs and political speech? When did you first hear that?
To the best of my recollection, it was in the February-March time frame of 2012.
Okay,
and then there were also...
No, you can't. On June 3rd, 2011, the chairman of the Ways and Means Committee, Dave Camp, sent you a letter. June of 2011, second paragraph. Now, without no warning, the IRS appears to have selectively targeted certain taxpayers who are engaged in political speech. And he goes on. How is it that he, the chairman of Ways and Means, sends you, the head of the IRS, a letter like this, and you say you know nothing about it?
So that's where I was going to go. This is a very separate matter.
No, you weren't.
This is a very separate matter. That's a gift tax matter that I'm aware of.
This is exactly about political speech, and it continues to go on. Then you hear from Charles Bustani, who sends a letter on October 6th requesting information about the tax-exempt sector. How is it that it takes you so long and you say you don't know this? And Mr. Wolin, you said you took immediate action. What happens with all of these letters? Mr. Shulman, when you get a letter from a member of Congress, who else is copied on that? Who else do you give it to? You're not the only one that sees this letter.
Who do I give it to? Letters usually, as far as I know the process, go into our Congressional Affairs Office. They get farmed out to the appropriate staff who are subject matter experts to try to get the best answer. And
does Mr. Wolin get copied on these?
Not that I'm aware of.
Does anybody at the Treasury Department get these outside the IRS?
I really don't know.
Does anybody get these letters at the White House?
At the White House?
At the White House.
Not that I'm aware of.
So when you get a letter from the chairman of the Ways and Means Committee, or the chairman of this committee, chairman of any, you're telling me that you have no idea where it goes and what happens to it.
To the best of my knowledge, it goes into our Congressional Affairs shop. Someone in the organization answers it.
And who do they...
comes up to, if it's for my signature, the return, that would come up to me for review most of the time. Let me also just note, of all the letters people are talking about, there's a lot of individual constituent mail that comes into the IRS.
You get a lot of mail.
Much of which I don't see.
But do you see all the letters from members of Congress?
To the best of my knowledge, I do, the ones to me.
So you got 132 members of Congress. The House
let me actually repeat, if it's something that someone else is going to take care of, I might not have seen it. But the ones you're referring to, Mr. Bustani's, Mr. Camp's.
Mr. Hatch, the 12 senators, did you see that letter?
Yes.
When he says this was a lie by omission, how do you respond to that?
My belief is that, well, first of all, the letter in question was not under my signature. And second
He's made a fairly serious I want to know what you think of this idea of lie by omission.
I disagree with it.
And that will have to conclude. We now go to the gentlelady from California, Ms. Spear.
Mr. Chairman, thank you. Mr. Shulman, you have been the head of the IRS for over 5 years. You're in charge of the Internal Revenue Service, correct?
I was head of the IRS for 4 years and about 8 months.
All right, 4 years and 8 months. You get 132 letters from members of Congress concerned about targeting, and you send them to Ledge Affairs to deal with. Did you feel any responsibility to go to the Cincinnati office and find out for yourself what was going on? Did you ever make a visit to the Cincinnati office?
I guess I don't accept the premise that I got 132 letters about targeting. I certainly wasn't aware of that number till now. I knew about 2 questions.
Well, regardless, when Congress contacts you, whether it's 12 senators or members of this committee, I mean, doesn't it alert you to the fact that, you know, maybe if there's smoke, maybe there's fire? So did you ever visit the Cincinnati office?
I visited early in my tenure the Cincinnati office, which has many different operations, but I don't believe I went to Cincinnati during this 2012 time
frame. You take responsibility responsibility for what happened in the Cincinnati office?
Do I take responsibility for the list?
Yes.
Being done? You know, I don't take personal responsibility for there being a list with criteria put on it, but I do accept the fact that this did happen on my watch.
So you don't take responsibility, but you recognize the fact that it happened under your watch?
Look, I recognize that this happened on my watch, and I'm very sorry that this happened while I was at the Internal Revenue Service.
You know, one of the problems we have here is people are unwilling to take responsibility for actions that happen under their command. And you had a duty, as far as I'm concerned, to find out what was going on in the Cincinnati office when members of Congress, 132 of them or 50 of them or 10 of them, inform you that they think that there's some kind of targeting going on. And if that doesn't elevate your concern and interest, then something's fundamentally wrong between the way Congress interacts with the administration and the bureaucracy. Now, Mr. George, the law is that a 501c4 must operate exclusively for the social welfare. That's what the law says, correct?
That is my, yes, that's correct.
Exclusively for social welfare purposes.
Yes.
And somewhere along the line, the IRS came out with a regulation that reduced it to primarily. Is that correct?
That's my understanding.
So does the regulation trump the statute?
Well, I'm not here to give legal advice. That is, as an attorney, that is my understanding, that a regulation does not trump a statute, but a regulation can be used to elaborate on the intent of the statute.
So if we just look at those two words, exclusively and primarily, there's a dramatic difference, correct?
Yes, in my view.
And if regulation can't trump statute, then everything that's been going on here relative to authorizing 501c4s, if they're not exclusively being used for social service purposes, is violative of the law, correct?
I would say yes, but we have to keep in mind there may have been court interpretations that between the passage of the legislation and the implementation of the passage of the statute and the implementation of the regulation. So, and I don't have the history of that.
In your review of this situation, have you identified in Cincinnati the individuals who have developed this BOLO list?
We have not yet, ma'am.
And why not?
We have had some difficulty in terms of getting clarity from some of the IRS employees we've interviewed. Keep in mind, this is an audit. The people we have been interacting with were not under oath. And so if this matter develops further and changes its character, that might change the willingness of people to be more forthcoming with the information.
Now, the committee yesterday interviewed Holly Pass, who's the manager of the Ruling and Agreement Office in the Washington, D.C. And for at least part of the time period in question, she oversaw approximately 300 employees in the Cincinnati unit that determines whether organizations qualify for tax-exempt status. She said that she was the first person in Washington office to learn about the use of inappropriate criteria in June of 2011. Do you agree with that? Is that consistent with your report?
I have no information on that, but if you'll, I beg your indulgence for 1 minute.
The gentlelady's time has expired, but you can continue to answer.
We do not have any information on that, Congresswoman.
I yield back.
I thank the gentlelady. We now go to the gentleman from Michigan, Mr. Walberg. Would you give me just 2 seconds of yielding? 2 seconds? I certainly would. The gentlelady, my colleague from California, the Center for American Progress and Organize for American Action and others are 501c4s. This is not new. President Obama uses a 501c4.
Will the gentleman yield?
It's the gentleman's time. I will yield briefly.
Thank you. Mr. Chairman, regardless of whether it's a Democratic, a progressive, a conservative, or Republican organization, laws we have should be enforced. and a statute was trumped by a regulation. We should all be concerned about that. I yield back.
And if I can clarify for all of us, this change in 1959, there's a whole lot of water over the dam since 1959. And I think that it's important today to realize that without congressional action, trumping a 1959 by the IRS would be legislating without a doubt. And I think the IG, in including it in his audit, told all of us essentially that the Ways and Means Committee has, in fact, a challenge to deal with, which is, do we really want it the way it is as it has evolved in use? But ultimately, the decision since 1959 has caused organizations that perhaps all of us have grown to like. The 501c3s, like the American Lung Association, endorses legislative initiatives, as you know, in California. They promote initiatives and so on. They do it as a minority of what they do. So I think one of the challenges for this committee, and I would only ask us all to think about in this term, is Ways and Means has authority to change the law or to essentially trump a regulation. In our case, we have primary responsibility to ask questions like, should the IG have known sooner and we've been reported? Should Mr. Schulman have been a better manager than he was? And if so, how do we ensure in the future that Mr. Wolin, for example, would in fact have known with specificity sooner? I think that's our lane, and I only would say that as chair because our lane is not unlimited. The jurisdiction of the Ways and Means as to laws governing the IRS does not belong in this committee. And I know all of us on this committee are very proud that we do a lot of work. The one thing we don't do is we don't pass tax law. Although we all have opinions on it, let me assure you. The gentleman is recognized.
Thank you, Mr. Chairman, and I'd ask unanimous consent to have my full 5 minutes restored. I mean, it's been interesting listening to the accounts here of 118 visits to the White House by Mr. Schulman. No talk about this specific issue. No talk about related issues during those 118 visits. 132 letters coming from members of Congress, 42 articles in newspapers, and frankly, we just had the opportunity now of having the press really get engaged with it, but 42 over that course of time. I also look at a train of events. September 2010, Senate Finance Committee Chairman Baucus wrote a letter to the IRS asking the IRS to survey tax-exempt organizations to ensure that political campaign activity is not the organization's primary activity. October 2010, Senator Durbin wrote to the IRS to review the purposes and activities of several tax-exempt organizations. February 2012, Senators Bennett, Franken, Merkley, Schumer, Shaheen, Udall, and Whitehouse wrote to the IRS about the issue. 32 Democrats in March of 2012, House Democrats, wrote to the IRS and the White House to ask that political activity of tax-exempt organizations be investigated. July and August of 2012, Senator Levin sent letters to the IRS and said that the IRS appears to be passively standing by while organizations clearly ignore the tax code with no apparent consequences. Now, this to me seems like a significant amount of requests for information and concerns that private citizens, organizations seeking tax-exempt status who happen to be of the conservative side would be checked on and questioned. Now, I find it difficult, Mr. Wolin, to understand how that didn't come across your train of reference and responsibility early on. Did you ever discuss congressional interest in the way the IRS was handling political nonprofits with the President?
I did not, Congressman, never.
Did you ever discuss it with anyone at the White House or any agency outside the IRS?
I did not, Congressman.
Why didn't you discuss this when you knew it was of such interest to Congress and you knew Congress was apparently not satisfied with whatever actions the agency had taken thus far on either side of the issue?
Frankly, Congressman, the correspondence to which you referred did not come to me. I think it was in general, as you suggested, addressed to the IRS, and I frankly was unaware of this, the concern until...
But Treasury has intense responsibility and ought to have intense scrutiny over the IRS, correct?
Congressman, I think it's important for me to reiterate that with respect to the details of tax administration and tax enforcement, it's been a long-standing practice of Treasury Departments spanning administrations of Republican and Democratic presidents not to get involved in those details, specifically because we don't want to have political influence over those kinds of detailed activities with respect to tax administration. I think this is a hearing and a subject matter that makes clear why that's not a good idea.
Not a good idea. Mr. Shulman, when did you learn about the second BOLO again and the failure of employees to follow explicit directions from their superiors?
About the fact that there was a BOLO and then a second BOLO and that employees hadn't followed directions?
Yes.
That I didn't learn about until, this last week when the report came out.
Wow. Were you involved in any discussions about disciplining people who were being insubordinate in the Cincinnati office?
Not that I remember.
In Politico today, I see this headline here: heads won't roll at the IRS. Heads won't roll at the IRS. Labor rules give workers protection. The amount of ineptitude, and it's assuming that a Fifth Amendment was requested by Ms. Lerner, who's not here, we have to assume that there's some concern about criminality as well. What does it take for someone to get disciplined at the IRS?
There's, at the IRS, there's, procedures that people follow, that, workers have.
And people don't follow, I would guess.
And there's a union, so it depends if it's somebody in the union or not. The best of my knowledge, it's the kinds of procedures you would think about in any organization.
Well, specifically, while you were commissioner,
go over it.
I only have 4 seconds. While you were commissioner, for what reasons did you discipline some individuals at the IRS while you were commissioner?
Inappropriate conduct, not doing their job, those kinds of things.
Wow. And we missed all of this. I yield back.
I thank the gentleman. We now go to the gentleman from Pennsylvania, Mr. Cartwright.
Thank you, Mr. Chairman. Gentlemen, I want to say I am deeply troubled, and I know I speak for the entire panel. We are all deeply troubled by what has happened at the IRS, and perhaps the most troubling part is that the IRS has been revealed to have targeted groups for their political beliefs, their political leanings. It's an outrage if this is true, and I want to drill down a little bit with you, Mr. George. You're the Inspector General. Last week, you testified in front of the House Ways and Means Committee to the effect that from your looking into this matter, whether you call it an audit or an investigation, from your looking into this matter, you saw no evidence that IRS employees were politically motivated in their creation or use of the inappropriate screening criteria. Was that essentially your testimony?
That we received no evidence during the course of our audit to that effect, yes, sir.
All right, so that doesn't really square with the headline that the groups were targeted by the IRS for their political beliefs and political leanings, and I want to ask you, I mean, isn't it true? People do things for a reason. If people at the IRS came up with improper ways of going about their business, improperly triaged groups with political-sounding names to the top of the list for extra scrutiny, if they did those things and it wasn't for political reasons, why did they do it?
Congressman, there are reasons for the IRS to issue be on the lookout types of directives, and without violating any, I don't want to say secrets, but without giving the bad guys a way of avoiding detection. I will point out that in the case of terroristic activities, both domestic and international, there may be a reason for the IRS to be on the lookout for a particular type of application or something of the like.
Well, one thing that Mr. Connolly mentioned earlier this morning was the doubling of the applications that we saw after the Supreme Court's decision in January of 2010 in Citizens United, and that's true. Is that correct?
It is correct, but I want to make sure that I'm clear about that. Our audit did not say this was as a direct result of that. It was coincidental.
And you're anticipating my next question. Whether or not we know there was a direct relation, we don't want to engage in post hoc, propter hoc reasoning, but whether or not we know what the cause was, we know that the applications doubled starting in 2010, right?
That's my understanding.
So we've got the workload doubling. We've also established that there were no additional resources given to the IRS to do this work. Is one of the possible explanations that the staffers who were not acting for political reasons were actually acting to streamline their own work and try to get through a twice as high pile of work in a streamlined fashion so that they could actually get the work done?
Congressman, there are certainly valid reasons for the Internal Revenue Service to try to become more efficient in the way they identify these types of cases. However, it is entirely inappropriate for them to use certain categories in which to accomplish that.
Exactly. Now, one thing I want to ask you is I think you've testified that you haven't really zeroed in on individuals because you've done an audit, not an investigation. Is that right?
That is correct, sir.
Why, Mr. George? In your testimony, you've said that you were asked by several members of Congress to do an investigation. Why have you not done one so far?
Many of our activities, sir, are covered by Privacy Act rules, and again, in some instances, during the course of an audit, if an investigation were initiated, the audit would have to cease because of conflicts and a variety of other rules.
So you do an audit first, finish that, and move to an investigation. I hope you will do that, and I want to finish with this question. Did the IRS's improper prioritizing of certain groups for extra scrutiny, did that lead to any actual incorrect determinations of the tax-exempt eligibility of any groups? And I'll open that up to all three of you gentlemen. Do any of you know, did this improper conduct lead to improper decisions?
I will say that this action led to the fact that not a single application for this status, this tax-exempt status, was denied. They were delayed for years at times, but not a single one of the ones that we examined were denied. So it does raise questions in that regard.
Mr. Shulman? Not that I'm aware of, but I defer to the Inspector General who's done the review.
Mr. Wolin?
I have no knowledge of this, Congressman. I too defer to the Inspector General who has looked at this.
Thank you, and I yield back.
Thank you. Just to clarify what the gentleman was asking, none were denied, but by definition, not granting them is in fact not allowing them to happen. So you can actually deny better by not denying, because if you deny, they have a right of appeal. If you just let them sit in limbo, they're screwed, and some are still screwed today. Isn't that correct?
That's
a term of art.
Yeah, I was going to say, I wouldn't use necessarily.
But if you were a Tea Party organization, you'd use that term.
I would be very frustrated.
Right. Two quick things to clarify, because the gentleman made a very good point. This doubling, isn't it true that they began targeting Tea Party before there was any doubling, that your own testimony shows between 2009 and 2010 there was not a marked increase, and they began targeting with just one Tea Party application and then expanded it?
They did, yes, sir.
Thank you. I think that makes it clear. Oh, one more thing. There were 479 or so of these Tea Party groups that were targeted in total. Were there any BOLOs issued for progressive groups, liberal groups? Because I'm assuming that your investigation, we can't see them, but your investigation showed liberal groups that flew right through during the same time and got their 501c4s. They were not stopped. Isn't that correct?
Sir, this is a very important question. Please, I beg your indulgence.
Of course.
The only be on the lookout that is BOLO used to refer cases for political review were the ones that we described within our report. There were other BOLOs used for other purposes. For example, there were lookouts for indicators of known fraud schemes, so they could be referred to the group that handles those issues. For nationwide organizations, there were notes to refer state and local chapters to the same reviewers, rather. As we continue our review of this matter, we have recently identified some other BOLOs that raise concerns about political factors. I can't get into more detail at this time as to the information that is there because it's still incomplete, that we've uncovered rather, because it's still incomplete. And there are 6103 issues involved here too.
So clearly it's fair to say, though, that there was a BOLO for Tea Party, but not a BOLO for Move On or Progressive.
I'm not in a position to give you a definitive response on that question at this time, Mr. Issa. Mr. Chairman.
So are you saying today that there were other 501c4s, not specific, so much as one other 501c4 not previously identified during your IG audit that were in fact targeted and held in a similar way?
I cannot give you a definitive answer, sir, at this time, but I certainly will.
I only ask if there's at least one. Are you aware of at least one that was targeted using a BOLO that was a 501c4 in which they were targeted politically but did not fall into this current report we have before us? I'm not asking for privileged information. I'm asking for one.
For the review, the purposes of the audit that we conducted, which was to determine whether they were looked for in the context of political campaign intervention, there were no others.
Thank you. As I recognize the gentleman from Oklahoma, I want to express my deep condolences for the losses. I realize you flew through the night to come back and that you'll be leaving as soon as votes conclude. But again, I think all of us on the dais would offer our heartfelt condolences.
Thank you, Mr. Chairman. Tough day for the folks in Oklahoma. Very tough time for a long time. Mr. George, I want to clarify several things. One of them, you made the comment that so far none of them have been turned down. They just have this inordinately large amount of paperwork and additional questions applied to them, and it's a long delay with no response, and it's basically we'll get back to you at some point. Is that correct?
That is correct, sir.
Man, that sounds like the Keystone Pipeline to me. But that's a whole different issue. You had mentioned under your audit, people under investigation are not under oath, or not under investigation or audit, are not under oath, and that the IRS staff has not been forthcoming on some of the things. Is that the statement that you used?
That's the inference.
Is that both staff and management that you've had conversations with, or has staff and management been in that conversation and you feel like they've not been completely forthcoming on all the questions you've asked?
Is it, I'm sorry, your question is because management?
No, staff and management, both. You say IRS personnel have not been completely forthcoming on some of the issues you've asked about.
That is an inference that can be made from the fact that we have not gotten clear answers.
So that's what I'm trying to ask is staff, management, so two different levels of individuals, you're not getting completely full answers that you expect when you ask them.
While I am not in those interviews personally, sir, that is my understanding.
Okay. Mr. Woolen, did you ever ask anyone at the IRS, because you had to hear about all these reports as well, that possibly political activity was happening within the IRS. It's been mentioned before already, 42 different major news stories were out there that there was potential targeting. Did you have a conversation with anyone, anywhere in the IRS where you asked the question, is this true or is this happening sometime after May the 3rd, 2012?
I did not, Congressman. Again, with respect to the details of how the IRS administers the tax code, especially—
No, I understand. I'm just asking, did you have that conversation where you asked someone, is this true, is this happening? Because there were a lot of media reports before this came out.
I didn't. First, I was aware of this, Congressman, when the Inspector General came to me at some point in 2012 and said, on the basis of some congressional inquiries, he was going to begin an audit, and that was the first I had learned of it.
Okay, so you didn't see any of the media reports over the group that you oversee?
I did not,
okay.
that I recall.
Wow. Someone in my office, before a letter goes out, there are 4 different people, including myself, that go through that letter. as it goes through the process of edits and review and fact checks and all those things. I assume it's very similar in your office as well, that you're not actually penning every letter. There are multiple people that are involved in the process on it. I'm one of many that wrote a letter in 2012 to your office and received a response back from Steve Miller. In that response that I got back from Steve Miller about this exact issue, he said in those cases where the application raises issues for which there's no established published precedent, I assume that's the Tea Party groups and everything else, or no uniformity, EO determinations may refer the application to EO technical. EO technical, the applications are reviewed by tax law specialists whose job it is to interpret and provide guidance on the law and work closely with IRS chief counsel attorneys on the issues. That's a lot of folks when there's new ground to be broken. Now, for my district, this is one of those letters that came in from someone in my district that specifically contacted me and had a whole series of questions that came back to them with what is in my area the Oklahoma City Patriots in Action Group. They were asked questions such as, have any candidates running for public office spoken, or will they speak at your function or organization? If so, include a transcript of any speeches given by candidates, which is remarkable to be able to ask. Do you directly or indirectly communicate with members of legislative bodies? And there's no definition for what indirect communication is given on that. It's just, have you had, I don't even know what that would mean. My favorite question, who developed the website and has control over the data generated by the website? Not only is that an insane question to ask, it's not even grammatically correct. 19A, provide all copies of your corporate minutes from inception to the present. This was asked, and at the beginning of the first page it says, under penalty of perjury, I declare that I've examined this information, and goes through in this long statement. My issue is this is new ground. And based on the letter that we received when I wrote the letter to you, it lists a long list of people that have to be involved in the formation of this. How do we get the list of individuals that were involved, or at least the process of how these questions were done? Because this assumption that this is a couple of rogue agents does not match up with the letter and how we were told this was actually created. This includes technical folks, attorneys, chief counsel, EO. This is a pretty large list of people that are involved in creating this. Someone knew, in fact, a lot of someone's knew about this, because you can't form this without this. How do we get that information? Ms. Lerner is obviously the best person to ask. She's chosen not to answer questions. How do we get that?
Look, as you said, there's probably other people who work on the details of that. You could ask, I would presume you ask it directly. I'd presume that the IG, who now has a better understanding of this, would be able to be helpful, and I would presume that the committee investigative staff will take letters like that in your questions and ask, who was involved.
If I can have the luxury here, Mr. George, is there any way to know about how many people? Has that been a part of your audit to try to determine how many people went into creating this and how many different offices? Because this lists at least 3 different offices and multiple groups of people that were referenced just in their response to me in creating one of these surveys.
My understanding is we have not make that determination, sir.
Wow. That might be something we need to know.
We will take that under advisement.
I yield back.
I thank you. The gentleman from Wisconsin, Mr. Buchanan.
Yeah, thank you, Mr. Chair. And in Wisconsin, we try to find silver linings. And in this one, Mr. Chairman,
if you find that you can find a sunny day in a snowstorm.
Well, I found a small one. The inept and excusable actions of the IRS have done more to unify Democrats and Republicans than I've seen in my 5 months here so far. So that's what I'm going with. I'm going to try to work off of that.
I'd use it until we lose it, and hopefully we won't.
Exactly. Let me drill down a little bit in a different area, because I think a lot's been talked about, really the ineptitude of what had happened. But specifically, Mr. George, one of your recommendations I think that stands out the most is the better guidance to determine whether organizations are properly qualifying for the tax-exempt status 501c4. Not related to the groups that have, but to the future, the fact that since the 2 years previous to Citizens United, there's a pretty even number of applications, and now in the last year that's more than doubled. So we're clearly seeing more activity in this area. If we really want to make sure, not through this sad way that was done through the IRS to try to find this out, but some other way. You, in your report, say that we need the acting commissioner for the tax-exempt government entities division to work with the IRS Chief Counsel and Department of Treasury to improve guidance to help determine the primary activity of social welfare organizations. That's correct?
That is correct, sir.
Okay. And to be clear, if a group's primary activity is political, they do not qualify for the 501c4, correct?
Again, as long as they pass that test of, not being that primary activity.
All right. And the IRS does, in your opinion, from the report, does not have adequate guidance so its employees can figure out this question. Was that your point?
That is definitely my point, sir. Yes.
Okay. Mr. Shulman, you're no longer there, so I'm not going to ask you this question, but I am going to pivot to Mr. Wallen. The Treasury oversees implementing regulations for the tax code passed by Congress. And in this specific area, do you expect the Treasury to come out with some guidelines measuring the primary activity of 501c4 organizations so we can actually have some clear and concrete guidance for IRS employees?
Congressman, the existing guidance, as you know, is very old, is a very complicated area, but as the IG report recommends, as this matter makes clear, we need to have some new guidance in this area. That's what the IG has recommended. We have adopted all of his recommendations. So we will work with the new acting commissioner, Mr. Werfel, to see what additional guidance we can provide so that we can bring better clarity to this area and help avoid the kinds of things that we've just learned were happening.
Do you have a timeline on that?
Well, I think we're going to get to our work as soon as possible, but I don't have a specific timeline for you, Congressman, other than to say that the Secretary has charged the new acting commissioner with a report in 30 days that includes, among other things, how we're progressing with respect to the implementation of the various recommendations that Mr. George has put forward and that we have accepted.
I just think this is probably one of the areas, we can look at the problems that occurred and they were significant, and as you can see, there's complete unanimity in the room here looking at this saying this was inept and inexcusable. But I think the next step is how do we make sure, because of Citizens United, the growth of these applications, that we have a fair and level process to work off of. So as soon as you can do that, that would be much respected. And then finally, Mr. Chairman, I would just close in saying, I think this has been really great to have this in the open so everyone can see this, and it's been a very good hearing. I would hope that you would still consider tomorrow perhaps opening the Thomas Pickering hearing so that we could try to indeed have, as I think he's requested, a chance to do that.
Will the gentleman yield? The gentleman from Wisconsin yield? Would my colleague yield?
Sure. Boy, you've got so much yielding to do, I may have to give you more time.
Would the gentleman yield? I thank my colleague. Mr. George, in response to Mr. Cartwright, you said something I don't think you're competent to say, and that is, when looking at your own report that showed the doubling of applications for 501c4s, you said, well, that's just coincidental to Citizens United. You don't know that. We don't know if it's causal or coincidental based on your analysis. I want to give you an opportunity to acknowledge that.
I agree with your statement, but my point was that we did not indicate in our report that because of Citizens United there was a doubling.
I understand. And is it not also true that a 501c4, one benefit of that versus a 501c3 is the donors don't have to be revealed? Is that correct?
That is my understanding, sir.
Thank you, Mr. George.
Gentleman,
and I thank my colleague.
Gentlemen, last 15 seconds. You can have the last 10 seconds.
Mr. Woolen, yesterday Mr. Lieu said senior aides at the White House, the Treasury Department, and the IRS debated the best way to break this news. When Ms. Lerner gave the speech and you had the planted question how you were going to spin this, how you were going to bring this forward, were you involved in those discussions on how this story was going to break to the American people?
No, I was not involved in
those. So you weren't one of the people at Treasury involved, even though it's your responsibility to oversee the IRS?
Congressman, there were, and I think there's been press reporting on this, conversations among folks in the Chief of Staff's office and among lawyers about these questions, and I was not directly involved in those conversations, no.
Who at Treasury was?
Well, I think, again, we'll work with you to get the names, Congressman, but it were people in the Chief of Staff's office.
You know how the name Celia Rhodey, she was the person who planted the question. You know how she was chosen? And why she was chosen?
Congressman, I had no involvement, no knowledge of that until we learned about it probably together when there was testimony from Mr. Miller on that question. I have no knowledge of that.
Thank you. I just
Mr. George, following up on Mr. Pocan, just one quick thing. I had our staff check, and Citizens United was decided and announced on 21 January 2010, and the IRS began targeting Tea Party groups in March of 2010. Isn't that correct?
I'm not sure of the date of the...
Well, the first file pulled, according to Ms. Paz, would have been that less than 2 months later.
No, I'm not sure of the date of the issuance of the Supreme Court.
Oh, no, we can all get that at Google.
Right.
That's a fact online. But essentially, if there's a coincidence, the IRS began targeting in less than 60 days Tea Party groups after Citizens United was started. I would assume that it's awful hard to have this supposed exponential increase in applications in less than 60 days, especially since they had gathered starting with application 1. Isn't that essentially, without exceeding what Mr. Connolly would agree to, if there's a coincidence, isn't that the coincidence that it happened so close to the deciding of a Supreme Court case, not to the increase in applications?
It does seem coincidental, sir.
Thank you. With that, we go to the gentleman from Arizona, Mr. Gosar.
Thank you, Mr. Chairman. Mr. Shulman, are you familiar with any examples in which confidential information relating to the application for tax-exempt status of groups was leaked to any entity outside of the IRS?
I'm familiar with some press reports and have vague recollection of things happening.
So we're going to pick up one in just particular. Media reports asserts that Austin Goolsbee, then the President's Chairman of the Council of Economic Advisor, disclosed confidential tax information about Koch Industries to reporters on August 27, 2010. Do you have any idea how Mr. Goolsbee obtained that information?
Two things. One is, if I remember from the time, it wasn't confirmed that he had confidential information, and to the extent he did, if that's your premise, I have no idea.
The whole thing is that it should have alerted you, because that's something very, very important. It kind of hit the screen and it's a pretty big deal. So did you ask your staff at the IRS how this happened, and did you find out if anyone at the IRS provided Mr. Goolsbee with that information? Because it caused you, I just saw you with your caution, it caused you to think about it, and somebody in your nature should have gone back and asked. Did you ask anybody, yes or no, in the IRS to look into that, how you got that information?
It was several years ago, but my best memory is, and I have a recollection that the Inspector General was actually did an investigation to see if something had happened. But that's my best memory.
At that time?
It's very vague.
Is that true, Mr. George? I didn't think you were at that time investigating.
Congressman, this is one of the most frustrating aspects of implementing or overseeing the Internal Revenue Service, and those are some of the restrictions that the tax code places on me and my ability to communicate information to people outside of the Ways and Means Committee.
Okay.
The IRS has strict confidentiality rules, which we actually enforce, and which I'm not allowed to provide.
I appreciate that. I want to keep going here. So Mr. Shulman, how would that information be obtained? I mean, from your understanding of the IRS, you're the head here guy. How would that be obtained? It had to come from a leak, right?
It shouldn't be obtained. Section 6103 prohibits IRS employees from disclosing specific taxpayers.
You gave me my answer. So, Mr. Shulman, 6 months after Mr. Goolsbee made that public information, you went to the White House and met with him according to the White House records on February 3rd, 2011. Did you ask Mr. Goolsbee then or at any other time how he obtained that information?
Not to my recollection.
Why not?
Because there's lots of things that happen in the press that involve the IRS. I don't remember that meeting, but I
But my understanding is this is a very important piece, particularly as a director, that you should have looked at. Because, by the way, sir, did you take an oath of office?
I did take an oath of office.
Okay. Let's keep going. Are you familiar with the news organization's pro-Politica's publication of pending tax-exempt applications from conservative-leaning organizations?
I'm sorry, could you repeat the question?
Are you familiar with those publications? The news?
ProPublica?
Yes.
I'm familiar with the organization
Okay.
ProPublica.
It is my understanding, based on reports from that publication, that your office provided that publication with the applications that were still pending, which were confidential. Is that your understanding?
That my office, I saw news reports of issues around ProPublica that I remember, and I don't remember the time stamp. And again, my best recollection is when those news reports broke, that it was referred to the IG to look at.
So what contributed to the confidential pending applications making it through the internal review process and being provided to the publication?
I
mean,
I don't have any knowledge of the premise that it happened. I saw news reports.
Well, but it should have alerted you because, I mean, as a head person with these big things happening, you should have followed up. Beauty's in the detail. I've watched you all day. You're really good at certain parts of detail, and then you obscure the rest. I mean, there's a disease going in America. You know, I see it in trials all over the country. You know, we feign because somebody gets in our face that we don't acknowledge something. I want to go further. Are you aware that in July 2012, Senator Harry Reid claimed Mitt Romney hadn't paid taxes for the last 10 years and claimed to have the information supporting that? Are you aware of that? I'm sure you are.
I have a recollection of reading that in the paper.
Do you know how Mr. Reid obtained that information? Did you look into this?
I have no idea. How
Doesn't that alarm you that all of a sudden this pertinent information comes up, you're the head of this agency, and you're not asking questions? Shame on you. Absolutely shame on you. Did you ask for any other leaks of any other information, confidential information on anybody else? I mean, I just now illustrated you 3 different incidences for private information, and yet you did nothing. So did you, let me ask you again.
If the gentleman would conclude his questioning.
Yes. Did you faithfully take this oath, and I want to highlight it, that I will bear true faith and allegiance to the same, and that I will well and faithfully discharge the duties of the office in which I'm about to enter? Did you take that oath?
I took the oath of office.
Thank you. The gentleman has concluded. Mr. Woolen, do you want to answer the same set of questions? I think they were directed to Mr. Schulman as a former agency head, but you were his superior and still would be the superior to each of those questions. Were you involved? Did you investigate? Did you have concern particularly for sensitive IRS information?
I would say a couple things, Mr. Chairman. One, I was not involved in any of those things. I remember reading news accounts of the ProPublica when it happened. I want to be sensitive, as the Inspector General has sort of instructed us, to 6103 issues. But the only thing I learned about one of those issues was from the Inspector General, who said he was looking into it. And of course, I did as I always do. I said follow the facts where they may lead, and otherwise stay out of the matter.
Mr. George. Mr. Chairman, we at TIC do have exclusive jurisdiction to review these types of allegations. And again,
But you had no authority to go to the White House, go to here on the Hill, or go anywhere else for that investigation. You're extremely limited. You can't, as I understand, you can't leave Treasury in your investigations.
No, that is not true. We do have the authority to go beyond Treasury, including the White House.
Okay, thank you.
Mr. Chairman.
Of course, Mr. Cummings.
Just further clarification. Is it, some agencies, if they read something in the newspaper, matter of fact, members of Congress, I mean, we can be subjected to an ethics investigation just by somebody reading something in the paper or hearing about it. How does that work there with the IRS? Some mention was made of Senator Reid and others. How does it work there? Maybe you can answer, Mr. So that we can all be clear. And so, you know.
Go ahead, briefly. I can assure you, TICTA has exclusive jurisdiction to investigate unauthorized disclosures of return information, tax return information. Now, these provisions prevent me from discussing in any detail other than with the Chairman of the Ways and Means Committee and the Chairman of the Senate Finance Committee. I can't even discuss these matters with the ranking member of the Ways and Means Committee, nor the ranking member of the Senate Finance Committee, but also the Chairman of the Joint Committee on Tax. So if a matter is in the newspaper and if it's publicized and if they name names, if I were to repeat the names publicly, I'm in violation of 26 Section 6103, notwithstanding the fact that
could you do an investigation? That's the question I'm asking.
Yes, certainly.
Right.
Certainly we could.
Thank you. The gentlelady from Illinois, Ms. Duckworth.
Thank you, Mr. Chairman. Gentlemen, you know, Americans have a good
reason to be outraged by the actions of the IRS, and I share their outrage. I'm just frustrated today listening to you. Beyond the mismanagement and the miscommunication that is well documented at this point, what troubles me most is the violation of public trust. It's clear that at several levels, from the misguided actions of the IRS staff in Washington, the IRS employees in Cincinnati, to yourself, Mr. Shulman, in your failure to disclose information to Congress, I just feel that you've really violated the public trust. And it's troubling because the IRS has such an awesome responsibility, such an incredibly important job to do, one that is central to how well our government operates. And as our tax code gets more and more complicated and IRS employees face furloughs and pay freezes, which, by the way, presidential appointees are exempt from, it is an increasingly difficult job to do. So I want to get at your comments. In yesterday's Senate Finance hearing, and again today in response to my colleague, the gentlewoman from California, Ms. Spears, you denied personal blame for the inappropriate criteria used by the IRS. So what will you accept personal responsibility for? How about the lack of training of the staff as identified by the IG? Will you accept personal responsibility for the failure to properly train the staff?
Look, I wouldn't go down a long list. I was the leader of the IRS at the time that this happened. I accept the fact that this happened on my watch, and I'm very sorry that this happened while I was at the IRS. I feel horrible about this for the agency, for the people there, for the great public servants. I'm not sure what else I can say.
Were you responsible for the training of the IRS personnel under your leadership?
I did not hands-on decide the training of 90,000 people.
So you will not accept responsibility for the training of the personnel under the IRS at your time there?
I accept that this happened on my watch.
Okay. So yesterday you said, talking about when someone found out about this problem, and you said when someone spotted it, they should have run it up through the chain. Why they didn't, I don't know. Do you accept responsibility for the poor reporting process up the chain all the way to you, as you yourself have identified happened?
As I said yesterday, it should have been brought up the chain earlier, so that it could have been addressed. There was clearly a breakdown in this one unit of the IRS and of the chain that moved up, and I accept that this happened on my watch.
Okay, so you won't accept responsibility that some sort of process needed to be in place, or a check and balance to make sure that if there was a breakdown that that would be corrected, and that they were properly trained on how to report up the chain? No need to answer. Now, do you accept responsibility for your failure to correct the public record once you found out your testimony was not accurate?
I answered truthfully with the information I had, and I've said before, when I found out that a list existed, I did not have all the facts. At that time, the Inspector General was going to investigate, and I feel very comfortable that the actions I took were appropriate.
Okay. Mr. George, your report indicated that after Ms. Lerner discovered the IRS employees in Cincinnati were using inappropriate criteria, she stopped them immediately. Is that correct?
That's, I don't know how you define immediately, but she did halt that behavior, yes.
Thank you. But then the employees started using slightly different but still inappropriate practices a few months later?
Correct.
Okay. How were these employees allowed to resume these activities after management stopped them the first time?
That is the heart of the question, Congresswoman, which we still do not have a definitive answer to. My response, if at this stage, would be a lack of oversight, a lack of follow-up on the part of Ms. Lerner and people within her immediate chain of command. No one went back to make sure that what was being told to do, by them to do in Cincinnati was being done, and that's inexcusable.
Mr. Shulman, do you accept responsibility for Ms. Lerner's failures as your employee to follow up and provide oversight necessary?
I have the same answer. This happened on my watch. I do not accept responsibilities for all the actions taken by all of the people outlined in the report.
Well, I am deeply disappointed in your answer because right now, in forward operating bases in Afghanistan, all over the world, we have 25-year-old buck sergeants and second lieutenants who know you can delegate authority, you can never delegate responsibility, and you're always responsible for the performance, the training, the actions of the men and women under you. And I hope that you remember that in the next position you go to. Thank you, Mr. Chairman.
Gentlemen would yield. I'm going to work with the ranking member, and we're going to either formally or informally ask the designate to be the next commissioner who has been the director of the Office of Management and Budget to come before us so that we can perhaps see in advance whether the management skills are there and the plan is there for what has clearly been a dysfunctional period of time.
Mr. Chairman, yes, I just want to thank you. I made that request in my opening statement, and I thank you because I think that's a major move.
Yeah, absolutely. And with that, we go to the gentleman from Pennsylvania who has been patiently waiting, Mr. Meehan.
Thank you, Mr. Chairman. Mr. Chairman, I would like to begin to follow up a little bit on some of the information that was generated by my colleague from Oklahoma, because I'm standing holding in my hand as well a questionnaire for one of the organizations that made an application. Their application was made in 2009. It's now 2013, and they still have not got a response. And yet here we are, 39 questions that are being asked. This is the second level of questioning. Now, we hear some of this. This is all being done for efficiency purposes and other kinds of things, and yet we have people that have 39 questions that they're asking on subsequent organizations. So the issue I have for you is there an ability to have these questions resolved as was stated by your successor, by a few people down in Cincinnati, or is there another level of questioning that these matters are vetted? Mr. Schulman.
I guess I'm not sure I understand your question. But
the testimony of Mr. Miller the other day, your successor, was that this matter was contained. It was at his specific language. This was the result contained by a couple of low-level employees in Cincinnati. This is where I'm having trouble really understanding where this is all coming from. And it was his testimony that it was a couple of low-level people in Cincinnati. And now I'm seeing 39 questions that are sophisticated and complicated. And the question becomes, is there somebody else beyond Cincinnati that's participating in the vetting of these questionnaires?
To the best of my understanding, I really don't know who approves all of the questions. It's pretty well outlined. I have made myself familiar with the IG report about requests for guidance and those kinds of things.
Mr. George, what do you know about this?
Actually, Congressman, one of our recommendations, which the administration has agreed would be
Mr. George, I'm not asking about a recommendation about what would be. I'm asking about what has happened, because the testimony of Mr. Miller was this was contained to a couple of people back in Cincinnati.
Yeah, I'm not able to give to...
Well, let me give you a little bit of information, because I have from the application. Now, this is the attorney who has actually made the application, and this is the words of the attorney. Indeed, more than one agent in Cincinnati has advised me that the instructions regarding the processing of the Tea Party-related organization clients were coming from the Washington, D.C. office. Yeah. Now, were there other levels beyond Pittsburgh, Cincinnati, as was testified by Mr. Schulman's successor?
That's still to be determined, sir.
Well, what ambiguity is there? What have you looked at? What questions have you asked to determine that?
Yeah. I have not been personally involved in the interviews, but I do know that there have been conflicting information provided to my, again, auditors, not my investigators, sir, but my auditors, as to how this came about.
Did you ask the question specifically whether there was anybody asking or involved in these evaluations beyond the Cincinnati office back in Washington?
Yes, yes.
And what was the answer?
I beg your indulgence. Sir, can I get...
No, you can't get back to me. I want to know. He just whispered something in your ear. What did he say?
I couldn't hear, so... Repeat it, sir. Apparently, again, the determinations unit on a number of occasions, not obviously I don't know the instant matter you're discussing, had made requests to the technical unit in Washington for guidance on how to handle certain matters. The technical unit in Washington...
So you're saying that this was a request that was made from the floor that went up and asked the technical unit. There was no involvement from anybody in Washington in the form of participating or directing in which things came up.
The answer is yes, but in this matter that...
There was involvement in Washington in which things came up?
Yes, because the technical unit...
All right, that contradicts the testimony of Mr. Miller, but please explain.
Well, the technical unit is located in Washington, and as I discussed much earlier at this hearing, the technical unit took an inordinate amount of time to respond to many of the requests from the...
5 years, 4.5 for this applicant.
But, sir, it's very important for me to point out, the administration has agreed to recommendations that they clear up all the backlogs, such as the ones that you're referring to. And so if they follow through on those recommendations, hopefully this matter that you're referring to now will be addressed.
Well, boy, I have a series of other questions, but this is just so frustrating to me. You know, the whole question here is, we've heard this from time to time, just about accountability. And in all the scandals, we hear the same thing from time after time by the government officials that are involved. Benghazi, IRS, AP reporters, Fast and Furious. Time after time, we're hearing people, wasn't my job, I don't know, it was the other office, I was recused. I didn't find out about it until you found out about it. Where does the accountability begin? People's lives are on the line in these things overseas. Constitutional rights are at stake here. Where does the accountability begin? I'll close with one comment. This was the President of the United States himself. These were his words on January 21st, 2009 in the memorandum. Governments should be transparent. Transparency promotes accountability and provides information for citizens about what their government is doing. Then he spoke to the heads of the organizations, and these were his words. Let me say it as simply as I can. Transparency and the rule of law will be the touchstones of this presidency. Don't let this president and this nation down.
Thank you.
Mr. Chairman? Just a quick point of
order,
if I could.
from Ohio seeks recognition.
I mean, I hope what Mr. Meehan said is right on target. I hope the chairman will look at calling in groups who, the victims, 4.5 years. I would love to have them in front of us, explaining what took place and what they had to go through. I hope we'll do that at a subsequent date.
I will direct staff to attempt to vet groups that can come before as witnesses. As the gentleman knows, and I think it's been said here, there's tremendous sensitivity as to personal information, but we certainly would welcome those groups asking us and then vet an appropriate panel. Mr. George, when in my opening statement I did talk about something we talked about personally, which was that you could not rule out that there were other problems because of questions about internal controls, that discussion we had. I assume in response to Mr. Meehan the same is true. Today you may not be able to speak to intervention that came from above or any other place, but you can't rule out that there was some at some time.
That is correct, sir.
Thank you. We now go to the gentleman from Illinois, Ms. Kelly.
Thank you, Mr. Chairman. Mr. George, I want to ask you about a report that the IRS disclosed taxpayer information that it should not have. Section 6104A of the tax code allows public disclosure of an application for tax-exempt status only after an organization has been recognized by the IRS as exempt. Last November, ProPublica reported that they requested from the IRS applications for 67 different nonprofits. In response, the Cincinnati IRS office sent ProPublica applications or documentation for 31 groups. 9 of those applications were still pending and had not yet been approved, meaning they were not supposed to be made public. Mr. George, during the committee's transcribed interview with Ms. Paz, committee staff asked her how this happened, and she explained that an administrative employee in Cincinnati who was supposed to check each application to ensure that it had been approved before disclosing it had made a mistake. Ms. Paz also told us that when the IRS discovered this disclosure, they referred the matter to your office. Is that correct?
I cannot even acknowledge the existence of an investigation, Congresswoman, pursuant to Title 26, Section 6103 of the United States Code.
Okay, well, can I read to you what she told us? Ms. Paz told our investigators that your office determined that this disclosure was inadvertent. And I will read about the IG's review, and I quote, "They found that there was no evidence that the employee had done it for any political reason. There was no reason to believe that it was anything other than a mistake." Can you tell us, Mr. George, did you in fact find any evidence that this release was intentional or that it was motivated by any political considerations?
Yet notwithstanding the fact that the victim is in a position to disclose his or her or its status, Congresswoman, I'm not able to comment on it.
Okay.
Pursuant to law, and I don't want to go to jail.
I don't want you to go to jail either. Can you recommend taking any actions, even if it's generic and you're not talking about a specific case?
If there is a matter that was sent to us for investigation, I can assure you that we did investigate it. We initiated over 143 unauthorized disclosure cases last year and counting. So.
Okay. Also, we do have a new acting commissioner, and he's tasked with addressing problems and restoring faith in the IRS. What would be your best advice for the acting commissioner, and what are things you think he should undertake quickly in the next 30 days?
Thank you for asking that question. Mr. Warfield has reached out to me already and has requested a meeting as soon as this week to discuss some of the problems confronting the Internal Revenue Service, and I've made a commitment to work with him to help him become familiar with the problems within the IRS that we've identified and ways to hope in the future to avoid them, well, obviously to address the problems that currently exist and to avoid future problems.
And do you foresee this meeting taking place within the next 30 days?
It's happening next week, ma'am.
Okay, thank you. I yield back. Yes.
Let me just following up on what the gentlelady just asked you about. When Mr. Warfield comes in to meet with you, how much latitude do you have with regard to disclosure? You just cited, and rightfully so, things that you can't disclose, whatever. How much information can you provide him?
I have the ability to provide him, the Deputy Secretary, and the Secretary of the Treasury, again, along with the Chairman of the Ways and Means Committee, the Chairman of the Senate Finance Committee, and the Chairman of the Joint Committee on Tax, any and all information, sir.
So you'll be able to tell him about ongoing investigations and what you have found to date. Is that correct?
That is correct, sir.
So he would be in a position, therefore, to, I'm not saying he will, but I hope he will, to be able to make corrections and try to create a better situation and correct some of the things we've been hearing and reading about. Is that right?
That is correct, but he is also confined by Title 26, Section 6103, so he'll be limited in terms of what he can publicly disclose. But
the most important thing, he will be supplied with adequate information so that he can begin to deal with this immediately, because I think all of us want that trust restored with regard to the American people as soon as possible. So I'm hoping that you will disclose everything.
I certainly will, sir.
Thank you.
Thank you. Now we go to the gentleman from North Carolina who has been in and out of here, but who has been active on this issue. The gentleman is recognized.
Thanks so much, and thank you, Mr. Chairman. So, Mr. Wolin, do you have meetings with Mr. Schulman and his then Deputy Commissioner Miller? Did you do that on a fairly regular basis?
I had, Congressman, quarterly management review meetings where we looked at broad issues with respect to the budget and to how their IT refresh was going and so forth. Again, taking full cognizance of this relationship with the IRS where we didn't engage in discussions, didn't work in the details of tax administration or tax enforcement.
Right, right. But so okay, roughly 4 times a year, you sit down, go over the budget, talk things through. That's good. In terms of report stream, you're the appropriate person for that to happen in Treasury. I understand that. So you regularly have this meeting, and you discuss budget issues. But this issue about IRS employees targeting conservative groups, did that ever come up in any of these meetings?
It did not. I have no recollection of that at all,
Congressman. Okay, so knowing what you now know, do you think there might have been a concerted effort to kind of prevent the report stream? I mean, prevent this from coming to you?
I don't know, Congressman, exactly what was going on within the IRS on this. What I know is that in general, and this is Treasury-IRS relationships for many administrations now of both political parties.
No, I understand. Right. We're not saying the IRS is a venerable organization, but certainly not as bad as what we've come to find out in this problem. So in May of 2012, the IRS had completed an internal review and investigation. Were you informed of that internal review and investigation?
No, Congressman, as I testified earlier this morning, I learned of that just in the last few days.
Okay, so no. Okay.
Right.
But were you informed, you were informed in June 2012 that the IG was undertaking their audit or review, right?
I'm not sure precisely, Congressman, when it was, but at some point, Mr. George came to me and said he was undertaking an audit.
May, June, July, summer 2012.
Some point in 2012.
Some point in 2012? Was it perhaps before the first Tuesday after the first Monday in November? Just established as a fact here.
It may have been, Congressman.
Okay.
Again, I don't precisely recall when it was.
Mr. George, do you have some further vague recollection? Was it perhaps hot outside, or were we wearing an overcoat? I mean, some time frame for me? Not to be glib about it, but,
No, sir. No, it was in the summer of 2012.
Okay, thank you. So in the summer 2012, you're informed the IG is undertaking this review. Does this raise any sort of concern with you?
Well, what it raises for me is what I said earlier, which is once the IG is looking at an issue, we ask.
No, I understand. I'm separate from that. I'm not saying you go to Mr. George and try to manhandle it and say, don't do this. I'm not making that accusation, okay? Just to be clear. What I'm saying is he brings this very serious matter to you. You've received letters from the left and the right in Congress to the Department of Treasury, among various other administration officials, right? They send letters to the Treasury and to the IG. It's their press reports. In the spring of that year, there's some concern. Your IG comes forward and says, look, we're going to take this review. Don't you go, this is kind of, a good thing, bad thing? Come on, give me some sort of sense of your emotions. You're a human person, too.
Congressman, I did not have awareness of this issue before. I don't believe.
No. I'm not talking about your learning. I'm talking about your feelings. Let's talk about your feelings then. And when you heard the IG is going to do this, you're serving a president. The president appointed you. You're Senate confirmed. Very important position. You're there from the beginning of the administration. The IG comes to you and says, we're looking into this very damning thing. It's a presidential election year. You don't say for a minute, this is kind of frightening.
He didn't come to me with conclusions, Congressman. He came to me with the fact of the audit. So what I said to him was, this is important, and you should follow the facts where they lead.
Okay, so then take me from there. Do you tell anybody?
No, not until much later.
When? Like when?
I don't know. I can't remember, but some point later, I came to learn that the IG had also told the fact of his audit to some other folks.
No. So we're talking about summer of 2012. The election is coming up. It's unclear who's going to win. Your guy that nominated you, I assume you still support him, but in 2012, you're looking at this election year, and you don't pick up the phone and say to your contacts at the White House, which, say, just as a heads up, this could actually hit the fan in a presidential year.
I did not, Congressman.
Okay. And you don't tell anybody in the Office of Counsel at the White House?
I did not.
Okay. So the first time you learned about conservative groups being targeted by the IRS was when this report came out.
The first time I learned that there was before the report came out, a draft of the report was shared with IRS, and IRS staff, as I think is now public, had conversations with some people at the Treasury Department. I didn't have any understanding of the details, but I understood from Mr. George, I think at some point in the last set of weeks, that this was going to be a report that was going to reach a very damning conclusion. But I didn't have any understanding.
Did you give a heads up to the White House Chief of Staff?
I did not.
Okay. Thank you, Mr. Chairman. Thanks for your indulgence. The absurdity of this is that when a huge accusation is being undertaken by an Inspector General in a presidential year, I just, it is beyond me to think that an administration official wouldn't have maybe, let me ask another question. Did you contact Chicago about it?
The time has expired. Make it very quick.
Did you contact the campaign about it?
I never had any contact with the campaign.
Thank you.
To make sure. Thank you.
Mr. George, just for the record, the date that the draft was shared, to your recollection, I think it's on your timeline.
A draft was shared with whom, sir?
With the Treasury.
Well, it would have been shared with the, we don't share drafts with the Treasury. We share them with the IRS.
I'm sorry, you shared with the IRS, and I thought there was a date you shared with the Consul for Treasury. Maybe I don't have that draft in front of me. You shared an unofficial draft. I just want to know if you have an official date on that one event. I just want it in the record.
March 28th, 2013, a discussion draft report was shared with the Internal Revenue Service.
Okay, so that's the date with the IRS. Correct. And the 27th was the acting commissioner.
Yeah, I have monthly meetings with the acting commissioner and his principal deputies. And
so outside of the Office of the Inspector General, before or after March 27, 28, were any other drafts or portions of drafts circulated outside of your direct reports?
If the question is whether my office shared drafts, we would have shared drafts with the IRS, I believe.
Right. In this discussion draft for this set of timelines you gave us, right, we only had the IG function head briefing, including the acting commissioner, and the discussion draft issued to the IRS the next day. Are there any other days in which discussion drafts or preliminary or portions were shared with anyone outside of your direct reports as the IG?
During the course of an audit, there is a back and forth sharing of information between the subject of the audit and our organization.
But the reason I ask is Mr. Schulman knows nothing. Mr. Wolin knows nothing in almost any of these areas, either doesn't remember or didn't know. So can you make available to us, to the greatest extent possible, those back and forth discussions that occurred with anyone, including Ms. Paz and others, so that we have a complete record of sort of who knew what when? Because, as you know, we didn't know any of this until long after the 28th of March.
Very good. We will provide that.
Thank you. We now go to the gentleman from Illinois. We're on a roll on the Illinois folks, Mr. Davis.
That is correct, Mr. Chairman, and thank you very much for holding this hearing. Mr. George, let me also commend you for your stamina and composure. It seems to me that you've been testifying around the clock all week. This is my second encounter with you from another committee. Let me ask you, according to your report, about one-third of the organizations selected for further review were groups with the words Tea Party, Patriots, and 9/12 in their names. Is that correct?
Yes. Yes, it is, sir.
Your report also found that as of December 2012, none of the applications submitted by these targeted groups had been denied. Is that correct?
That is correct, sir.
Several progressive groups have now come forward to say that they were also included in this enhanced review process. According to these groups, they also received requests for additional information, similar to those sent to conservative groups. The IRS asked them for detailed information about meeting minutes, officers and board members, and specific activities they conducted. These groups also experienced substantial delays in the processing of their applications and in some cases were denied tax-exempt status. Mr. George, how is it that these progressive groups were included in the enhanced review if their names did not have the words Tea Party or other designated words?
Mr. Davis, well, first of all, in the course of this review, we were looking at political intervention, and that was the exclusive charge that we had. I have subsequently received information that what you're indicating may have occurred, and as a result, we will be conducting a follow-up review to determine whether or not that is the case, and if so, the extent of it.
Thank you. You testified yesterday that in conducting the audit, your office did not give further review to any of the more than 200 501c4 applications in your statistical sample and did not have Tea Party, 912, or Patriots in their title. Is that correct?
We looked, sir, I beg your indulgence. 202 non-Tea Party cases, and so the various groups that you just enumerated, were reviewed for indications of significant political campaign intervention, which was our key criteria, again, in this exercise, in this review, Congressman. We did not evaluate whether or not they were conservative groups or progressive groups or liberal groups or whatever term you want to use, because those groups did not, again, have the be on the lookout terms, Tea Party, Patriot, or 912 in their names.
But then it is true that conservative-sounding groups, or with the names that some people would associate with being conservative, were not the only groups who went through this process and were treated essentially the same way.
We were unable, we did not make that determination, sir, for fear of not being able to determine what group stood for what position. But it is a possibility.
Thank you very much. And I got one question, Mr. Wolin. What is your title?
I'm the Deputy Secretary of the Treasury, Congressman.
And the Internal Revenue Service reports up through you?
It does.
And when they encountered these applications, did anyone come to you for advice or come to you and say, we're getting all of these applications, we're not sure what to do with them? What do you suggest or recommend?
No, they did not, Congressman.
Thank you very much. Chairman, I yield back.
I thank the gentleman, and I would like to let everyone know that the intent of the chair is not to stop during the upcoming votes. So as we get close to the votes, if some folks that are not in the queue want to go, there will be 2 votes. They can vote on either one of them or both of them, and then return. My expectation is that I will continue until concluded. If you are not here and we pass you by and we get to the end, we will dismiss our witnesses. So do your best to get back quickly. Immediately following the hearing, we will go into a markup. This is a bipartisan markup, but we still want a quorum. So please make sure you're here. With that, we go to the gentleman from Tennessee, Mr. Desjardins.
Thank you, Mr. Chairman, and I thank the witnesses for appearing here today. We start a lot of these hearings saying we don't want this to turn political, but we're almost in kind of a strange parallel universe today where Democrats and Republicans alike are in agreement that what has happened here just shakes the very foundation of what this country was built on. People are here today to get answers about what the outcome of this is going to be and who's going to be held responsible. We all trotted off to our high school government classes and history classes, and we were told what a great country we are because of the freedom we have, the freedom of the First Amendment, freedom of speech, the right to hold elections without fear of tyranny or being oppressed. But now we have a federal agency that has admittedly targeted, in this case, conservative groups. And I think both sides are equally concerned because this could go either way. And I think what people want to know is who is going to be held accountable and how they're going to be held accountable, how high up this went or didn't go. And so what we're here today is find those answers. Now, Mr. Shulman, do you consider yourself a good leader?
Excuse me?
Do you consider yourself a good leader?
I do.
Okay. So you're as an American, outraged like the President over what's happened within your agency. Is that correct?
I'm deeply saddened and dismayed
Okay.
what's happened at the agency.
What would be justice to you? What would restore the faith in the American people in the IRS, in your opinion? What should be done?
I don't have all the facts, and I'm not in a position to, I'm outside of the government at this point, so it's not my decision what should be done.
Okay. But you admit that people were targeted, and you found out about that over a year ago. You knew that conservative groups were targeted.
No, over a year ago, was informed that there was a list. I did not know the details. I didn't know the severity.
A list of people who were targeted. This is really hard for you to say. Everyone else is saying it, but you can't say that there were groups targeted.
As of May 2013, so sitting here today, I mean, you can call it what you want.
A year ago, you didn't know that groups were being targeted. Did Mr. Miller, your predecessor, did he know that groups were being targeted?
I can't tell you what he knew. I can tell you what he told me.
What did he tell you?
It's what I said, that he told me that there was a list, that the word Tea Party was on it. We didn't know what else.
And when did you know this? You knew this before the election.
What's that?
You knew this before the election.
Sometime in the spring of 2012.
Okay, and that would be before the election, I believe. You did know there was an election going on that year.
Excuse me?
You did know there was a presidential election.
I'm aware that there was an election last
year. All right. Do you think that that type of information could potentially harm the president in an election year? Did that cross your mind?
No, that did not cross my mind. I was the Commissioner of the Internal Revenue Service, and when I get a piece of information of concern, I viewed my obligation not to think about elections, but to think about, once information came to me, was it being handled properly? And as I've said before, I've been told that it had been stopped or was in the process of being stopped, and that the...
And as a good leader, that was good enough for you?
Excuse me?
As a good leader, that was good enough for you?
I feel very comfortable with my actions.
Wow. Okay. What about the credibility of the IRS moving forward with implementing the health care law? A year or so ago, you and I had a conversation in this room about the IRS's readiness to implement the health care law. You felt that even though it took 55 minutes for someone calling about a tax question to talk to a human being and get an answer, that you felt comfortable that we would be ready to implement this health care law. How do you feel about that today? I know this won't be your responsibility. Do you still think the IRS is ready and has the confidence of the American people to share their most personal information with them to go ahead and implement the new health care law?
I mean, I think a couple things. I think, one, the last couple of years, Congress has not been funding the IRS sufficiently. And, I would defer to the Inspector General, who's done some looks at least when I left, had been looking at, is the IRS ready to implement its portion of the Affordable Care Act?
Are they competent to do it? Are they trustworthy enough? This is personal information people are going to have to share. I mean, we have to restore the confidence, and we don't even know what we're going to do in this case where our most basic freedom of speech has been violated, and you don't know whether anyone should go to jail. You don't know who should be held accountable.
Look, I feel very confident in the men and women of the IRS to do the tasks they gave them. There was clearly a serious breakdown in this unit and in the topic here, and it's very serious, and the committee should be looking at it, et cetera. But I feel very confident in the capabilities of the IRS broadly and generally.
We'll see if America shares your views. And I yield back.
I think the gentleman from Vermont is recognized.
I thank the gentleman for this hearing and support the aggressive investigation. Mr. Chairman, you're known to be aggressive, you're known to be persistent, and those are qualities that are going to serve us well in this effort. There's really two issues. The first that's vitally important is, has the principle of equal protection and equal enforcement of the law been violated? And the second question is whether First Amendment rights have been infringed. Those are the focus of this hearing, and I support the aggressive efforts of this committee led by our chairman and ranking member to A, determine the facts, and B, follow the facts wherever they lead. America deserves an answer. And the fundamental question here is whether or not at the end of this investigation the conclusion is this was poor judgment and mismanagement, or were these actions politically directed and politically motivated by politically powerful people? That's our oversight function. And you're pursuing that, as you've said, aggressively, and we support that, both of you. But there is an oversight function, as Mr. Cummings said. And the oversight question asks us the question as to what is going on in the campaign finance world that we all live in. It also raises the question as to whether or not America's institutions are failing the American people that they serve. This was a failure by the IRS, whichever conclusion the facts lead us to. Just the conduct that raises legitimate questions as to whether or not there's been selective enforcement and politically motivated action compromises the ability of that institution, the Internal Revenue Service, to have credibility to do the job that the law requires it to do. But this mess goes back to a decision by the United States Supreme Court in Citizens United. In that case, in my view, the court made what I think is an absurd decision. They said a corporation is a person. And corporations have rights, and they should be protected. Corporations serve a very important function in our economy, and those should be promoted. But a person like you or like me, that's just nutty. You know, when it comes to the question of personhood, Mr. Chairman, and I'm talking about this because of our oversight function where I hope we do find some common ground, the Supreme Court gets it wrong. In 1857, in the Dred Scott decision, the Supreme Court said an African American was not a person. That is a stain on the court. It's a stain on our history. That was corrected by this Congress in 1868 with the 14th Amendment. The challenges we face as a Congress is whether or not we're going to acknowledge what has happened in campaign finance since Citizens United. And let me just give a few facts, because this is really, I think, in my view, a threat to the access to democracy by everyday people. Last presidential election, our candidate spent $1.1 billion between what he raised and what outside groups
put a B on that one, if you would. Billion, yeah.
Yeah, thank you. And the Republican candidate spent about the same. And, you know, in the quaint old days when President Clinton ran for his first race, he spent about $42 million, but that's an M, and Mr. Dole spent about $44 million. In the congressional races that we have all been engaged in, the House races were $1.1 billion. And the Massachusetts Senate race, $82 million. A House race in Florida, $23 million. And what has happened with all of this money coming into the political process, and I think we've all experienced this because I've talked to my colleagues, there's more 30-second attack ads. They do nothing to elevate the debate or explain the sharp divisions we have on a legitimate issue of taxing and spending. There's less control that each of us as a candidate have over what it is we're promoting to the people we're trying to represent, because outside groups are starting to spend more than the individual candidate does. There's more despair by citizens that we all represent that this political system has anything to do with anything they care about. And this is something I've noticed as a member of Congress. There's less ability for us to try to find common ground and make compromises that are in the public interest, because some loopy billionaire on your side or ours can flood the airwaves with an avalanche of cash criticizing us because we actually dare to make some compromises. So this campaign finance system, in my view, Mr. Chairman, is in dire need of reform. So, yes, let's get to the bottom of this situation, but let's also acknowledge that this money that is coming into the political system is a very threat to our ability of this institution to do the job that the people expect it to do and the Constitution requires us to do. I yield back.
I thank the gentleman. We now go to a gentleman who got here based on his ability as an attorney, not on based on being a billionaire. Mr. Gowdy.
Thank you, Mr. Chairman. Mr. Shulman, when you learned that conservative groups were being targeted by the IRS for discriminatory treatment, what did you do?
When I learned of the existence of a BOLO list, in that same conversation or right around that time, I also learned a couple things. One, that it was being stopped. So that.
All right, and who told you it was being stopped?
That's Steve Miller, my deputy.
All right, and did you investigate further? Can you give me the name of a single person who was involved in the original decision to target conservative groups for disparate treatment?
I'm not aware of those names.
Why can't you give me a name?
So at the same time that I learned and that it was being stopped, I was also told that the Inspector General was aware of it.
Mr. Shulman, is the Inspector General the only person who can investigate wrongdoing within the IRS?
My general practice.
Can you answer my question and then you can explain? Is the Inspector General the only entity who can investigate wrongdoing?
Congress can investigate.
How about you? Can you do it?
The practice of the Internal Revenue Service that I inherited.
So if there's inappropriate conduct being done on your watch in the IRS, then that inappropriate conduct can last as long as the Inspector General's investigation lasts. Is that what you're telling me? That you're not going to step in and stop it?
No, what I'm telling you.
If there's someone wielding a knife in the parking lot, are you going to call the Inspector General? Are you going to wait until his or her investigation's over before you stop it?
When I was told about these allegations, I was also told that they were being stopped, and so the inappropriate criteria were not being used.
Despite the seriousness and potential criminality of that conduct, you didn't investigate it yourself at all?
So the procedures that I inherited and that my
Mr.
general
Shulman,
practice
this is going to go much quicker if you'll answer yes or no, and then you can explain. Did you do anything to verify that the practice, as insidious as it was stopped?
The Inspector General is going to be looking into it, and that's what
Is it that you can't say yes or no, or you're just choosing not to say yes or no? Can you answer the question, did you do anything personally to make sure that this insidious, discriminatory practice was stopped? Yes or no?
At the time that I learned about it, I also learned two things. The first was that it was being stopped, and the second was that the Inspector
And what did you do to verify that it was stopped?
The responsible deputy of the Internal Revenue Service told me it was being stopped. I had no reason to believe otherwise.
Did you investigate why conservative groups were being targeted?
Excuse me?
Did you investigate? So you can't give me a single name. You can't answer the who. Can you tell me the why? Why were conservative groups? Why was the culture such under your watch that an employee felt comfortable targeting conservative groups? Did you investigate that?
You know, from my reading of the report, I can't tell if it was political motivation or if it was tone deaf, somebody trying to expedite a way to
You still don't know that this was political.
Excuse me?
You still don't know that this was political?
I defer to the Inspector General.
Well, I'll tell you this, Mr. Shulman. Your predecessor said that he wasn't sure if it was partisan, and that requires the listener to be as stupid as the speaker to utter a comment like that. He just testified that policy positions dictated this. What does that mean to you? If it's not partisan, what does that mean?
I'm not sure I heard that testimony.
Well, we'll be sure and get you a copy of the transcript, and you can supplement your testimony. How's that? Do you agree with
I'd be happy to
Dan
answer the
Pfeiffer?
committee's questions.
Do you agree with Dan Pfeiffer that the law is irrelevant, or do you think it is relevant?
I think the law is always relevant.
Do you think 26 U.S.C. 7214, which provides for criminal penalties for this conduct, would be relevant? And did you refer the matter to someone with law enforcement investigative jurisdiction?
A, I'm not going to speculate what's appropriate legally in this matter, and Mr. George, I knew his operation was looking at it, I believe.
I thought it was an audit. I thought he just testified it was an audit, not an investigation. Did you refer it for criminal investigation?
I didn't refer it. It was already being looked into at the time that it was brought to my attention.
I want to be real clear because my time is out. The only recourse you have when there's an allegation of wrongful conduct on your watch, the only thing you feel comfortable doing is waiting on an inspector general to finish his or her report.
The general practice is to make sure the inspector general will look into it.
No matter how insidious the conduct. If it were an allegation of racial discrimination, you would have waited until Mr. George finished his investigation? Is that your testimony?
I'm really not going to answer hypotheticals.
I tell you what, instead of answering a hypothetical, why don't you answer the case at bar today? If there's an allegation that groups are being discriminated against based on political ideology, are you really going to wait until an inspector general finishes his or her report before you take corrective remedial action?
When I have a fact, but I don't have all the facts, and I don't know the scope and
severity.
Did
you investigate the facts, Mr. Schulman? Did you lift a finger to identify the facts?
Felt very comfortable. The facts, the inspector general was going to run down the facts, and once he had it, it would be reported out.
Let the record reflect that's a no.
Thank the gentleman. I know you guys have been there a long time. We appreciate your patience. We got to give you time to use the men's room. So we're going to take a short recess, 5 minutes. The chairman is headed over to votes. We're going to be votes just got called, so we're going to 5 minutes. We're going to bring you back, and when the chairman gets back from voting, I'm going to try to run. We're not going to recess. We're just going to give you a restroom break. All right. Okay. Oh, I'm sorry, Mr. Chairman. we start?
We don't have our witnesses here. We are.
Can you get them?
Yeah, they're being gotten right now.
You get the number, and we get the number, and well, if you don't want to do, I'll do it. If I'm sitting here, when you're sitting here, that's why it's on. I follow the chairman's lead. And I hope you'll continue to pray. We could have audience take their seats, and members who are still here, we'll give Mr. Woolen just a minute or two to return. Again, we want to thank our witnesses and appreciate time, commitment, and patience. Gentleman from Nevada, Mr. Horsford, is recognized for 5 minutes.
Thank you, Mr. Chairman. I agree with a number of my colleagues here today that the behavior of the IRS has been inexcusable in regard to this situation. You know, no group or person should be inappropriately scrutinized because of their political affiliation. And the bottom line, unfortunately, is that this is not the first time that this has happened. Focusing on groups because of their political beliefs was wrong when the IRS did it to Greenpeace. It is wrong when the IRS did it to the NAACP. And it's wrong now when they've done it to these 501c4 applicants. Regardless of which party holds power, this behavior has to stop. What I'd like to focus on is how we can reform this process so that it never happens again. Following up on the ranking member and Representative Spears' line of questioning, the Inspector General's report found that the IRS employees in Cincinnati, quote, lacked knowledge of what activities are allowed by tax-exempt organization. It explained in the report that we believe this could be due to a lack of specific guidance on how to determine the primary activity of an IRC 501c4 organization. Treasury regulations state that IRC 501c4 organizations should have social welfare as their, quote, primary activity. However, the regulations do not define how to measure whether social welfare is in an organization's primary activity. So, Mr. Shulman, as the past agency head, in judging whether a 501c4 has conducted an impermissible level of political activity, the IRS applies a wide-ranging, multi-factor facts and circumstances test. Is that correct?
Yeah. First of all, I'm not an expert in 501c4 law and the details of how individual applications are reviewed, but Yes, I mean, broadly, they look, the IRS looks to see if political activity is the primary activity, which would disqualify an organization from being the 501c4, and the inquiry is done, or at least should be done, and broadly done on a facts and circumstances basis.
Okay, well, someone who is an expert, Professor Ellen April, has explained that the IRS's facts and circumstances test, quote, reach broadly, gives discretion to the administrators, and leaves many organizations and their advisors with little certainty on how to conduct their activity day to day. So, Mr. George, do you believe a clear, bright-line test for what is permissible level of political activity would be helpful to the IRS specialist?
Well, again, I'm going to have to preface my response by saying that the Secretary has delegated tax policy to the Assistant Secretary for Tax Policy. There is no question that clarity in the law and how to implement it would certainly help anyone who's trying to apply the law in this instance.
Has your office made that recommendation?
We have, and one of the recommendations in this report is that the Internal Revenue Service work with the Department of the Treasury for clarity in this area, sir.
Well, I think it's imperative, particularly since primary activity isn't even the standard. It is, according to the federal law, exclusively. Exclusively is stated twice in 501c4A of the Federal Tax Code. It is stated nowhere primary activity, and yet that is what the standard is that's being used by IRS, and that standard is not even clearly defined. So this is a major loophole that must be addressed. Mr. Woolen, are you intending to revisit these regulations so that taxpayers are on notice of what legal requirements are and how auditors can enforce the rules fairly?
Congressman, the IG's report makes clear that additional guidance in this area is necessary, and we will work with the new acting commissioner to do just that. This is very old guidance. It's in a very complicated area, but we will endeavor to make sure that we can provide as much clarity as possible.
Well, again, I would just hope, based on what the chair and the ranking member indicated with the new commissioner coming in, you're right, for years we've had this ambiguity. Tax and campaign finance experts have urged the IRS and the Treasury Department to better define electoral advocacy beyond the ambiguous facts and circumstances test, and to set clear limits for how much political advocacy is too much. But the agencies have failed to respond. So I hope that based on the leadership of this committee, within our oversight and reform role, this is a reform policy that cannot wait, because it did not just happen to this group or set of groups. It's happened before, and it must stop. Thank you, Mr. Chairman.
I thank the gentleman. We now recognize the gentleman from Texas, Mr. Farenthold.
Thank you very much, Mr. Chairman. Mr. George, earlier on you testified that some of the questions that were asked to some of these groups included a request for their list of donors. Do we know what happened to those list of donors? Do we have any insurance that, or assurances that those lists weren't made public, or somebody snapped a picture with their cell phone and sent it to an opposing group or a political candidate or somebody?
Very good question, Congressman. We were told by the IRS, the office that collected this information, that they did destroy the information. However, again, they were not under oath. We weren't there when it happened, but we have to take them at their word.
Yes, but we have no conclusive evidence that somebody wasn't trying to create an enemies list or something like that.
That's correct, sir.
All right, let's talk a little bit about the IRS procedures. You know, there was a Fox News report today that the president's brother, I think, got his 501c4 approved in a matter of days, and we've got some conservative groups and possibly other groups that are waiting multiple years. Is there a standard of time within the IRS that these are expected to be handled? Are there some processes and procedures in place?
Addressed to me.
Yeah, I'll start with you, Mr. George.
Well, first of all, I cannot, pursuant to Title 26-6103, make any comment that would in any way make...
No, I'm asking about the procedures of the IRS.
Yes.
That there is a procedure in place to...
Yes.
So after a certain amount of time, the computer says what happened to this?
I don't know exactly how it works, but they do have target deadlines or dates for processing these. However...
Mr. Schuman, are you aware?
I don't know the specifics. Generally, there's goals for processing of any sort of cases. Those goals generally in the last couple of years have been very difficult to meet, with budget.
Right. I practiced law for a while. We had a tickler system that when something came in, it got entered into the computer, and if after a certain number of days, it flagged it, and after a few more days, it would flag the boss. Mr. George, you're indicating you?
Congressman, thank you. I was just informed by staff that the standard is 121 days for the processing of these, but unfortunately, they've averaged over 574 days.
So when they get behind, do supervisors get noticed? Are you aware of a escalation procedure? Again, I've never managed an organization the size of the IRS. I think the most people I've ever supervised is around 50. But I had procedures in technology in place to where when somebody was screwing up, it moved up the chain of command. Mr. George, Mr. Schumer, are either of y'all familiar with any procedures like that?
I'm going to defer to Mr. Shulman, rather, on this one.
I don't have detailed knowledge of this specific unit handling these 300 cases.
Well, and a news station in Cincinnati, the IRS, indicating who reports to whom, and of the 6 identified employees, they report to different managers, and then above them even to different territory managers. This sounds like a reasonable and rational organization. I mean, the government, we love our chain of command here. I guess my question is how, in any sort of rigid chain of command, do these extraordinary delays not move out of one department and get up to a supervisory level within that department and then on up within the chain of command to Washington, D.C.? It just seems unfathomable to me that that wouldn't happen. Either of you gentlemen like to comment?
Unfortunately, Congressman, and it's not just in this context, but if you look at the processing of FOIA requests, Freedom of Information Act requests, many times because agencies are overwhelmed by the number of those requests and the limited number of resources that they have to address those requests, they fall behind.
Okay, and if I don't file my tax return or extension by April 15th, is there any chance it will fall through the cracks and get ignored for 3 years?
I'm going to yield to Shulman on that one.
I'll yield back to Mr. George.
Why don't we go to Mr. Wolin, who is still involved?
I will address those questions. Is there not the command structure is the one that I want to get at. Isn't there or shouldn't there be a command structure where this gets escalated to a level that this should have been caught long before it was?
I would say this, Congressman. I think the IG's report includes an important series of recommendations that speak to some of these management issues and training and making sure that these cases are handled in an appropriate way and in a way that's within the time frames that are meant to be. What we have done is we've asked the new acting commissioner who started this morning to be on top of that to make sure that these things get implemented quickly to report back.
And let's get some automation in there. Trust but verify is a good
I thank the gentleman from Texas and admonish him to go vote. I now recognize the gentleman from Georgia for 5 minutes.
Thank you, Mr. Chairman. I appreciate the witnesses being with us for so long today. I appreciate the Chairman's generosity in allowing that last restroom break to give you the ability to focus on my questions. They're fairly simple, and I wish Ms. Lerner was here because I think she explained part of it in her opening testimony. Mr. George, about how many applications are we talking about in a year on 501 C3, C4 categories?
It's approximately 60 to 65,000.
60 to 65,000. And this problem isolated in a Cincinnati office, but about how many of those 60 or 65,000 applications flow through this Cincinnati office?
It's my understanding that all of them do.
100% of these. So it's, yes. When we're talking about what our challenge is, it's not that it's some couple of rogue employees in one small branch somewhere. We're talking about a problem that exists in the center that processes 100% of all of these 501c3, C4 applications. Is that correct?
My understanding there may be one or two, offices out in the field that might have a smaller role to play, but the vast majority are.
Vast majority are here. Mr. Shulman, I don't envy the job you had at all. In full disclosure, I have a bill that moves us away from an income tax to a consumption tax. I don't know how an agency can have the kind of responsibility and authority that the IRS has and not have really bad mistakes happen. It's just it's an awesome responsibility. It's one that I would argue that no agency ought to be entrusted with. But you took on that challenge. Mr. George has told me that virtually 100% of all of these tax-exempt applications are handled in this one facility in Cincinnati. I go back to your testimony in March of 2012 where Chairman Bustani said, can you give us assurances that the IRS is not targeting particular groups based on political leanings? And your response is, thanks for bringing this up. There has been a lot of press on this and a lot of moving information. I appreciate the opportunity to clarify. First, let me start by saying, yes, I can give you assurances. We have 100% of these applications being processed in this one office in Cincinnati where this problem was discovered and widespread. Who did you contact in order to give yourself the confidence to give the chairman of the subcommittee your assurances that this was not happening?
Well, first of all, I'd note that that hearing, the focus was on the budget and our appropriations. This was a question that came. The chairman had written to me, or members of Congress had written to me in the month before.
Due respect, I just have limited time. Again, serious question, off topic, granted for the hearing, but you gave your assurances. Mr. George has several times said today, I can't give you an answer to that. I have to go back and reference more information. We're not prepared to give you a definitive answer on that today. But you said in response to, can you give me assurances? Yes, I can give you assurances. I'm just wondering from what research did you arrive at that conclusion?
So I said targeting in the sense that 501c4 applicants did not need to apply. The ones that had applied had come in voluntarily, and my understanding was that there were questions being asked, that those questions were within the realm of authority of the IRS, and that those questions were not only being asked.
Understanding that was your understanding.
That was my understanding.
Again, going on, you in fact made that testimony. You said further in your testimony, there is absolutely no targeting. This kind of back and forth happens when people apply for 501c4 status. Knowing now what you know about that back and forth, would that still be your testimony? There is no targeting. This is the kind of back and forth that happens?
In May 2013, sitting here before you today, I would have answered differently.
And that's my concern for folks. We saw a press conference with Jay Carney on this very issue. He said, the reporter asked, can you categorically deny the White House had any involvement in this? He said, yes, I can categorically deny it. He said, well, how do you know? Have you done any investigation? Jay Carney said, no, I've done no investigation whatsoever. I just feel like it's probably true. Here you are giving congressional testimony. Your assurance, you could have said, I don't know. You could have said, it's outside the purview of this hearing. I haven't prepared. But you said, Mr. Chairman, there is absolutely no targeting. As you sit here today, you would say there absolutely was targeting. That this line of questioning was absolutely inappropriate at that time. And yet, with 100% of these applications being approved in one office, the office that has these problems, you contacted no one there before making these assurances, not just to this Congress, not just to the chairman of the subcommittee, but to the American people. That's my concern. Whatever the truth is, we'll bring the truth out, but we can't bring it out if folks treat the truth in that cavalier fashion. Again, I don't envy you in your awesome responsibility. I would just encourage folks, if the answer is no, say I don't know. Being on the record about something as serious as this and being wrong does a great deal undermine the trust in our government. And I thank the table.
No, I appreciate your concern. If I could just say, I answered that question truthfully based on the information I had at the time.
But to be clear, you asked no one. The information you had was no information. All of this office work goes on in one office in one city in Cincinnati, the chain of command of which runs directly to your office. You called no one in that chain of command. You asked no one in that chain of command. I'm not saying you were lying. I'm saying you were derelict in inquiring about what the truth was. It was a straight question about 501c4 applications, all of which are processed in Cincinnati, and you made not one inquiry before testifying before Congress about what the truth of that is, a truth that now Mr. George says is not truth whatsoever. That's troubling. Thank you, Mr. Chairman.
I thank the gentleman. Mr. George, on May 10th of 2013, committee staff sent the following. This is paraphrased, or not paraphrased, it's a portion in quotes. The fact that this information is now public and we have not been briefed, despite my repeated request over the many months, is completely unacceptable. It was from my committee staff based on the release by the IRS of your audit information in an inappropriate fashion. Your response was, and I believe it was one of your staff again, staff to staff, on May 10th also, the IRS issued a press statement without our knowledge, consent, or even advance notice. Are you familiar with this exchange?
I am not familiar with that exchange, sir.
Is it correct, though, that the IRS issued a press statement without our knowledge, consent, or even advance notice?
And I want to make sure that we have the dates correct. If this is the event in which Ms. Lerner gave a speech and responded to a question.
A planted question, we now know. So she created a press release by planting a question which she was prepared to answer, and there appears to be an audit trail of that plan.
I had absolutely no inkling that that was going to occur, sir.
I don't want you to overly go past the hypothetical, but release of this kind of information, advanced information, is in fact not legal, right, roughly? It may be criminal.
You know, I cannot give you a definitive answer there, sir, but I can say it has never happened before.
Okay. Will you agree to research this under your authority so that we may all know all of the details without us having to go and ask for those many papers that often take a long time to come?
Yes, but in all, let's see, yes, because she's within IRS, so we do have the authority to do so, yes.
Okay, I appreciate that. Yesterday, well, Ms. Loomis has arrived, so I'm going to cut short. I only have one quick question for Mr. Shulman. The 5-year term that you received is, in fact, statutory. Isn't that correct?
The term is statutory.
So you're appointed by a president to be a nonpartisan, effectively, because you're a term appointee. So by definition, you and the president and the Senate come to an agreement on somebody who will normally transcend at least their one term, or always transcend at least one of their terms, correct? The requirement for your position is management skills, isn't it? In other words, this is not just any political hack kind of a deal. This is one in which you're supposed to possess management administrative skills. That's how you're chosen in an agency that only gets 2 political appointees, one who's the commissioner and the other who is the counsel to the commissioner, as I understand it. So you have one lawyer and one manager. Am I just setting the tone correctly for the record?
Generally, the goal is to have a commissioner who has a 5-year term to run the agency.
Were you selected, in your opinion, because of your management skills?
Yeah, yes, in my opinion.
Okay, that was what I was trying to get to for the record. Now I'll recognize the gentlelady from Wyoming for 5 minutes.
Thank you, Mr. Chairman. Mr. Woolen, I want to go back to something Mr. Schulman said. He testified earlier that he inherited the practice of deferring to the IG for audits and investigations when problematic issues arise at the IRS. Mr. Woolen, did Mr. Schulman have the authority to change the management practices he inherited at the IRS? Yes or no?
Sure.
In this circumstance, do you think he should have changed the practice of deferring to the IG and looked into the targeting on his own?
Oh, if the question is, well, Congresswoman, I think that once an IG begins work, it's very important to stay clear of it. If a political appointee, for example, involves themselves in the work of an IG or in topics that the IG is looking at, I think they run the very big risk that's understandable that will be seen as interference. And that is why for many administrations, for the longest time that I can recall, it's been a core principle of ours that when an IG begins their work, we stay clear.
What kind of activity do you think it would take to change the practice of deferring to the IG for audits and investigations?
Well, I'm not sure I understand your hypothetical, Congressman. I would say this, that here, of course, by the time, for example, I learned of the fact that the IG was conducting an audit, the offending conduct we now learn was no longer taking place. I would expect that if the IG were looking at something and he determined that there was something that was ongoing that needed quick action, that he would raise that and that we would have a conversation so as specifically not to be either interfering with an IG's work or being seen to be interfering with an IG.
Would the gentlelady yield for just 1 minute?
Yes, Mr. Chairman.
I think it's important, Mr. Woolen. You keep saying, and Mr. Schulman kept saying, that by the time you learned about it, the offending activity had finished. The offending activity is two parts. It's the abusive behavior of questions, inappropriate questions, questions that are probative that in fact make us doubt whether or not that information leaked. Let's leave that aside. I think the IG has determined a cutoff date. But are you here today to tell us that no entity has been denied approval or denial in a timely fashion? Because I believe Mr. George will testify that as far as he knows, people are still in limbo today.
No,
on your watch.
Not at all, Mr. Chairman. I think you're exactly right. The IG has made that clear. Now that we know that, we learned that last week, this needs to be fixed quickly, absolutely, and that's part of the charge that Mr. Werfel has. Absolutely.
Okay. But he's not, but he is the acting director at this time.
He's the acting commissioner as of this morning.
Commissioner as of this morning. So we would expect that in spite of these draconian budget cuts, that these 100 or more potential entities will in fact get a prompt and accurate adjudication, meaning days now that it's been years.
Well, I don't want to speak for Mr. Werfel in setting a precise timeline, Mr. Chairman, but
you're his boss. You speak from the President to the Secretary to yourself to him. What the heck appropriate timeline should we expect when you've been drowning these people for 3 years or more in some cases? What is the timeline today? If you're not accountable today, then you're not ever accountable. Could you give us a timeline? In your opinion, what would be the maximum time somebody should have to wait when they've waited for years?
Well, as I've said, Mr. Chairman, what we've charged Mr. Werfel with is coming back within 30 days and to fully and promptly implement the various recommendations in the IG's report, of which this is one.
Mr. George, I'm taking a lot of the jail lady's time, but 3 years you wait. If you're sitting in that pile after 3 years, it's 30 days to find out what the plan is to have you come out of that pile, when in fact other entities that were submitted 2 years after you, also involved in this, quote, category, have been approved. Is 30 days, in your estimation, before a plan is submitted, is a new acting commissioner the reason? First of all, none of these commissioners knew anything, apparently, or asked anything. So why is the new one important? If you could answer, and I apologize, the gentlelady, give her back her time.
Yeah, if I will allow, Mr. Chairman, I believe I've made a commitment to work with Mr. Werfel, and he realizes the high priority the President that my organization have placed as Secretary of the Treasury on this issue. I can't give you a definitive timeline, a date, but I will commit to you that we will work to expedite these, and help him rather expedite these applications.
I thank you. And the gentlelady will be given 2 additional minutes. Thank you.
Thank you very much, Mr. Chairman. In reclaiming my time, I want to take issue with one thing that our esteemed ranking member of our committee said earlier. He said that the trust in the IRS has been undermined. And the issue I would take with that is that trust has not been eroded or undermined, that it's been destroyed. That trust is gone. My constituents, the people I represent, believe the federal government is out to get them. And when things like Watergate were going on, you had a battle of titans. You had the politically powerful going after the politically powerful. But in this matter, you have the politically empowered going after the people who hired them, and people who don't have the weapons of the imprimatur of the federal government to turn to. You have people who are relying on trust, and that trust is absolutely gone. I have no idea how we can restore the trust that has been destroyed as a result of this. The IRS has let down the very people that they were employed to serve. In fact, the people think the IRS has turned against them. And it is on a stack of other concerns where they believe the federal government has turned against them. This is Goliath against David. These are the people who hired Goliath and empowered Goliath. And Goliath has turned against those very people. It's moms and dads at kitchen tables who are taking kids to soccer games who want to have a political organization like a Tea Party. It's people who believe they're patriots. And their own government is telling them, we will not allow you to exercise your patriotism in this way because we don't like your brand of patriotism. This is far worse than anything we've seen in Watergate or that the government has done to the government, because this is the government turned against the very people who hired them, who trusted them, and who have destroyed that trust. Mr. Chairman, I yield back.
The gentlelady yields back. We now go to the gentleman from Washington, Mr. Hastings.
Thank you very much, Mr. Chairman. I think the tone of this hearing is the reputation of the IRS being at stake, but I recognize that may be an oxymoron, to be very honest with you. Mr. Wolin, in response to a question by Mr. Langford, you stated that you were not aware of the complaints of conservative and Tea Party groups that received extra scrutiny from the IRS until you were informed by Mr. George of the Inspector General audit. Is that correct?
That's correct.
And once again, when were you informed of that audit?
Well, I don't recall precisely, but I'm prepared to accept the.
Well,
the
give me a
IG statement.
ballpark. Give me a ballpark.
The IG, I think.
I thought it was the summer of last year, right?
That's right.
Summer of 2012. So do you not see any of the letters from members of Congress about this matter?
I don't think there were many letters, if any.
I didn't ask you that. I asked you if you were aware of them, not how many.
No.
You were not aware. Did you, so you didn't see any news articles about this before that date, is that correct?
I was not aware of this.
Did you, I asked you if you did not see?
I don't recall seeing any news articles.
Okay. And you had no conversations with anybody about the extra scrutiny of the Tea Party groups before that date?
I had no conversations of that sort.
Okay, good. Mr. Schuman, just to clarify, when you get a letter from a member of Congress, that goes to your personal attention, or at least your signature when you respond. Is that, did I hear you correctly when Mr. Shavitz asked you that question?
We get a lot of letters.
I didn't ask you that. I asked you questions from members of Congress if you personally sign those letters, if they're addressed to you.
Some come to me,
okay,
I respond to, and some come to me that other people respond to and sign.
Would would a letter from Mr. Camp, Chairman of the Ways and Means Committee, get your personal attention?
If Mr. Camp wrote to me, generally yes.
Generally, yes. Well, he wrote to you in June 2011 about the Tea Party issue. So now does somebody sign your letters other than you?
I don't, but to the best of my knowledge, that in my memory is that was not about the same issue.
Okay, well, according to the records we have, he sent you a letter in June 2011 regarding this particular issue.
That's not my memory. In
Okay,
June 2011?
Well, that's our records. Let me ask this. When you testify in front of Congress, do you have a preparation prior to testifying before Congress?
Yes.
You do? Who participates in that preparation?
It can depend on subject matter, but it was generally people in my direct office.
Generally, your chief of staff, probably your top aides?
Yes.
Does it change from subject to subject?
It can change from subject to
okay.
subject.
When you testified in front of the Ways and Means Committee, and this has already been brought up where Mr. Bustani asked you the question, and then you had an exchange with Mr. Lynch. Let me see, where is that? That is on, well, at any rate, the question was, can you assure us? And you told Mr. Bustani that you could assure him that nothing was going on. Then you had an exchange with Mr. Lynch. Do you recall that brief conversation with Mr. Lynch earlier today?
Yeah, I don't recall the exact words, but I recall the.
Well, let me. This is what you said, and the issue was you can give the phrase that you use in response was you can give assurances that there was no targeting. That's what you said in testimony. Now, you said then in response, because he interrupted you and he says, "Let me answer the question," and so you then said in responding to Mr. Lynch, you said that those assurances and no targeting came from conversations. Who were those conversations with?
I had my understanding at the time, March of 2012.
No, who were no. The question was Mr. Lynch said, is there no targeting? And you said in conversations that's what that's what I believe. Okay, I'm asking you who those conversations were with.
So I can't tell you these are the exhaustive conversations, but when the letters came in, I know
I'm talking about the testimony from the question of Mr. Bustani.
And in my mind was the letters that I had received about extensive questioning, and those conversations were most likely, my memory is not clear on this, with my deputy, with his deputy, with my chief of staff.
Who are those by name?
I would have most likely had conversations with Steve Miller.
Steve Miller. Who else?
Nicole Flax.
Who?
Nicole Flax.
Nicole Flax.
Deputy at the time.
Who else?
Those are the two with the most knowledge of tax-exempt organizations that I relied on the most.
Okay,
it could have been other people on my staff as well. I just don't have a clear
Which other people on your staff?
My chief of staff was an obvious person that I have conversations but didn't have knowledge of tax-exempt.
Now, with your indulgence, Mr. Chairman, you said on conversations, this is how you do that conclusion. Now, you prepare for these hearings. Did you anticipate that question prior to this Ways and Means hearing?
I didn't anticipate the precise question, but I generally familiarized myself with the letters, and the questions about donors were the main things that were on my mind.
Okay, so that means that then you prior to that question, when you gave assurances there was no targeting, when you give assurance, that's pretty hard stuff, no targeting. So in preparation, you had discussions about this, and yet you answered to Mr. Bustani. You gave assurances there is no targeting. Now, the issue, of course, that we are concerned about is that you haven't apologized for not stating that correctly, and you just now said that in preparation you anticipated at least the subject of this question. I have to say, Mr. Chairman, that I find once again I won't say non-answers or vague answers here. Trying to find out who in fact did all of this is pretty hard to come by when we get, frankly, Mr. Schuman, answers like this. You prepare for these meetings, you anticipate at least the subject of this question, and then you respond to questions here today that in conversations with people, I feel very comfortable. There's something missing here, I have to say, in my mind, Mr. Schuman, and I suppose I'm sure that this committee will try to find those answers, but leave me in the dark on that. Thank you, Mr. Chairman.
Thank you, Mr. Hastings. I will note that this is a committee that was told that justice didn't let guns walk at the ATF. So sometimes it's their definitions versus the common sense real definitions. At this time, I'm asking unanimous consent that the page 16 from the GAO report, which is entitled Budget Data Fiscal Year 2008 to 2012, be placed in the record for the purpose of authenticating that Mr. Schulman, in addition to being detached from the running of his business, also is unaware that the fiscal 2008 budget of the IRS, $11.6 billion, rising to $11.9 billion, rising to $12.6 billion, and roughly stable at $12.6 billion in fiscal year 2011. Mr. Schulman, there are no budget cuts during the period of time in which you're claiming you don't have enough money to do your job. Without objection, so ordered. We now go to the gentleman from Missouri, Mr. Clay.
Thank you, Mr. Chairman, and let me thank Mr. George for being here, and thanks also to your staff. They have given our committee staff several briefings now, and we appreciate their work. I understand that from your staff that your office was not particularly happy about the way Lois Lerner at the IRS essentially tried to get out ahead of your audit. She basically orchestrated a question and answer at a ABA meeting on Friday, May the 10th. In your experience, have you ever seen an IRS official do something like that, or was that a first?
It was a first during my tenure, Mr. Clay.
And your audit was not finalized yet at that point, is that right?
That is correct. Well, let me double. That is correct. There's a clearance process, sir, that has to occur to ensure that any Title 26, Section 6103 information is not premature, is not released, period. And that clearance process had not been completed by then.
So you hadn't completed your job yet, but just to play devil's advocate, you had already briefed them on your findings. So what was the problem with them going public before the report was final?
They're privy to all of the information that we find because they have, again, access to information under the tax code, Title 26 for the most part. But there is a provision within the tax code, again, Section 6103, which provides for potentially criminal results if you release information, sensitive return information is what they call it, but the bottom line is that it's taxpayer information without the approval of the taxpayer. And a lot of the reports that we issue, this report included, contain information that would have been violative of the law had it been prematurely released.
And the White House was informed about your audit on April the 24th, according to Jay Corney, the White House press secretary. But the White House took what I view as the more responsible approach. They were waiting until your report was final. To me, that seems much more in keeping with how draft Inspector General reports should be treated. In fact, let me read a quote from our chairman, Mr. Issa, who said this, and I quote, "This is one of those things where it's been, in a sense, an open secret, but you don't accuse the IRS until you've had a nonpartisan deep look. That's what the IG has done. That's why the IGs, in fact, exist within government to find this kind of wasted fraud and abuse of power," end of quote. And on this rare occasion, I do agree with Chairman Issa's statement. Do you, Mr. George?
You know.
I'm asking the witness. Do you agree with the Chairman's statement?
And I'm sorry, sir, I missed the quote that you were attributing to the Chairman.
Okay, I can read it again for you.
Thank you, sir.
This is one of those things where it's been, in a sense, an open secret, but you don't accuse the IRS until you've had a nonpartisan deep look. And that's what the IG has done. That's why the IGs, in fact, exist within government, to find this kind of waste and fraud and abuse of power. And I agree with the Chairman's statement in this instance.
I do also, sir.
Okay, there has been a lot of discussion recently about why the White House did not come out publicly as soon as they knew about the IG report in late April instead of waiting for the final IG report to be issued. And I think the terrible way the IRS handled this proves the point. And thanks to the IG's hard work, we now have precisely the type of nonpartisan, deep look Chairman Issa was talking about. So I want to thank you, Mr. George, for your hard work in this area. And Mr. Chairman, I will yield back.
I ask the gentleman to yield briefly.
I yield.
Mr. George, exactly in that line of questioning, based on the timeline you gave us, on May 29, 2012, the audit briefed the IG in advance of the IRS Commissioner's meeting. May 30th, IG and function heads briefed the IRS Commissioner, Doug Shulman, and the Deputy Commissioner, Steve Miller and Beth Tucker, on the audit, specifically that criteria targeting Tea Party patriots or 912, another key word, and other policies issues were being used in reviewing applications for tax-exempt status. You briefed, and that's your notes.
Yes, correct.
And so what you say on May 30th is they're targeting these groups. That's a confirmation. You reach the conclusion they're targeting them using these key words.
Yes. Now, just to be clear, I didn't take these notes up. These are accurate. Sir.
Right. Yeah, and I'm just using these because they were delivered to us from your staff. So on May 30th, there was a there, and you briefed Mr. Shulman and two others. On June 4th, you went on to brief the IG, or the IG briefed Treasury General Counsel Chris Meade on the same thing, correct?
That is correct, sir.
So in fact, the General Counsel at Treasury was aware that, in fact, these groups were being targeted in a conclusion that you made on May 30th and then again briefed them on June 4th, correct?
That is correct, sir.
Mr. Wolin, were you also aware that, in fact, this conclusion had been reached by June 4th?
No, no, I was not, Mr. Chairman. I think that the...
So this bypassed you and went to your General Counsel?
Well, I was not briefed on any findings when the Inspector General came to me. I think his testimony under oath in the Finance Committee and in the Ways and Means Committee was he briefed merely on the fact of the commencement of an audit.
No, that is not what the IG just testified to here, Mr. Wolin. I walked him through his own notes, these briefing notes that were given to us. The briefing was on the conclusion that specifically that criteria targeting Tea Party patriots or 912 and other policy issues were being used in reviewing applications for tax-exempt status. That's a conclusion that they were being used. Mr. George.
Chairman, I may have to clarify my earlier response to you. On the 4th of June, I had a meeting, and I regularly meet with the General Counsel, Chris Meade, or whomever the General Counsel is of the Department of the Treasury. At that meeting, I certainly made him aware of the audit. I do not keep notes of those discussions. I don't recall verbatim what it is that I discussed with him. I may have characterized the overall audit, but I certainly, I did not have findings then because the audit obviously wasn't concluded.
No, you had findings that you gave, and I'm calling them findings. Now, I have to remember I'm not an IG, that the term finding may be more technical, but you had reached a conclusion that criteria targeting Tea Party patriots, 912, and other policy issues were being used in reviewing applications. That's a conclusion that these criteria, these keywords were being used, and that ultimately we now understand how horrific this is on the face of it, correct?
I would say, sir, that I would have characterized part of the audit of looking at those issues. And so we obviously had not concluded the audit, so we did not have final determinations at that time. So I don't believe, and again, sir, I'm operating from memory here, and it was a while ago, and had no idea that this issue would come up in this manner. But the bottom line is I cannot say that with certainty that I said to him, this was definitively happening. I said, this is the allegation, this is what we're looking at, and
essentially you told Mr. Shulman sitting next to you that shots were fired to use an analogy, that there was a there. Now, a question of who fired him, what caliber it was, whether somebody was hit, you do a lot of detail in an IG report. As a matter of fact, it took a year. So a year ago, Mr. Shulman was told that, in fact, there had been targeting. And Mr. Shulman has already testified that essentially the reason there wasn't further action was that it was over as far as he was concerned, in that although you were briefing him that they had targeted, I believe Mr. Shulman testified effectively, and I'm paraphrasing you, sir, so correct me if I'm wrong, that basically your reason for not doing further was, although you now knew that they had inappropriately targeted people, that in fact it was now no longer happening. Is that correct?
I said that, you know, to the best of my knowledge earlier today, to be clear, I mean, when I learned that the IG was going to be looking into it and that the practice was being stopped.
Okay. And the May 30th, what I read to you about that targeting, the May 30th briefing in 2012, the IG's briefing of you, Mr. Miller, and Ms. Tucker all occurred, and you were in that meeting.
Yeah, but the language you used there, that there was a conclusion of targeting, is not my recollection of the meeting.
This is not my language, this is the IG's.
No, I hadn't seen that language, but my recollection is, you know, that Mr. George said they were looking into the allegations.
Thank you. Mr. Massey.
Mr. Chairman, today we're here to repair the trust of the governed in their government. But to repair the public trust, we have to fix the problem. And before we can fix the problem, we have to define the scope and the type of problem that we have. Mr. Shulman, how many employees work for the IRS?
About over 90,000 employees.
So over 90,000 employees work for the IRS. And how many work for Mrs. Lerner?
She stated 900 today. I don't know the exact number, but that sounds about right.
Now, the behavior of some of those 900 employees has been described by Mr. Wolin today as inexcusable and deplorable. Do you accept responsibility for that behavior of those employees?
I've said before that I am incredibly saddened by this event, that it occurred on my watch.
I heard that answer before, so I'm asking, do you accept responsibility for their behavior?
I don't accept responsibility for putting a name on a list with
Mr. George, did I hear you refer to some of the behavior as gross mismanagement earlier in your testimony?
That is correct, Congressman.
And that was at the Cincinnati office?
That's correct, sir.
Would you have been referring to either or both Mrs. Paz and Mrs. Lerner?
I wasn't referring to any individual in particular, but I just want to actually revise what I just said. The gross mismanagement was not limited solely to Cincinnati. It extended to Washington.
Okay. Mr. Shulman, realizing that you do not accept the responsibility for the behavior of all the employees at the IRS, do you accept the responsibility for the mismanagement that occurred at the IRS?
Look, I'm very sorry that this happened while
I understand you're sorry you said that before. Can you answer that question?
I don't know generally what you're talking about. I don't accept the responsibility for every single action of every single employee at the IRS, but this did happen on my watch. I accept that.
Mr. George, you mentioned before that there were lists that were used as triggers. They were called be on the lookout lists. But some of these were used as triggers to refer cases to the fraud division or to state and local governments. Is that correct?
That is correct, sir.
Okay. So my constituents whose trust has been damaged in their government are now asking me, were they audited because of lists? And Mr. Shulman, can you guarantee to us here today that there were practices in place in management such that none of these audits would have been triggered by a list such as we've seen the list today?
For your constituents?
Yes.
Look, I don't believe of it that audits were triggered because of it.
Can you guarantee that they were not?
No, I can't.
Okay, that concerns me. We've got to fix that before we can fix the trust in the government. Mr.
Mr. George, you stated that there were 143 unauthorized disclosure cases that were started in the last year?
That we looked at last year, yes.
And I know you can't comment on the particular cases, but would you expect some of those to be confirmed leaks from the IRS of confidential information? Or in the past, have you ever
respond to that? Unfortunately, I'm being instructed by counsel that I cannot acknowledge the results of those investigations, Congressman.
Okay. Can you acknowledge results of prior investigations? Can you acknowledge that a leak has ever been confirmed, that anybody's private information has ever been released?
We don't have an answer to that, sir.
Okay. Mr. Chairman, we need more hearings. We need more investigations. We need to get to the bottom of this. I think people working for the government right now need to be fired for abusing the public trust. But let's not delude ourselves. We're just treating a symptom of the disease. And the disease is a bloated, abusive government that has become self-serving. We've seen that Mr. Shulman has stated he can't be held responsible for 90,000 employees. I doubt any man or woman could be held responsible for a bureaucracy that's 100 years old that has that many employees. We sit here comfortably on the dais questioning three men here today, but I think Congress created this monster. We need to look inward. We have 70,000 pages of tax code, 90,000 employees that work for this bureaucracy. And a lot of this tax code is open to interpretation. I think it's ripe for corruption and abuse. And I think in order to restore trust, the public trust, we're going to have to address this issue. And I think Congress needs to take it upon itself after today to shrink the size of the IRS, to simplify the tax code, and to restore the public trust. Thank you, and I yield back.
We now go to the gentlelady from New Mexico, Ms. Luan Grissom.
Thank you, Mr. Chairman. Certainly the tone of this hearing in a bipartisan fashion has been that any government agency targeting in any way any inappropriate investigations or information is deeply disturbing, and the fact that it's the IRS just makes that even more troubling. And I don't think there's a member on this committee who doesn't also agree that we want a thorough and complete investigation, and we want all those held accountable, and then we want steps implemented there and everywhere in government to make sure that this never happens again. And I certainly want to be on the record echoing those statements and am deeply troubled as well. But I do want to talk about 501c4s. Now, Mr. George, your report explains the lack of clear guidance on how groups are determined to be eligible for tax-exempt status were one factor that contributed to the terrible decisions made by IRS personnel. But one key reason, in my mind, that this problem even exists is because of the difference between the original statute Congress passed and the regulation the Treasury Department subsequently issued. The original statute passed by Congress provides that organizations may qualify under a 501c4 only if they engage exclusively in social welfare activities. That seems fairly clear that political activities are not allowed at all. But in 1959, a regulation was issued provided that entities could qualify under 501c4 as long as they engage primarily in social welfare activities. These groups now believe they can spend up to 49% of their funds on campaign-related activities. Now, this goes to Mr. Wolin. Requiring organizations to be primarily engaged in social welfare activities is significantly different than requiring them to be exclusively engaged in social welfare activities. Wouldn't you agree?
It is, Congresswoman.
All right, Mr. Shulman, would you agree?
Yes.
And Mr. George, would you also agree?
About whether or not clarification is necessary, most definitely.
And would the three of you support that maybe Congress should make this even clearer? It seems to me that this issue, this regulation was issued fairly arbitrarily.
Well, Congresswoman, as I said earlier, I think that this is an area that requires additional clarity. The IG's report recommends that we at Treasury, working with the IRS, provide that clarity. We will get to that right away, working with the new acting commissioner.
Mr. Wallen, while you do that, it is now my understanding that in addition that the Treasury Department plans to start investigating further 501c4s to determine if they have spent more than the 49% on political activity. Now, if a 501c4 in this review violated the law and used more than 49% for political activity, will the names of those donors who donated to those 501c4s be released?
Well, Congresswoman, the Treasury will not be investigating 501c4s. That's not within our purview. And again, it's important, I think, just to reiterate that the Treasury not involve itself in matters that relate to the administration of the tax code, and particular ones that have these kinds of political overtones.
Well, and then maybe it's my understanding that Mr. George?
Actually, yes, it will be my office. We have committed to doing just that type of an examination.
And will those donors' names be released?
It's highly unlikely because of, again, privacy or confidentiality restrictions that are placed upon us.
But the issue would be that those donors would then be required, if there's a violation, to pay taxes on those donations, would they not?
I cannot give that.
Would the gentlelady yield? If you go, if you go to Organizing for Action, President Obama's 501c4, you'll note that it says contributions are not tax deductible. This is about the entity not paying taxes, as I understand it. If you're declined a 501c4 status, some of these organizations 3 years, under certain circumstances, you then have to pay corporate taxes on this as though it was income. You then could even have your officers and directors personally responsible. But it's not a C3. These are C4s, and I'm sure that we have people here that could define the difference. But it's real important to understand this is about if you were, for example, were determined to be a 527, nothing would change, except, as you said, the potential names. 501c4s, 527s, the difference is not really a taxable event.
Mr. Chairman, I appreciate that clarification. However, if I'm not clear that some of these organizations provide the right disclosures, I'm not clear that folks who are providing donations to those organizations are clear about those rules, I'm not clear based on the scope of this investigation to date that we've got clarity about whether folks really are qualified as a 501c3 or a 501c4. And as we uncover more information about those donors, those differences, those investments, and the engagement of activity of these organizations, it seems to me if there are violations made, the disclosure of donors in a violation and taxes be recovered if they so apply should be done by the IRS.
I appreciate the gentlelady's comments. Would somebody clarify for the record the taxation policies so that that can be clear? Because I think there's a, Mr. Shulman, you certainly know the difference. There's obviously a huge misunderstanding as to the taxability and the ramifications, what you really get on a 501c4 versus 527.
There's a chart actually in the Inspector General's report, I think, that has the different taxable entities and the different.
Right. I mean, 501c3 is a big deal, 501c4 less. Mr. George? To the extent that you can answer to clarify for the lady.
Yes, certainly. A 501c3 may do the following. They may receive tax-deductible charitable contributions. They may not engage in political campaign intervention. They must publicly disclose the identity of the donors. I'm sorry, they may not disclose the identity of the donors. They may engage in lobbying, limited but must not be substantial. They may engage in general advocacy not related to legislation or the election of candidates, but it has to be an educational activity, and they must apply with the Internal Revenue Service for their 501c3 status. Now, as to 501c4, 5, and 6s, no, none of their contributions are tax deductible. They may engage in limited political campaign intervention, but again, it may not be their primary activity. They do not have to disclose the identity of their donors. They may engage in lobbying, but it has to be in actually an unlimited amount of ability to do that if it's in furtherance of the taxes purpose for which they were established. As it relates to general advocacy, they may also do so in an unlimited way, as long, again, as it's in furtherance of their tax-exempt status, and they do not need to apply to the Internal Revenue Service for this status.
Thank you. The gentlelady, I presume, is satisfied.
I am not, Mr. Chairman.
Well, we'll make additional information available, but
Can I make one statement, Mr.
Of course.
Chairman? Thank you so much. To the issue that in a 501c3, which I'm clear about the differences between, and I appreciate doing that for the record, sir, 501c3s and 501c4s, donors are not required, you don't have to, the 501c4 doesn't have to disclose donors. Correct. If they have violated that political activity premise, just like a 501c3, I'm making the argument here that they should have to then disclose those donors. And now that you're disclosed, I want to make sure that appropriate taxes have applied to that person's personal income as a result of knowing that they've made contributions that were not disclosed in any form, so that there is a double check. In the same way that the IRS receives independent information about my income, what I receive and what I don't receive.
Well, the gentlelady may turn the tax code upside down if she would like. I suggest you find co-sponsors, but the fact is that these individuals give money post-tax. They pay their taxes and they give the money out, and they do not control the organization. So the idea that they would take on personal responsibility for their contributions and somehow be double taxed, perhaps the gentlelady would reconsider the chilling effect, whether it's a 501c3 or 501c4. And with that, we go to the gentleman from Georgia, Mr. Collins. I'm terribly sorry. We're going to Mr. Meadows. I'm reading the list. I should look at the gentleman first.
All right. Thank you, Mr. Chairman. And I want to follow up on some of your line of questioning there as it relates to, and I want to make sure that I understand you, Mr. George, on May 29th of 2012, almost a year before the official report came out, you were briefed, and as my understanding, you specifically knew at that particular point that there was a criteria that was being used to target the Tea Party Patriots 912 group. Is that correct?
Actually, sir, that was my final briefing on this matter during the course of the audit.
Okay, but this is May 29th, 2012. Is that correct?
That's correct.
All right. And so on May 30th, the day after that, you actually briefed Mr. Schulman, Deputy Commissioner Steve Miller, and Beth Tucker on this new audit, and using that same criteria that it was being used against Tea Parties. Is that correct?
Sir,
that's what your notes say.
Yes, but you know, my colleagues behind me who were in attendance at the meeting.
Right. It said function heads, so I assume they were your function heads.
And they indicated we had some indication at the time that the allegations had merit, but we did not characterize. We cannot. I'm not in a position now to characterize the level of detail that we had at that point.
I'm not asking about detail. Was there a separate criteria used for those groups? A separate criteria used for Tea Party groups that you just amended to just a few seconds ago?
You know, again, sir, I'm not certain as to exactly.
Well, is your function heads, are y'all familiar with it? We have notes that would indicate that there was a separate criteria used.
Yes, sir. I was just informed that we knew there was a criteria. We didn't know the nature of the extensiveness of it, sir.
So we know that it was separate, though.
Yes.
And you, the gentleman to your left, you did notify him of that on May 30th of 2012.
That is my recollection, sir.
Okay. Then on June the 4th, this note says that you briefed the General Counsel, Mr. Chris Meade. So you briefed him of a separate criteria in the Treasury Department on June the 4th, 2012. Because all of a sudden, you know, all of this is supposedly it's just happened, but this is well over a year ago. So you briefed the General Counsel, the Chief General Counsel of the Treasury Department, well over a year ago.
I did. I have to acknowledge that in the briefings that we hold with the Commissioner of the Internal Revenue Service, I have my subject matter experts in the room.
So you went by yourself to the General Counsel, and so you may not have given them the complete story.
I'm certain that I did not give them the level of
Why would you have not given them the complete story if you had just done it a few days before?
Well, because the Commissioner is the person who we directly oversee. I actually have.
So this was a courtesy call.
It is a courtesy call, sir.
So a courtesy call to the General Counsel.
Yes, it is.
All right. Let me go a little bit further because I'm troubled by some of the things that have been said. We've got Lois Lerner. Why would she have been privy to all the interviews and know exactly what the interviews were going on during this process? Why would she have known that?
I'm glad you raised that, sir, because it was raised much earlier. My understanding, and again, I was not privy to those meetings. I was not in attendance.
Okay, let me ask you another question, because my time's running out. Holly Pass, why was she in almost all the interviews that you conducted? You talked about original and proper protocol from an audit standpoint. She was in these meetings with her subordinates and other people. Why would you have somebody from the IRS in all of those meetings?
You know, well, first of all, in some instances, they...
Is that proper protocol?
In some instances, it may be.
Well, I know when you get audited, you keep people separate. Why would you do this and put them together?
Well, because in some instances, they have collective bargaining units.
So this was all because of collective bargaining?
Well, no, I was just told that Holly was requested to leave when we were querying the IRS staff.
Yeah, but she was in 36 of 41 interviews, Mr. George, that requested to leave. She was in 36 of 41 interviews.
I'm unaware of it. This is the first time I'm hearing.
So are you gentlemen aware of it? I mean, just talk to me. You've been going back and forth.
Nope.
So this is the first you're aware of?
Well, none of the gentlemen here would have conducted those interviews directly, sir. And so...
Well, I just was past this. It was in the document that you've given us. It was in the document that you've given us. So are you just giving us stuff that you're not aware of, Mr. George?
I don't know which document you're referring to, sir.
I'll be glad to give it to you.
Okay. Thank you. What is this? What is this? Who put it together?
I just find it highly inappropriate.
Sir, this was put together by auditors, as you can see, of some of whom are in Washington, many of whom are in Washington, but some of whom are not. These are level.
Well, that's my point. This is not isolated to 2 people in Cincinnati. This has a whole lot of people in Washington, D.C. And why would she have been part of it? Would you normally conduct an audit in that manner?
You know,
the gentleman's time has expired. You may answer, though.
Congressman, I would respectfully request the opportunity to look further into this and to report back to the committee, because this is the first time that I was made aware of this, and I really don't have information about it.
I thank the chairman.
Thank you, and we will allow the gentleman time to do the research and get back with us. We now go to the gentleman from California, Mr. Caderas.
Thank you very much, Mr. Chairman. TICTA made 9 recommendations detailing how the IRS can improve its process for reviewing applications for 501c4 organizations. Mr. Wellen, who at the Treasury is working with the IRS to ensure that these recommendations are fully implemented?
Well, most of them, Congressman, are focused on actions for the IRS to take, and so the new acting commissioner, Mr. Werfel, will be quick at work on those. There's one that we've discussed here in this hearing that relates to better guidance with respect to this question of whether entities are meant to be 501c4s or not, and that has a role for Treasury as well as the IRS on that guidance. But in any event, the Secretary of the Treasury, Mr. Liu, has charged Danny Werfel with getting back to him within 30 days to report on his progress in implementing the recommendations from the IG report, plus whatever other steps he feels are necessary to make sure that this misconduct does not happen again.
Okay. And Mr. George, what can you say about that?
Mr. Werfel reached out to me last week, Congressman, and requested my assistance in helping address many of the issues that we identified, actually all of the issues that we identified in our audit report, and I have committed to doing just that to assist him. So we are going to do our level best to help guide him as he's attempting to address our recommendations.
And what has the tax-exempt division regarding this implementation? What have they shared with you?
I have had no discussions with the tax organizations division thus far. I don't know whether my colleagues have, and if you'll beg your indulgence.
Sure, please.
Yes, no. Apparently not yet, sir.
Okay.
But we will starting
That was my next question. When you say you will, is there an intended timeline? Is there a goal?
Mr. Warfield and I have committed to meeting next Monday, or actually Tuesday. Monday's a holiday.
So as early as next week?
Yes.
Okay. 8 of TICTA's 9 recommendations are directed towards the exempt organizations office and the tax-exempt and government entities divisions of the IRS. In a few cases, the exempt organizations office and TICTA did not see eye to eye on the specifics of some given recommendations. Can you share with us what the disagreement was and why?
They, in a couple of, well, first of all, it's overtaken by events, actually, Congressman, because when they initially provided us with their response to our recommendations, it was before the President directed them and then through the Secretary subsequently to adopt all of our recommendations. But to answer your question directly, in some instances, they indicated that they had already addressed the problems that we identified and 1 or 2, like posting information on the Internet for the public. I do have the detailed response, but it's not before me. If, again, with the Chairman's permission, I would like to submit that for the record. But the bottom line is they have subsequently now agreed to adopt all of our recommendations, and that's, I think, the ultimate goal.
Including posting the process online so that people could understand what's going on behind that IRS curtain with their application.
Now, if they come back with an extraordinarily plausible reason, again, citing confidentiality or security or what have you, we would obviously take that into consideration. That was not their initial objection, but but they have committed to adopting all of our recommendations, sir.
So I anticipate this is not the last hearing we're going to have on this. So as you progress and have that dialogue and you have that back and forth, is there any reason that you anticipate that you could not share with this committee what their responses are and what their intended cooperation with these implementations are?
Excuse me, sir, I will commit to doing so, but we've also committed to conducting a follow-up audit to ensure that they have accomplished the goal of achieving the recommendations that we established.
Okay. And you mentioned that the President directed the Treasury to implement all of your recommendations. And so as far as you can tell, there hasn't been any resistance to since then?
I haven't, but I yet have had my meeting with Mr. Warfield, but I assume they're going to follow the President's instructions.
Yes, please.
Congressman, there will be no resistance. We accept the 9 recommendations from the IG as they were written. I think the President and the Secretary and I have all made that clear to Mr. Warfield, and I think he is 100% on board.
Well, I'm sure that with an organization like the IRS, there's probably never going to be 100% contentment with every American with this particular department, yet at the same time, I think that the timeliness of you being able to, all of you being able to do your part and to restore confidence at least around this issue, that we can do that as expeditiously as possible. I yield back the balance of time. Thank you.
Thank you, and I'll note to gentlemen, we have 2 additional members to ask questions. Then we're going to go to 5 minutes aside as the limited second round, and then we'll dismiss our witnesses for today. At this time, we go to the gentleman from Michigan.
Thank you, Mr. Chairman. Mr. Schulman, I've got to hand it to you. 5 hours under all this questioning, and you've been able to maintain some coolness, calm. But at any time, did you ever feel uncomfortable, intimidated by the questioning going on?
Congressman, my goal today is to try to answer your questions.
Okay, so you didn't feel the same thing my constituents feel when they get a letter from the IRS, or that I felt when I was reading a memo that said how the IRS deemed educating on the Constitution and Bill of Rights to be a political act. Does the IRS still believe that educating about the Constitution is a partisan political act?
I don't know what the IRS believes, but if you're referring to the criteria in the report,
right,
I would agree it's inappropriate.
It's inappropriate. You know, can you imagine how I felt as a former school teacher teaching Constitution and the Bill of Rights, and thinking about, wow, I could be subject to an IRS audit simply because I'm doing my job? Do IRS agents take a class on learning about the Constitution and Bill of Rights before joining one of the most powerful agencies in the Federal Government?
I don't know the answer to that question.
Okay. You do teach ethics, correct?
I do.
Or the IRS requires ethics training?
Yes, there's
but not the Constitution.
I don't know the answer to that question.
Yeah, the answer is no. I understand that they take training classes on ethics, but specifically about the Constitution and Bill of Rights, you don't know that. Given their power to destroy businesses and audit individuals, do you think it would be useful for the IRS to require all of its employees to take a class studying the Constitution and Bill of Rights in order to make positively sure that they understand the concept of government restraint created at our founding?
I think it's very important that IRS personnel be well trained.
Did you study the Constitution? You're a lawyer, are you not? Or an attorney?
I went to law school.
You went to law school. Did you study the Constitution?
I believe I took constitutional law, but I'm not prepared to take an exam at this time. Meaning, I'll answer any of your questions, but I can't promise, you know, I'm an expert.
Expert. Well, you know the First, Second Amendment, and one of my favorites, the 19th, right? You know those.
Excuse me?
You know those
I told you I'm not.
The constitutional amendments. You know the first, you know the second, and you know the 19th.
I don't necessarily have the Constitution memorized, sir.
Okay. Well, they're pretty general. I mean, in what each one is. Like First Amendment is freedom of the press, freedom of religion, and freedom to petition the government for redress of grievances. First Amendment, right?
I really can't recite the Constitution, sir.
Okay. Do you understand what? Do you know what the word T in Tea Party stands for?
I do not.
It stands for taxed enough already. That's contrary to what the IRS wants, I think, because they want to tax as much as possible, don't they?
The IRS's job is to administer the tax laws that are on the books.
Mr. Chairman, I yield back my time.
Would the gentleman yield?
Yes.
Just briefly, I want to make sure this gets properly in the record. Yesterday we had a transcribed interview, and I'm going to ask unanimous consent to place at this time pages 189 and 190 in the record, without objections, so ordered. And I would just read very briefly from it. This was to Ms. Paz. When we asked her about, did you ever accompany any other employees to their interviews with TIGTA? And she said, yes, I sat in on all the interviews, but the arrangement we had worked out with TIGTA was that I would leave at the end of the interview so they could ask anyone interviewed any questions they wanted to ask without anyone else present. So that was done. Is that correct, that her testimony that she was in at least what she thought was all the interviews, and that she left for a short time at the end?
I've been informed by staff that that is accurate, sir.
Thank you. And we went on with Mr. Hickson, one of my staff attorneys, asked, and he is an attorney, he didn't just go to law school, how did that arrangement come about? When TIGTA approached you about conducting their audit, did you request that you be present at all the interviews? Ms. Paz answered, yes, I believe, ... I can't remember if I made the request or Lois Lerner made the request, but we discussed that in order for the IRS to be able to respond to the report, we had to understand what information TIGTA had and what they were being told. Mr. George, you're a seasoned investigator. Those individuals who did that on your behalf, is that routine to basically let the target of an investigation/audit sit in so they know the questions and answers when they later may be a target of misconduct?
The operative word, Mr. Chairman, is audit.
Okay, so I'm going to stop you there.
Yes.
Because this was an audit, it was conducted much more, if you will, like people coming in and just going through the books to find out, you know, how much more taxes you owe, right? It wasn't conducted as an investigation.
That's correct. It was not conducted as an investigation.
Okay. I'm going to conclude later during the last 5 minutes. Sure. Go ahead, Mr. Cummings.
Let me make sure, just for clarification and truth. Usually, when you are conducting an investigation, I know this was an audit, I got that. You want to keep your witnesses separate because you're in search of the truth, and you're trying to make sure that there is no advantage of a person hearing what somebody else said. As a matter of fact, I mean, that's just pretty standard procedure. And can you tell us what the difference is and why there is, if there is a difference, with the way you all proceed with regard to audit, that is allowing somebody to listen to testimony? I think that would be clarifying for all of us, because, you know, maybe an audit is conducted differently, but it would seem to me that even in an audit, you're in search of truth and accuracy. And then where there's a, if there is a conflict, then you figure out who's inaccurate or maybe who's lying, but then you figure out how to get to the truth. But when, you follow me?
I do, Congressman, and again, each case is different. I am not privy yet to the details of these interviews as I just learned about this, but I have to say that, again, the operative word that you used is the truth. We want to make sure that the information that we receive and act upon is accurate. And sometimes it is beneficial to have more than one person in the room who may have worked on the same matter, so that in case some person doesn't recall a particular decision, action, activity, the other person might, and that might click the memory of the person who we were originally questioning. So it really depends on the circumstances. Now, in hindsight, given this matter, obviously this seems somewhat unusual. I need to do a little more research.
This is just 30 seconds. Based on what the chairman just read, it sounded like Ms. Paz was, she felt like she needed to be in the room because she wanted to be able to defend herself or the agency, I don't know, based on what may have been said or information gathered in that interview. And that seems like it goes against what you just said.
Again, hindsight is 20/20.
All right. Okay. All
Thank
right.
you. I thank you for your comments. We now go to the gentleman from Florida.
Thank you, Mr. Chairman. Thanks to witnesses for toughing this out. I'm just a little still stunned by the beginning of this hearing. We are investigating the IRS targeting groups who, among other things, educate about the Constitution and the Bill of Rights, and yet we have one of the officials potentially responsible for that invoking one of those constitutional rights. So it was a startling thing. Let me ask Mr. Wolin, just so I get this right. IRS reports essentially to the leadership of the Treasury Department and then the President. Is that the proper chain of command, so to speak?
It is, Congressman. Okay.
And Mr. Schulman, I noticed that you've made obviously a lot of trips to the White House. That was discussed. You also have met with the President in 2010, one occasion, and then twice in 2011. Is that correct?
I don't know the exact dates of meetings. So
well, I didn't ask the dates, but is that about 3 times during that period? Is that, I mean, we just have the log. That's what it says. June 29th, 2010, February 3rd, or excuse me, June 6th, 2011, and December 2nd, 2011.
I have memory of 2 of the meetings. I'm not sure I have memory of the meetings.
Now, we don't yet have the log for 2012, but did you ever meet with the President in the White House during 2012?
Was the last date, could you give me the last date?
The last date that we have is December 2nd, 2011.
I'm sorry, I was referring to a December 2012 where I had a photo taken with my family.
So is that the only date you remember from 2012?
So my memory, that's the only date I have any memory of with the President in 2012, except for perhaps a holiday party or some such.
Okay, so when you were going there, were those discussions, or what were those discussions about? The Affordable Care Act, 501c4s?
The discussions with the President? I don't remember having extensive conversations with the President. The first conversation that you referenced was about the tax gap and tax collection in general and how the IRS works and how to collect the proper amount of revenue for the government. That's my best recollection.
So that is the extent of the substantive conversations you had, or were there other topics discussed? I mean, I understand you're busy. I understand you meet a lot of people, but most people probably remember when they meet with the big guy.
No, that's the extent of my memory, and I also, now that you bring this up, I haven't looked at these dates. I'm not at the agency anymore. I also had a discussion once where he convened a number of agency heads talking about how to improve the government generally.
Now, according to these logs, it was pointed out that there were over 100 times where you visited the White House generally, I think 118, and there are 46 of them. There's a purpose of health care, and it looks like it started in April of 2010 and really continued throughout 2010. So when you were going to discuss health care, was that specifically to discuss the Affordable Care Act, a.k.a. Obamacare?
The IRS was tasked by Congress to have a role in the Affordable Care Act, and I had a number of conversations with, at OMB and the White House about that.
One of your predecessors, Commissioner Everson, he testified about this issue with the Affordable Care Act. He said that he didn't really recall ever going to the White House for policy discussions. I think he said he may have gone one time, and he said that he worried about the IRS being this intimately associated with kind of a signature initiative, that it may actually hurt the IRS ability to conduct its core function of tax collection. Do you believe that there's a danger in that?
I believe the IRS is part of the executive branch, and when it's tasked with a major job of implementation, it needs to have proper coordination.
Well, that didn't really answer the question. I mean, putting this new, which could be a very intrusive burden in terms of American citizens having their health care, being involved with the IRS, to be able to do that is obviously going to require resources and manpower. And I guess my question is there a danger that that could take away from the traditional functions of the agency?
The IRS is, when people think about the IRS, they think about collecting taxes. They don't think about figuring out application for tax-exempt status. They don't think about a lot of things. So over the years, Congress has loaded the tax code with many, many different functions, all within the tax code, and the job of the IRS is to administer the tax code. So I really, the IRS is going to do what Congress asks it to do.
All right. I just note that it still didn't really answer the question, but I will yield back to the chairman. Thank you.
I think the gentleman, we're now going to go for this last 5 minutes that I mentioned each side. Mr. Cummings.
Thank you very much, Mr. Chairman. I'm going to be very brief. And this is something that we have not talked about yet, and it's something that I just want to get you all's opinions on. Mr. George, there are some organizations that if the tests for tax exemption under these circumstances were administered fairly, might not meet the test. Is that a fair statement? You understand what I'm saying? In other words, there's a law, there are standards, and some organizations, I'm not talking about the ones here, but I'm talking about generally, might not meet the test.
I guess
for tax exempt status.
I'm sure in theory you're at.
Yeah, I'm talking about in theory. Yes. Let me tell you what I'm really concerned about, in addition to all the other things that I've said. I'm concerned that all of this may have a chilling effect on employees, where they say, when normally we would, look at certain criteria fairly, not targeted anyone, but say, uh-oh, I'm worried because I better let this go. Let's say, for example, we were talking about audits. And they say, uh-oh, I'm not going to do this because I may be called in and told that I didn't do things properly. You follow what I'm saying? And so then the organization does not do what it's supposed to do. Are you following me?
And not only am I following you, sir, there's evidence to that effect with the passage of the Restructuring and Reform Act of 1998. And with the deadly sin, the top 10 deadly sins, there was a steep fall-off in IRS enforcement because IRS employees were afraid to be very aggressive as it relates to trying to recover money.
And I'm just wondering, how do we strike that balance? I know one thing, Mr. Wolin, is making sure the law is clear. Another thing is making sure that there's some kind of guidelines that are consistent with fairness. What else can we do? Because we got to have that balance. We cannot have employees who are sitting there shaking like a leaf on a windy day, believing that if they fail to properly do what they're supposed to do, they may get in trouble. But they also have to know that what their guidelines are. And I'm just curious. Now, you said that you're going to have a conversation with Mr. Woelfel, the new commissioner acting, and I'm just telling you, I'm trying to figure out how does all that, taking what I just said into consideration, how do we help him to create an atmosphere where the employees can still do what they are supposed to do in the way they're supposed to do it, without feeling threatened. Does it make sense?
It makes complete sense. And just to be clear, it's more than a conversation, Congressman. We are going to work with Mr. Warfield. If he has the ability to make sure that his employees are trained, if they know that they have his confidence and he has their back, I think it'll help address some of the concerns that you're alluding to, sir.
Mr. Walden, do you have a comment?
Congressman, I think that it starts with leadership. He has, I think, an impeccable record, Mr. Werfel, and is very well suited to hit the ground running to make sure that he starts the path toward restoration of not just the public's confidence in the IRS, but also, as you're pointing out rightly, sir, the employees' capability to do the job, the important job they need to do. And I think that that partly is about holding people accountable for misconduct that occurred, and it's partly about putting in place procedures and policies and a culture that makes sure that these kinds of things don't happen again, that people are appropriately trained, that there's clarity about what the rules are, and so forth. And that's the process that he's begun today and will really move forward with focus on, and with our full support.
As I said at the beginning of the hearing, this is about trust and truth. And I want to thank all of you for being here today. This is an ongoing process. But I want us never to forget that it's not enough to just investigate. We've got to bring about reform. And this is I think there are moments that come in life, as I close, Mr. Chairman, there are moments in life where incidents happen. And at that moment, we must take advantage of the moment, because the moment will tell us that we need to change things and do something in a different way. But if we let that moment pass, usually things only get worse. And so I'm hoping that you all will, I know you left, Mr. Shulman, but I hope that we can get your cooperation in any way that you may be able to do it. Mr. Wallen, Mr. George, I hope you'll keep that in mind, because the American people are very concerned about this. And Mr. Chairman, I want to thank you for, I think, what's been a very good hearing.
Thank you, Mr. Cummings. Out of the 5 minutes, I yield 1 minute to the gentleman from North Carolina.
Thank you, Mr. Chairman. Mr. Shulman, with this internal investigation that was done originally, am I correct in the person that headed that up, that left from Washington, D.C., and went to Cincinnati, was actually the special advisor to Sarah Hall, who is now over our health care? Is that correct? Mr. Miller employed her to go and do this internal investigation.
As I stated earlier, I don't know it.
So you have no idea what happens below you at all?
No, that's not what I'm stating, that I actually didn't know it and didn't be an internal investigation.
But you agree that it was her, and she is the special advisor to Sarah Hall, who is now over our health care?
To the best of my understanding, and I've read the report, that's where I see it was special advisor.
Did you ever talk to Mr. Miller about that? Who was going to head it up?
I think
do you know who Ms. Marks is?
Yes, Naomi.
Okay. Was she the special advisor to Sarah Hall?
I don't know. I think at the time, my best recollection is she was special advisor
there's two
to
C's
Joseph
here.
Grant.
Either there's a cover-up or it's an extreme lack of curiosity on your part. I yield back.
I thank the gentleman. We now go to the gentleman from Ohio, Mr. George.
I thank the chairman, and I want to direct my questions to Mr. George. Let me first, putting aside the fact that I do think the audit was compromised by what both the chairman and the ranking member asked you about, talked about earlier, with the interviews being conducted in the way they were with Ms. Paz present in almost all of them. But what I want to go to is the timeline you gave us, the TIGTA timeline. And on March 8th, you all met with Oversight and Government Reform staff, you with the folks back here, and you talk about this issue. Then you decide to do an audit. That meeting took place March 8th, 2012, when you first met with Oversight staff. Then you decide to do an audit. On May 29th, you brief the IRS. May 30th, you brief the IRS about some preliminary findings. You give them a heads up, but it's not just a heads up about we're doing an audit. It's a heads up we're doing an audit, and oh, by the way, we have discovered that Tea Party Patriots 912 identifiers were used in groups applying for tax-exempt status. Looks like 5 days later, June 4th, you give the same kind of heads up to the Treasury General Counsel, Chris Meade. So I really only have one question. Why didn't you give us a heads up?
Actually, Congressman, if you look closer to the top of the timeline, it was March 1st that my office was contacted by staff of this committee.
Right.
And we were requested by this staff to look into the matter.
No, I get that. Right. We asked you to, but a few months later, you're telling both the IRS and the Treasury Department that so far in this investigation, we have uncovered that Tea Party Patriots and 912 were used to identify groups and single them out for different kind of treatment. Why didn't you tell us the same? We'd like to know that information. All we knew from you was, okay, we're doing an audit. In fact, we hadn't even formally requested the audit. Mr. Issa and I sent a letter to you on June 28th. You've already given those guys, the IRS and the Treasury, the guys sitting beside you, you've already given them a heads up about some initial findings. We didn't. The first time we heard about that in any public way was a few weeks ago. So all I'm asking is, why didn't you afford us the same opportunity you gave them and say, oh, you know what? We are doing an audit, and we found that these terms are being used.
But again, sir, if you look through the timeline, there have been communications between...
Yeah, but you've never once told us what you just wrote in writing. You told them. You think it makes sense for people to ask the question? You're giving a heads up to the Democrat administration about the terms Tea Party, Patriot, 912 being used, but you're not going to give a heads up to the Oversight Committee, the very committee who oversees the Inspector Generals in our government, the very committee who asked for the audit, and you don't give us the same heads up, which includes those identifier terms? You don't think that's unusual in an election year?
The gentleman's time is expired. Please go ahead, Mr. George.
Sir, I was not at these briefings, so I'm not certain as to exactly what information was communicated.
This is your stuff. You lay it out. You tell them those terms, and you don't tell us, and somehow that's fair, and we're the ones asking for the audit?
Well, but once again, sir, this is not exhaustive in terms of what was communicated, and but those were...
So are you telling us you told this committee about the terms Tea Party, Patriot, and 912 being used in 2012? You instructed this committee that those things were being used in 2012. Did you ever communicate with anyone on the Oversight Committee or any member of Congress about that?
The gentleman may answer, but that will be the end.
Yes, I did not have discussions with...
Of course you didn't. You just talked to them.
My staff did, sir.
Thank you. Thank you. I really have no time left in the 5 minutes, so I will close this by saying that we will work. I've directed my staff to work along with the minority staff on an analysis with your office of the timeline of the initial audit period, and quite frankly, to come up with some future guidelines as to when an audit should turn to an investigation. I understand from your earlier testimony that when an investigation begins, an audit ends. It is a consideration of this Chair that there was a time during this audit in which the knowledge was sufficient of the primary activities that did occur that an audit at least possibly should have been converted into an investigation, which I think would have changed a great deal of the procedures that we've had a discussion about here today. I'm not going to make any further judgment this time. I'm going to ask my staff to work with your staff and the minority staff so that we can sort of put this together into a package and not be doing any, not limiting to this preliminary timeline, if that's acceptable with you, Mr. George.
It is, but again, sir, we can speak offline because
thank you.
There are certain protocols. These are criminal versus civil.
Right, and that's the reason I think this hearing is not the place to go flesh it out further. And with that, excuse me, at the beginning of this hearing, I called 4 witnesses. Pursuant to a subpoena, Ms. Lois Lerner arrived. We had been previously communicated by her counsel, and she was represented by her own independent counsel, that she may invoke her Fifth Amendment privileges. Out of respect for this constitutional right, and on advice of the committee counsel, we in fact went through a process that included the assumption, which I did, which was that she would not make an opening statement. She chose to make an opening statement. In her opening statement, she made assertions under oath in the form of testimony. Additionally, faced with the interview notes that we received at the beginning of the hearing, I asked her if they were correct, and she answered yes. It was brought up by Mr. Gowdy that, in fact, in his opinion, as a longtime district attorney, Ms. Lerner may have waived her Fifth Amendment rights by addressing core issues in her opening statement and the authentication afterwards. I must consider this, so although I excused Ms. Lerner subject to a recall, I am looking into the possibility of recalling her and insisting that she answer questions in light of a waiver. For that reason, and with your understanding and indulgence, this hearing stands in recess, not adjourned.